When people ask who is she, I am a triple negative breast cancer survivor. You see, the intruder thought that it would end my life, but I have too many angels up in the sky, and God will not allow me to fail, and never puts more on me than I can bear. I've been through a lot, but through it all, God made sure I came out on top. Being on top looks different for everyone. Being on top for me means counting my blessings, each and every one of them. God chooses his army wisely before creating our stories. I'm grateful every day, but God gets all the glory. If you ask how I'm still standing, I can only give you one reply, and that is, God don't play about me and mine. I'm a survivor. God is not through with me yet. I'm a survivor. God gets all the glory. I just ask him what's next. I'm a survivor. What else would you think? I'm a survivor, and beyond the chemo room, my black is pink. I'm a survivor. They are gonna feel us on this G.O.D. I'm a survivor. I block out the noise and it's just you and me. I'm a survivor. God, you promised that I would be healed. I'm a survivor. We beat triple negative breast cancer and left cancer dying on the field. I'm a survivor. I'm Survivor Speaks. Yeah. When they ask me who I am, tell them I'm Survivor Speaks. Shout out to G.O.D, who's #1 in my life. God bless Survivor Speaks. Yeah, I'm a survivor. If you asked how I'm still standing, I can only give you one reply, and that is, God don't play about me and mine. I'm a survivor. God is not through with me yet. I'm a survivor. God gets all the glory. I just ask him what's next. I'm a survivor. What else would you think? I'm a survivor, and beyond the chemo room, my black is pink. I'm a survivor. They are gonna feel us on this G.O.D. I'm a survivor. I'm a survivor. What else would you think? I'm a survivor, and beyond the chemo room, my black is pink. I'm a survivor. They are gonna feel us on this G.O.D. I'm a survivor.
Under Section 107 of the Copyright Act of 1976. Allowances is made for fair use for purposes such as criticism, comment, news reporting, education, and research. Fair use is permitted by copyright statute that might otherwise be infringing. Smash that like button. Let's go. What up, good people? What up? Thank you so much for coming back. I'm sorry about the volume on the other video. We ain't gonna really get into that. Just put a 1 in the chat if you guys can hear me. I just want to make sure before we get rocking and rolling. If you can hear me, just put a 1 in the chat, please. And then we'll go right on from there. 1 in the chat, anybody? 1 in the chat. Can you guys hear me? Okay, so I see the ones you guys can hear me. Thank you so much. I just didn't want to go on and you guys couldn't hear me. So welcome. Thank you all for coming back. I do appreciate you all, but I'm sorry, got to go do this again. But for the sake of the video, for the replay, excuse me, we do. Give me 1 second. Let me get over here and get No One's back, the music that No One created for me in the background. Shout out to No One. If you guys are looking for instrumentals to play in the back of your videos, check out No One. His link will be in the description throughout this stream. If you're looking for whatever other kinds of music, you can reach out to No One on your own and y'all can work that out. Okay. So, but he did create this background music for the videos for me, and I'm forever grateful to No One for that. All right. So, It's your favorite breast cancer survivor speaks back with another live stream. So, two young lives, two harrowing stories, and an unsettling echo that can't be ignored. So, what happens when two cases separated by time and space share chilling similarities that demand deeper investigation? Welcome to today's live stream. So we're going to be continuing the parallels between two heartbreaking stories, Iyana Sawyer and Ziyah Harris. So these cases are more than just headlines. They're windows into systemic patterns, unanswered questions, and the search for justice. So what do these cases tell us? So not just about their victims, but about the world that we live in. So stick with us because this is a conversation that we all need to have. So we are going to be going over the Iyana Sawyer case. However, we are keeping in mind how eerily similar the cases are. The case is to the Ziyah Harris case. So if you hear me reference the case, it's because we still have a focus on the Harris case. And so I want to pay attention to the similarities of the two young ladies, babies, if you will, children, if you will, and the monsters, the grown adults that stole their innocence and then disposed them like they meant nothing. So I'm going to just briefly say this. If I shout out to all the content creators that are covering this story. We thank you all for that. The more covering, the more coverage, the better. So if I do share an interview, I am very well aware of when the interview was recorded. But some of my subscribers and some of my supporters have not seen those interviews. Some of them don't have channels. They're not content creators. So I mean, even though they're subscribers, they didn't watch that information. I think it's pretty important for us to keep bringing awareness to this, and look back at what was said when Ziyah Harris first went missing and what was said on the stand at the preliminary hearing and what is going to be said on the stand. We're going to make a comparison. What is going to be said on the stand whenever the trial starts? We do not have a trial date. What we do have is a pre-trial and conference hearing coming up on March 7th. It's going to be live streamed right here. So I just wanted to get that out. So if I post a video and it's of an interview that happened previously, you heard it, just click out of it. I just don't know. You don't need to come here and say, oh, we want to hear something new. You're not going to hear anything new because there's nothing else new that's coming out. The only other thing that you will hear that's new is if Shannon continues to run her mouth or the family members come out and keep running their mouths. That's what you hear that is new. I only play the videos just to hear, to see what they are saying, and and bring that to my subscribers and supporters, because the contradictions are crazy so far between all of when she first went missing to now. They have the charges on Jarvis Butts, to how the family, the grandmother and the aunts, well, the grandmother's really not talking. So it's the aunt Shannon and whoever else, how they're coming out here and they never really, they don't shed a tear. They're just saying things that they know are politically correct, but in saying those things, there's a lot of Freudian slips. So that's why I'm bringing it to the attention of the people. So I don't need anybody to correct what I know that already. And if you're, why are you here? You're almost at 200 and something K subscribers. So why are you here commenting on my small channel? I just don't get it. I don't get into all of that back and forth with people and all into the politics. My focus for this case is to bring awareness to people with children, people that have boys or girls, because it doesn't matter. In some cases, that is my focus. It is not about the I'm trying to please this person, compete with this channel about that. That's not how this works, y'all. That's not what Survivor Speaks is about. So I don't care what the next channel is doing. I really don't. I do watch the way some channels cover this because I like their channel. I like what they are saying and how they're presenting their information. If I go to somebody's channel and you start talking about Ziyah and you say anything that's like false and you're running with the story because it just sounds good, I'm just going to unsubscribe. I'm not even going to watch. I'm going to unsubscribe. They have not found Iyana, they have not found Ziyah Harris's remains. Not. Her remains was not found charred, burned. Like this is the stuff that some people are reporting on. And when they're told that that's not true, that's something that they thought when people started, when they had boots on the grounds and they started seeing other, things, and the channel is told that that's not what's going on. Why would you play the video? That's not the truth. I'm hoping that they do find her remains so she can get a proper burial. That's all that matters to me. Any interviews that Shannon, Annette, Florentino does, I'm going to play that because I love to hear the contradictions and hoping that you guys can point out the contradictions with me. Because, there's a lot of contradictory statements. And Shannon Harris had one of the biggest Freudian slips ever. I know Ziyah was not protected. What do you mean? So you're just sitting here, so you guys didn't protect her because she lived with you and she lived with her mother, your mother. You guys didn't protect her. Got it. So this is what we're looking for. We're not looking to be in a competition with anyone. We're not looking for any of that. The more people that do commentary on this, the better. Just do it with integrity. But I'm not the overseer of YouTube. I don't own YouTube. Google owned YouTube last time I checked. So all y'all content creators out here mad because people are reporting on this story, please stop. You don't own the content. You're getting the content from somewhere else. I always shout out 7 Mile Radio because he's been on this. He's boots on the ground down there. And this is the type of work that he does anyhow. He does advocacy work for children, trying to show them a better way, trying to pull them up out of the streets. So I will always shout him out. I'm not selfish like that. Anybody else? Right now I'm not shouting out any, more pages, unless it's Flesh of the Gods. Cat Not Williams is covering ASAP Rocky. I see. Way to go, Queen Slime. But that is what it is. Like, everything else is irrelevant. I just want the people that's typing all the stuff that we already know in my comments or trying to get a rise out of me. You're not going to get a rise out of me. What's going to happen is, shout out to my managing mod, Child Diggy, and all my other moderators that don't play. It's going to just get deleted. Nobody cares about. Let's talk about Ziyah Harris in my comments. But we have a lot of positive feedback. People are glad that I'm covering this. People are glad that I am comparing these two cases. We get a lot of that as well. But then we get a lot of the people coming in here with almost 200,000 subscribers and this, that, and a third, and you leaving comments that's going to be deleted. I can talk about the change that is on the refrigerator. It is sickening. It is called, if you have that many children in the home, it is called raising them up to not, I understand the overindulgent in eating, but what about like children deserve snacks? Children deserve all that. People used to ask me, why the heck do you have so many snacks in your house? Because I never want my children to go out there in them streets and beg anybody for nothing. I didn't allow them to ask people for nothing. You got all that stuff at home. Basically, you got carte blanche to carte blanche to all that stuff at home because there wasn't a lock on nothing. There was nothing on nothing. It's just it's there for my children. I don't want them asking nobody nothing in the street for nothing in the streets. I don't want them going to the school. Oh, can I have some of those? No, no. So if you raise the children right, okay, it's nothing wrong with putting something in place. All right, you eat here. You may have a little snack here. You eat here. You may have a little snack here before you go to bed, something like that. And you instill that in them. They should listen to you, right? So anyway, let's see who is up in the building. I'm done with that. FFS, thank you so much for coming back. You mean so much to me. I wouldn't be able to do it without you. Chloe Albert's Revenge. What is the question marks for Chloe and FFS? I don't know. Chloe Albert's Revenge. Girl. We got Gimme Mo back over here. Glad to see you back. Thank you so much for being with me this morning. Tech Clouds, what up to you? Laugh always is going to always make sure the likes are liking. So, yeah. She's going to make sure the likes is like. Jazzy T. Hey, sis. Okay, so I see we on Jazzy T. We got Jazzy T, Godzilla King. What's up with you? What's up with you, Godzilla King? Welcome. Who else we got? We got my right hand. She keeps me grounded. Godzilla, excuse me, not Godzilla. I done pick. Oh, that's Child Diggy said, "Hey, to Godzilla King. It's been a long night." What's up, Child Diggy? This is my right hand. Right here, I wouldn't be able to do it without her. Like she keeps me grounded. Believe it or not, she does. And let's see who else is over here so we can get started on this commentary. And I think no one. Shout out to no one up in the building. The music you hear in the background was made by no one. Shout out to no one in the building. We got some stuff that is going to be coming up. I hope we got a little something coming up. Just got to get to it. But shout out to no one of the dopest. I'm gonna say music. I don't want to say artist because I don't want to. But he's dope with the music. Shout out to one. That's all nothing but love. Jason Hodges, what's up, my boy? What's up? Thank you so much for coming on over here. And let me see. We got everybody. A little Southern hospitality. I like to speak to everyone. I think we just missing is she here? My Just Valencia. I ain't seen her in here. And Blues Clues is a new subscriber. Shout out to Blues Clues, y'all. Shout out to Blues. That profile picture is child Blues Clues. Leave Blues Clues alone, FFS. She's new up in the building. Why? Why? All right. And so we're going to get right into the content. Today you're going to probably want to stick around to the end because John Quiles' brother, the man who called the cops, and told them what John Quiles told him because he had six children, and the fact that this family was looking so hard for Iyana. He just could not sit around and not say anything. And so when they did the text messages and the Snapchat messages, they have read the message of what he said, the message that he sent to his brother. But if they found out that he did it, he told his brother, "Nice knowing you. I'm out." He got 6 kids. Like, it's understandable. So when it comes to, in this case, about snitches get stitches and all this, and that's his brother, I take my hat off to him. I commend him for being able to come forward, and it's, and just realizing that, this issue's wrong, and you out there looking for them with her when you know exactly where she's at. Come on now. Anywho, Let's go, y'all. Let's get this let's start this. Let's start. Let me get your comment off of there. Let me go on here. I might have to turn the music off in the background depending on how it's working out for us. We're going to get our trigger warning sign up here. It's very triggering, very triggering. And yeah, let's go. And I just need y'all to put ones in the chat when I start the video if you guys are able to hear. Because, oh, Lord. Let's put that there. All right. So let's go.
Okay, no problem. Is there anything I need to be aware of what's going on?
Yes, sir, Judge. For purposes of just one minute on the record.
Oh, let me boost this just a little more. I know it is boosted.
My phone calls, you mean phone calls from the jail?
Last night after closing session, I received just this morning, probably an hour after. There's a comment that you made.
If you turn up the volume on your devices, it may be better, but let me just see if you guys are saying that you can hear over here in the chat. Free flex all day. Can you guys hear? Hold on, let me check it.
I even forward two separate emails, all discussions in the day last night on testimony. Just wanted to make first put it on the record explosive because again, there's not a decision. There's no evidence. Testify. This is something certainly an acknowledgement. His brother did the right thing. Things don't work okay with that.
Can you guys hear?
And our position is one. Now explosive events.
Hold on, let me check it.
Okay.
Can you guys hear?
Is not even an issue. Appears to be on testifying in that society, but
Is there a video of it?
I'm trying to look at our hands on it.
Okay, I'm sure they'll turn that over. I'm sure they'll turn that over to you guys. Obviously, I'm assuming they want to see that before their client makes a final decision on that issue. And I'm sure the state will. I'm sure they got people working on that, if I had to assume. Is that fair, Mr. Skinner? Okay, so but not just the emails, but a copy of the video is going to be turned over to the state, to the defense.
Sending her email afterwards.
Okay. Mr. Davis, you said you wanted to. Guys, we got to keep the noise down in the courtroom. If you got to talk to somebody, please go outside the courtroom. I'm still in session. Mr. Davis, you said you want to address any motions now at the end of the state's case this morning. You want to do that now?
Can you hear me okay, Your Honor?
Yeah.
Thank you. Judge, at this time, the defense would move for a judgment of acquittal, specifically as to counts 1 and 2. To start with, the state cannot prove a crime was committed without the statements of the defendant. Specifically, they cannot prove that it was premeditated or whether or not it was a heat of the moment or a crime of passion. They cannot prove where the crime actually committed, specifically that the elements of the crime that IS and her unborn child are dead, that the death was caused by a criminal act of Jonathan Quilez, and that the act was premeditated without the defendant's wire statement or wire recorded statements that were on the by the jailhouse snitch. The detective Billy Abbott repeatedly stated when he was on the stand on cross-examination that the case turned from a missing person case to that of a homicide case based on the confession and the wire on the defendant. The alleged crime scene at Ace Pick-Apart is based solely upon the confession and the wire of the defendant, and that Detective Abbott specifically stated they could not prove premeditation of murder of IS and the unborn child until they had the confession, and that was on the wire. Without Jonathan Quilles's statements on the wire, the state cannot show that a murder has occurred, that there was, in fact, a crime scene at Ace Pick Apart, and that he had allegedly lured IS up there to a remote area of Ace Pick Apart and ultimately murdered IS. All of that is based on, Your Honor, corpus delicti. Specifically, the state's entire case hinges and is based on, specifically, Billy Abbott's testimony stating that it's either the confession on the wire or his statements to his brother. As such, Your Honor, the defense would rely on, and I'm pulling it back up, forgive me, Judge, I got to pull up my case sites. I had everything pulled up, Judge, and I got kicked off the internet with where I had everything saved.
He should have been prepared.
Pull this up real quick on yours. Mine won't do it. Where there was the JJ case. Judge, I need 1 second because I lost this.
Okay, I do have a jury waiting on me.
Let him know. And I sped him up, and he's still taking all down.
Specifically, Judge, the state's entire case hinges on and is based on Jonathan Quilles's statements, either on the wire or the confession to his brother. Based on this, in Williams v. State, 689 Southern 2nd, 393, and that is a Florida 3rd DCA case, 1997, and Burks v. State, 613 Southern 2nd, 441, specifically citing page 443, that's a Florida Supreme Court case out of 1993. And it specifically goes into the state may offer into evidence admissions against interest to establish one or more of the elements as charged, but they must have independently established corpus delicti to prove that the defendant actually committed the crime and or that there was a crime scene to corroborate the state's version of the facts. In this case, Judge, there is no blood, there is no body, there is no murder weapon, there is no DNA, and only the wire and the confession to his brother tie Jonathan Quilles to this case specifically. Detective Billy Abbott specifically stated that without the defendant's statements, they could not approve this case. Judge, without that, there is no corpus delicti in this case, and as such, counts 1 and 2 specifically should be dismissed. Going to count 3.
Can I stop you there? What was the case you cited?
I have 2, Your Honor. The first is Williams v. State, 689 Southern 2nd, 393. That is a Florida 3rd DCA case, 1997. The second case, Your Honor, is Burks v. State, 613 Southern 2nd, 441, citing specifically to page 443. That's a Florida Supreme Court case from 1993, Your Honor.
Okay, go on to count 3 then.
As to count 3, Your Honor, that is based on completely circumstantial evidence of the fact that there may or may not be the defendant's DNA on the pair of panties. The FDLE expert said that his DNA was present, but could not definitively say whether it was a skin cell transfer or whether it was a serology transfer or semen. He said based on his the testing that he had, there was no definitive either way. again, without the defendant's statements, saying specifically on the wire that he had sexual intercourse with the two daughters, or excuse me, two nieces, that the state cannot meet their burden and prove their case. Again, that is corpus delicti, and I would cite the same two cases and ask to take that under consideration for the defendant's judgment of acquittal, Your Honor.
Anything else?
No, sir, Your Honor.
State.
Request to remain seated, Your Honor.
Sure.
Your Honor, the state of Florida would ask you to deny judgment of acquittal. There is a lot of cases. I'm going to cite something more recently that counsel has. Mackerley v. State, M-A-C-K-E-R-L-G-Y. The state, it is a 4th DCA case from March 22 of 2025, Florida Law Weekly, D, Dog 722. Stands for the proposition that circumstantial evidence was sufficient to establish corpus delicti for murder, even though the victim's body was never found. And then it goes on in a lot of facts, just like we have in our case. In that particular case, Judge, under the corpus delicti portion of the opinion, just to make sure the record's clear, there are 2 paragraphs, there's a pertinent note, and it reads as follows. They were basically the situation, judges, they didn't object to trial with respect to either nor argue it at a judgment of acquittal. The appellate court said even if they had preserved the issue, they went on to say this. Even if they have the issue preserved, we would conclude the state of Florida proved the corpus delicti of murder before Mackerley's confession was admitted to trial. Murder cases in which the body of the victim was never found frequently invoke questions concerning whether the corpus delicti of the crime had been established prior to the introduction of a confession or admission. It cites Myers v. State, 704, Southern 2nd, 1368, a Florida Supreme Court case out of 1997. Also Bassett, 2 S's and 2 T's, v. State, 449, Southern 2nd, 803, Florida Supreme Court case out of 1984. Goes on to state, as the 5th DCA aptly pointed out, in Lindsay, the state v. Lindsay, L-I-N-D-S-E-Y, 738, Southern 2nd, 974. That case says reads as follows. The term corpus delicti does not mean dead body, but is more properly defined as the body, foundation, and substance of the crime. Florida Supreme Court has embraced a 3-part test to establish the corpus delicti for murder: fact of death, criminal agency of another person as the cause thereof, and the identity of the deceased. Improving corpus delicti circumstantial evidence is sufficient, and proof beyond a reasonable doubt is not necessary. Again, we're talking about at the JOA, at the objective stage. Obviously, we need to prove it to the jury beyond a reasonable doubt. And they cite, in that particular opinion, Sawyer v. State, S-O-C-H-O-R v. State, 619, Southern 2nd, 285, Florida Supreme Court case out of 1993. In this particular case that I'm citing for the court, it reads as follows. Mackerley contends that the state failed to establish a corpus delicti of homicide because the state did not demonstrate that they named the victim was dead, and that his death was the result of the criminal agency of another. And considering this argument, it is important to note, to establish a corpus delicti, the state is not obligated to prove the specific manner in which the victim died, nor the identity of the person who committed the homicide. Burks v. State, 613, Southern 2nd, 441, Florida Supreme Court case out of 1993. The state need only present some direct or circumstantial evidence tending to show that the victim is dead and the death is a result of criminal activity. Once the state has presented prima facie evidence of the corpus delicti, the state may then introduce the confession or admission of interest to show that the defendant is a perpetrator. In this case, for the court, Your Honor, the defendant, it's not just this wire. There are a load of Snapchat messages from the defendant to the victim that this jury listened to that showed this ongoing relationship and this how enraged the defendant got. All those statements are not on the wire. They're confirmed by the wire. But all those Snapchat statements, Your Honor, were establishing sort of a relationship, establishing this was the only person she was in this relationship with. They were establishing that this is who Jose was. They were establishing that the victim herself, IS herself, Your Honor, was trying to leave him. They established numerous things before we even ever get to the wire. Furthermore, the evidence very clearly shows them meeting up. He turns his geolocation data off at the same time she's leaving Terry Parker High School. Haley Shimper testifies she saw him pick her up. That's connecting them. That's putting them together. That's showing that when she disappears, she's with him. All this evidence that we put forth showing that she no longer exists, her bank statement, family, her last work at Chick-fil-A. She didn't even pick up her checks. We established she did not exist on the face of this earth. We established that when she disappeared, it appeared to be that she was walking off school grounds, never to be seen again by family, my friends, my phone. The phone goes off. All the things that we're able to show to establish she's deceased. This is foul play. This is nothing she did. Essentially, here we are 4 years later, she's been plus, and she's never to be seen again. The state not only establishes that absent any wire, the state also shows in corroboration of the wire prior to the wire ever even happening. He's telling his brother. He's giving his brother, he calls his brother and confesses, which again, as the court knows, we put all 3 of those confession witnesses on at the very end of our case, having established all these other facts that show this is foul play. She's gone. She disappeared off the face of the earth. The case law supports the proposition that circumstantial evidence does warrant proving corpus delicti. In this case, to answer that proposition, we'd ask the court deny, and for the same arguments with respect to the sexual battery, deny deny the JOA with respect to counts 1, 2, and 3.
Counsel, how do you spell Mackerley again?
Mackerley.
That was March of 22.
Yes, sir. March 22 of 2000.
I'm sorry, I misunderstood you.
Yes, sir.
I think was it a fourth ECA?
Yes, sir.
Okay, I found the site. In March they threw me off. It's actually I think the main date came down April 2nd. The case is 294-7-3-3-11, fourth ECA. I'm sorry, that's not the case. My apologies.
I can give you a copy. I've got a hard copy.
Oh, it's okay. I'll find it.
If I may, Judge, just briefly,
Oh, yes, sir. Of course.
in Burks v. State, I agree with everything that the state said, except the state has the burden of proving by substantial evidence, and this is a quote in Burks, that the state has the burden of proving by substantial evidence that a crime was committed, and such proof may be in the form of circumstantial evidence, but it cannot be just mere evidence to show that a crime is committed, and it need not be proven beyond a reasonable doubt. But in this case, specifically to differentiate, Billy Abbott specifically said that without the defendant's own statements on the wire, he had no knowledge that a crime had been committed and that she was dead. As such, he admitted there was no blood, no body. He couldn't confirm as to what was the murder weapon, and there was no DNA found other than on the panties, and he couldn't say if that was in the commission of a sex crime or not. And then he based everything solely on the wire and the confession of the defendant to his brother. That, Your Honor, is failing to meet the grounds for corpus delicti.
March 22nd, 2000.
Yes, sir.
Site 754, 7 seconds, 133. That didn't look like it was squashed on the court. It looks like it was a wholly separate issue, though.
Yes, sir. And
Court opinion.
if you go to that third,
Yeah, let me get the side on the record. The site court case 777, 7 seconds, 969. Looks like the issue on appeal was in general reversing the murder on dual theories of premeditation and murder. That was the issue on appeal that was certified by the court. I want to make sure, even if it's a red flag with Westlaw, to see a red flag, your eyes perk up a little bit. But those are the issue that was addressed. The separate issues is what's being discussed here in court today regarding the JOA issue. So I just want to make that clear.
yes, sir, thank you. And the reason we're citing it is because it lays out that line of cases that stand for the proposition that is good law. I cited Bassett, Meyer, Lindsay, and SOCOR, SOCHOR, Drysdale, all the cases that I read when I was going through the body stand for the proposition that even the defense agrees is good law.
I do. The light third will state the JOA is denied. You bring the jury back in now?
He got right to it. Denied. Bring the jury in.
Defense? Sorry. The state's asking to replace 33B with a working CD.
No objection.
Okay, go ahead and take care of that. At this point, what I'm probably going to do is not give the jury a mid-morning break. I'll go straight to a lunch hour, take an earlier lunch, and see where we're at.
One moment, Your Honor.
Yeah.
I agree. Judge, for purposes of, rather than stopping, taking the jury out, do you want to inquire of our client now as to whether or not he wishes to testify?
Does the evidence that the state mentioned this morning change that analysis at all? That's why I was going to wait. If it's not changing the analysis,
They've had a chance to talk to me, Your Honor. We prefer court fire now. Once they've gone, I think they're three witnesses and they can rest and move on.
okay. Mr. Quellis, can you raise your right hand, please? Do you swear or affirm, tell the truth, the whole truth, nothing but the truth? All right, sir. So we're at the stage of the ballgame now where the state's rested their case in chief, and now I turn to the defense. Obviously, as you heard me tell the jury during jury selection and throughout the trial, the state of Florida bears the burden to prove the case beyond a reasonable doubt. The defense does not have to do anything, does not have to call any witnesses, etc. You have an absolute right to remain silent, and I'm going to talk to you about that. You have a constitutional right to remain silent. If you decide not to testify, the court will instruct the jury that the fact that you do not testify is not to be considered by them in any way whatsoever in their deliberations. And if you recall, we talked about that in jury selection, and I gave an example of that. If you choose to testify, the court will instruct the jury that the testimony is to be considered like the testimony of any other witness. If you testify, the state will cross-examine you and ask you, if applicable, if you are a convicted felon, and if so, how many times. My understanding is that you are not a convicted felon and do not have any convictions for crimes of dishonesty, so the state is not able to ask you that question because they don't have a good faith basis to ask you that question. Is that correct, defense? State?
Yes, sir.
As you saw throughout the trial, a couple times it was mentioned, are you a convicted felon? If so, how many times? That line of questions will not be able to be asked of you because it's not pertinent to your testimony since you do not meet that criteria. The right to remain silent belongs to you and to you alone, not to anyone else, including your attorneys. Your attorneys can give you advice and their opinion, but the decision whether to testify or remain silent belongs only to you. Have you discussed all of this with your lawyer?
I have.
You need more time to do so.
No.
And what is it? And what decision have you made regarding testifying?
I'm not going to testify.
Is this decision being made voluntarily?
Yes.
Has anyone forced you to make this decision?
No.
Coerced you?
Nope.
Pressured you?
No, sir.
Threatened you in any way whatsoever?
No.
He already
You had any
testified.
time to talk to your attorney about this decision?
Yes.
You seem rather confident in the decision.
Yes.
Is there any inquiry you want me to make in addition to that regarding his decision not to testify in defense? Correct. Okay, so I'm putting aside the decision not to testify. I'm going to move over to another line of questionings. But there's nothing else you want me to inquire about specific regarding his decision not to testify. Okay, so the court is making a finding that his decision not to testify has been made freely and voluntarily, and the court will instruct the jury regarding his decision not to testify at the applicable stage of the proceedings. So, Mr. Requeles, it sounds like your defense attorneys are calling a few witnesses to testify on your behalf. I have a general knowledge as to what they're going to say. Obviously, you have more in-depth knowledge than I do at this ballgame because they've talked to you about all this. Have they located the witnesses that you want them to locate to call on your behalf at trial?
Yes.
And you're in agreement with them calling these witnesses to testify on your behalf?
Yes.
And I believe there's 3 of them?
Yes.
Okay, and you're in agreement with that?
Yes.
There's no additional witnesses that you want them to call that they are not calling, is that correct?
You couldn't find the other ones, so.
We talked the John Smith and the Larry?
Correct.
Well, I think the John Smith issue got debunked by the states.
Well, the issue is, Judge, actually during the course of the trial, it popped up in the phone record. It's not John Smith. It's a different name. It's John Anthony. So it popped up during the course of the trial. The state did provide information. We did attempt to follow up. But given that the person's out of state, we are unable to complete our follow-up investigation and produce that person. But it was not a John Smith. It turned out to be a John Anthony.
Have you talked to him?
We have not been able to reach him.
He may call back today at some point, but at this point, he's in, I believe it was Georgia, if I'm not mistaken. Yes, okay. He's in Georgia, and so the likelihood of being able to provide him here, at this stage, it's...
Do you know what he allegedly would say? He's a coworker at the ASPEC Park?
We have no idea, Judge. That's the whole reason.
The expectation, Judge, would be that our understanding is that he is on some of the video that the jury observed of him at work. He was with another gentleman during a portion of that video. That gentleman worked with him throughout that day. And so I don't know exactly what he would say specifically, but we would expect that he would provide information as to observations he made of Mr. Quillez that particular day.
Well, there are quite a few people who work at ACE on that day. We can all agree to that, right?
Of course, but this...
And none of them are being called to testify.
No, and this particular person is someone who worked with him on a regular basis, and so this is someone who might remember that particular time. I think we did reach out to try and figure out if there were other people who may have worked with him, but we just could not find anybody who remembered that particular time. So,
Because to them it was just a regular day. There was no reason for them to specifically remember this day.
correct, and so they couldn't provide us with any information that would be something to put in front of a jury. Other
Okay.
than speculation of, oh yeah, I don't remember anything abnormal, which I believe both of the Lindros testified to that. So I don't think there's anybody else out there that we could have. This person in particular that Mr. Quillez requested us to try to find, he believed would have a little bit more direct information as to where his movements and activities throughout the day. Not knowing that name, of course, Anthony versus Smith, that obviously impeded us from being able to fully investigate that prior. And we literally received that towards the end of the day or middle of the day yesterday. So it's not like we had a great amount of time to do any additional legwork.
Okay. And then Larry was the other person that had no last name.
We did figure out Larry. Larry was the supervisor that's been discussed as having been on leave during that time period. He was not present during any of those days.
But
so
he
we did not pursue
testified.
Larry, although we did have the information for him, and we did discuss that with Mr. Quillez.
Okay. So the only issue being John Anthony.
Correct.
Okay.
Judge, we just want the court to be aware that this bill has been told our client. We've literally made every effort to make sure no stone is left.
Understood. So Mr. Quillez, going back to you, sir. You're in agreement with these 3 witnesses being called on your behalf, correct?
Correct. Yes, sir.
Okay. And so when I asked you about any additional witnesses, it was the previous issue that we discussed regarding John and Larry.
Yes.
Other than that, is there any other issue or witnesses you want your attorneys to call to testify at your trial?
No, sir.
Have they done everything that you asked them to do in this case?
Yes.
Obviously, throughout the course of the trial, I've noticed that you've taken extensive notes on a legal pad. I've seen you talk to Ms. Michelle and Mr. Davis quite a bit. You've been engaged throughout the entire trial. You've taken quite a bit of notes from what I can talk. I don't know what you're writing, but you're writing something. And you've been conversing, ripping papers up given to your attorneys to ask questions, I'm assuming, of certain witnesses. Have they been engaging with you throughout this entire trial?
Absolutely.
And they've been taking your advice of issues that you want them to address?
Yes.
And you believe that they done a good job for you?
An excellent job.
Good to hear. So I'm assuming based off that you're satisfied with their services here at this trial.
Yes, I am.
Is there anything else you want to bring to my attention?
No, sir.
Has anyone told you how to answer my questions here today?
No.
Anything else the defense wants me to inquire about? Anything the state wants me to inquire about?
No, Your Honor, thank you.
Okay, so at this point, we'll go straight through the morning. We'll take an earlier lunch. We'll see where we're at. If there's a rebuttal case or not, but if not, we'll start closings this afternoon after the lunch hour.
Judge, could I inquire, when you had the clerk come get me, I was in speaking with one of the witnesses in the conference room. As the jury's coming back in, can I go finish up with him to make sure he's ready and on deck when he calls when Michelle's ready?
He's not the first witness?
No, he's going to be the second witness
So you want to talk to him in the interview room while Ms. Michelle is inquiring?
of the first witness that she's going to call, yes. Just so that we have,
Okay.
ready to move him straight to the chute and ready to call.
The staff can accommodate you. I'm sure it can happen.
Thank you, Your Honor.
Okay. Any reason why we can't bring the jury in?
No, Your Honor.
Defense?
No, Your Honor.
Okay. Let's bring the jury back in, please.
Your Honor, the jury's re-entered the court.
Members of the jury, welcome back. Everyone may have a seat. Sorry for the slight delay this morning. Had to do some work with the attorneys outside your presence. Because of that, what I'm probably going to do is just take an earlier lunch break. For you guys, if that presents an issue for any of you guys, let me know. I'm not going to go to 12:30 straight, I promise you guys. If I take an earlier lunch, if that presents a problem, slip a note to the bailiff. I'll certainly accommodate you guys. But with that said, we're going to begin. The state rested their case in chief yesterday. You guys all have your correct notes? Okay, people are shaking. Okay, good. So the state rested their case yesterday. I'm going to move forward to the defense side. Mr. Davis, Ms. Michelle, you can call your first witness.
Our defense will call Carol Clip.
Ms. Clip, good morning to you, man. Come over here to your right. Just watch your step as you come forward. You need a glass of water, let us know. Mr. Gray and staff will certainly accommodate you.
I'm nervous, but I think I'll be fine, thank you.
Yes, ma'am. No reason to be nervous, but I understand why. You can manipulate that microphone to help you project your voice. And I just asked if there's an objection made by one of the attorneys during your testimony, just pause, let me rule on the objection, and we'll go from there, okay?
Yes, sir.
All right, ma'am. With that said, state you may inquire. You're ready.
Yes, Judge, thank you. Good morning, ma'am.
Oh, there you are.
Yes, I'm right. Good morning.
Good morning.
Could you please begin by introducing yourself to the jury, please?
My name is Carol Ann Clip, and I live here in Jacksonville, and I work for the health department half my life.
Thank you so much for giving us that. Are you related to anyone in this case, Ms. Clip?
No, ma'am, I'm not.
Do you know anyone by the name of Jonathan Quillez?
No, ma'am, only through this instance now.
And did you hear that through the news?
Excuse me?
And did you hear his name through the news?
Yes.
Okay. Outside of hearing his name on the news, had you ever met him or spoken to him or know anything of him?
No, ma'am.
Do you know, maybe from the news as well, outside of what you may have heard on the news, did you know a young lady by the name of Iyana Sawyer, IS for the record?
No, ma'am.
Did you know anyone that was related to her at all?
No, ma'am.
Do you recall a time in December of 2018 where you witnessed something noteworthy?
Yes, ma'am.
Can you tell us what you witnessed?
I was coming home from my mother's house in Tampa at Christmas time, and it was actually the late afternoon or evening of Christmas. And I came down off the 95 ramp to come down on Phillips Highway. Well, I had to stop at that light there It just wasn't green and you could just go. So I was stopped behind several cars, and the light turned green. As the light turned green, it went and merged onto Phillips Highway. And as I did, I noticed this young girl walking in front of the two hotels there. There's two hotels right side by side. And I noticed her, and I thought to myself, it's going to be dark soon. You know, no young person should be walking down, headed south on Phillips Highway when it's going to be dark shortly. And I was concerned. And then I got home, and I didn't think anything more of it.
All right. And you said that you were concerned. Is that something that you thought about later and wondered about what was going on with her?
Well, later on, I think it was several days, I saw on the news, I was actually sitting in front of the TV, and I saw the news about the missing girl. And through their description and the picture I saw of her, that was her. In my heart and mind, that was her. And so I had to call. I had to call the police and say that I had seen her.
And did you do so?
I did so.
Did you do that right then and there?
I did that the very day I saw that on the news, yes.
When you called her, did you tell police what you've relayed to the jury just now?
Absolutely. And I probably even went further because it was more fresh in my mind.
And I was going to ask you some of those details. I know you told us where you saw her and you saw her walking. Do you remember what she was wearing?
I remember her hair. I remember a backpack. I remember, that's about all I remember. But I know that whatever it was, I told the police whether it was more or less was what I saw, which was more fresh in my mind 4 years ago.
Of course. And when you made that phone call, why did you call right then and there? Tell us your thought process.
Well, because I was concerned. And if you see, and I believe in that. And so, therefore, I did.
That when you saw that news picture and the description that you called then, how certain are you that the young lady was, in fact, that same young lady that you saw in the news that was missing? IS.
Well, if I was not certain in my heart,
I don't know why she keeps
there would
calling.
be no reason to.
Let me ask you a couple of last questions. Did you want to come here today to testify?
It's kind of scary.
I was going to ask you that. Is that why you are testifying?
That's why I'm here.
And what you've told us is what you saw. No, as best your memory can recall, no additions, no subtractions.
No, that is true. This is what happened.
Thank you.
You're welcome.
Nothing further.
Yes, ma'am.
Besides the nervous part, huh?
I've never done this.
So, ma'am, I'm going to obviously talk to you about back in December 2018 and January 2019. This individual that you observed, it was on December 26, 2018, between 5 and 6 p.m. Is that correct?
It was the 25th. It was Christmas.
Do you recall telling the police that it was December the 26th, 2018?
No.
Okay. And do you recall...
Oh, you know what? It may have been because I spent Christmas at my mother's. Pardon me.
That's okay. Did that help refresh your recollection?
Yes, thank you.
No problem, ma'am. And you had told the police that it was between 5 and 6 p.m. Is that fair to say?
If that's what I told them, then that was the truth.
And it was getting dark, wasn't it, at this time?
It's going to be soon, and that's why I was concerned for that young person.
And you recall the fact that this individual had a backpack.
I do.
And I think the other thing that you remember is that this individual had hair extensions.
I do.
Okay. And you stated that then on January 1st, that would have been 5 days later, correct, that you saw a picture on the news?
Possibly, yes.
Okay.
I knew it was several days. I don't know the date.
Do you recall what picture you saw on the news?
I do not.
And had you ever seen the individual by the name of Iyana Sawyer before?
I don't believe so.
And
I was what, ma'am?
It's fair to say that you were driving at this time, correct?
I was driving. I was stopped. The light turned green, and I proceeded around to Phillips Highway.
Yes, ma'am. Is it fair to say that the total time that you saw this individual while you were moving was 5 seconds, correct?
About 5 to 7 seconds, yes.
No further questions, Your Honor.
She don't
Good
got
to see you. Ms. Michelle, you can call your next witness. Yeah.
Your Honor, if we can next call Ulysses Dixon.
I'm aware. Yeah, I think Officer Hill tried to ask him outside. I just didn't know the. Mr. Dixon, good to see you, sir. Just walk up here in front of the clerk. Mr. Dixon, good morning to you, sir.
Good morning, sir.
You need a glass of water, let us know. We'll do our best to accommodate you. An objection made. I ask that you pause and let me roll in the objection. We'll go from there.
Yes, sir.
All right. With that said, Mr. Davis, you may inquire. You ready?
Thank you, Your Honor. Good morning, Mr. Dixon. Would you please state your name and introduce yourself to the jury, please?
My name is Ulysses Darrell Dixon II.
Okay. And where are you currently housed?
At the PDF detention facility at the county jail.
Okay. So you're at the Duval County Jail, right?
Yes, sir.
How long have you been at the Duval County Jail?
I've been at the Duval County Jail for about 6 years.
Okay. Now, just to be clear, 5 prior felonies, right? In your history?
Yeah, I don't know how many, but yes, I have felony priors.
Okay. And you have pending charges as well, correct?
Yes, sir.
How many pending charges do you have?
I think the state amended it when I was about to go to trial. I think it's like 13, 12, 13.
Okay. Now, are any of those crimes of dishonesty?
No.
Okay. You don't have prior crimes of dishonesty?
No, that's not what no, sir.
All right. Now, at the jail, are you involved in a Bible study group over there?
Yes, sir.
And how long have you been running a Bible study group at the jail?
Since 2018.
Okay. And do you run the Bible study group?
Yes, sir.
Okay. It's something you set up on your own, right?
Yes, sir.
It is not affiliated with anything through the jail or some other religious or ministry group or anything like that, correct?
Correct.
All right. Now, do you give incentives to people that come to your Bible study group?
Definitely, like food and extras. Yes, sir.
Okay. And do you follow up with people that come to your Bible study group on a regular basis?
Definitely.
Okay. And just to be clear, this is done in the dorms there at the jail, correct?
Yes, sir.
All right. Do you do an outreach program to recruit new members and get new people that are coming in to attend your Bible study group?
Yes.
Okay. For lack of better words, are you basically like the minister or conduct this ministry yourself?
Yes, sir.
Do you bring in a minister to participate in this?
Do I try to encourage other people to preach? I do.
Okay. All right. Do you have an occasion to know the name Damian Hatch?
Damian Hatch, yes, I do.
What name does he go by at the jail?
Dino.
Dino. Okay. And do you know Jonathan Quilles?
Yes, I do.
And how long have you known Jonathan Quilles?
I knew John probably since either 19 or 20. It's been a long time. It's been a while.
When you say 19 or 20, you mean 2000?
2019, 2020.
Just so the record's clear, let me finish my question, and I'll let you finish your answer so that this young lady can take everything down, okay?
Yes, sir.
right, thank you. All right, now, I want to go specifically to around February of 2022. Was Dino or Damian Hatch attending your Bible study group regularly?
Around 21, 22, yes. Dino was a regular.
Okay. And do you recall, or do you know, has Jonathan Quilles ever attended your ministry or religious groups?
John started right about the beginning of this year, maybe January, December, somewhere around the beginning of this year, end of last year. But
So from 2018 until to the end of 2022, he did not attend your religious or ministry group.
no, he didn't. Though I tried to, convince him to start attending services and seek Christ.
How are you certain he did not attend?
Because I lead Bible studies. I do Bible study after lunch. It's more in depth, get into hermeneutical interpretations of the books, and then at 6 o'clock services, that's the main service where it's like preaching, hallelujah, thank you Jesus, and encouraging the guys, exhorting the flock to just continue in the doctrines of our Lord and Savior Jesus Christ. And he wouldn't attend, but he went by the name Brother John. So I was like, bro, you're a brother. I should try adding it because he does a lot of good stuff in the jail, clipping toes for the old people. When the guys they have bowel movements for themselves, he watches them. He do a lot of good work, but he don't come to church. So that stuck out to me.
All right. And have you ever seen Dino and Mr. Quilles hanging out at Bible studies together?
No, because John don't come.
Okay. Well, he didn't come at the same time that Dino was.
Yeah, not at that time. Dino was at Bible study. John wasn't.
So if somebody were to say that Jonathan Quilles attended your Bible study and was there with Dino, would they be telling the truth?
That Dino attended with John, that's a lie.
Okay. Did you ever see them hanging out together after the Bible studies?
No.
Okay. All right. And how are you certain of that, of their attendance?
Well, I have records. I keep up with the flock. The Bible says be diligent to know the state of that flock, and so I keep meticulous records. I have the names of the regular main attendants, and if guys just pop up and make a guest appearance, so to speak, I write the names on the bottom in that section so I can follow up. Say, hey man, I seen you at church today. How did you like the service? Woo, and just try to bring them in, usher them to Christ.
Before you came over here to testify today, did you review your records to ensure that they were accurate, that Jonathan Quilles never attended your services before this year?
Yeah, I turned them in to the people that came and asked me about them. You guys asked me, and I got records to prove, if you think.
Okay. All right. You also showed those to detectives when they came and talked to you?
No, I didn't show them to the detectives. I didn't know why they was calling me out.
Okay. All right. May I have just a second with Counsel here?
Morning, Mr. Dixon.
Good morning.
Now, sir, you have pending charges that you're currently facing right now. Is that correct?
Yes, sir.
And there's 13 of those, right?
Yes, sir.
You brought them up. What are they?
What are my charges right now?
Sir.
I have human trafficking, deriving financial support from the proceeds of prostitution. There's kidnapping. There's a aggravated battery, possession of a firearm, sexual battery.
All right, you left a few out, didn't you, sir?
I think I was correct with all of them.
Okay. You said human trafficking. Is that correct?
Yes, sir.
Isn't it true, sir, you have 2 counts of human trafficking charged against you?
Yes, sir.
And then you said sexual battery. Is that correct?
Yes, sir.
Isn't it true you have 6 counts of sexual battery charged against you?
Yes, sir.
And then you mentioned kidnapping. Isn't it true, sir, you have 2 counts of kidnapping charged against you?
Yes, sir.
And you have 1 count of aggravated battery. Is that correct?
Yes, sir.
And then you have 1 count of deriving support from the proceeds of prostitution. Is that correct?
That's what I said.
Yes, sir. And then you said a possession of a firearm. Did you mean possession of a firearm by a convicted felon? That was
Yeah,
charged with?
yeah, that's more formal. Yes, sir.
Okay, thank you. Now, you are a convicted felon, right?
Yes, sir.
How many felonies do you think you have?
Why would they child?
Well, 2,
Okay. Counsel asked if you had 5.
I don't know, probably 3, 4, 5, maybe.
You keep meticulous, detailed records about who attends your Bible study, but you don't know how many felony convictions you have, sir?
I mean, if you gave me my record, I could show you that, like I could show you the records for my Bible study.
I'm asking you about what you think. How many felonies do you have?
2, 1, 4. I thought I had 4.
All right. Now, these charges have been pending against you since 2017, right?
Correct.
And they were filed by the state attorney's office that I'm a member of, correct?
Correct.
And you agree, sir, that you're fighting those charges.
Yes, sir.
They're pending right now.
Yes, sir.
Now, this group that you lead over at the jail, excuse me, this takes place in the pod, in the dorm, is that correct?
Yes, sir.
Like, if I'm laying in my bunk on the first or second floor, the group can be heard right down there in the pod, correct?
Yes, sir.
In fact, you can see from each respective bunk, you can see in the dorm when the group is meeting, right?
Yes, sir.
In fact, everybody can see it.
Yes, sir.
In fact, when you meet as a group, do you agree, sir, that you meet at one section of the open dorm that's open to all?
That's changed.
I'm talking about back in the time period you're testifying about. Not now, not today, but back when we were talking about 2022, 2021, 2020, 2019. Right?
When we made that conversion from the secluded area to the open area, that was around about 22.
Okay. And the defendant, you've seen him in your dorm since 2019, correct?
I don't believe I was in the dorm with him at 19.
All right. You said to this jury just a few minutes ago, sir, under oath, that you've known him since 2019.
From 1920, we weren't in the dorm together when I first met him.
All right. How'd you meet him?
He works in the jail. He was a trustee, what they call it, pass out the trays, help people, stuff like that.
All right. When did you become a fellow inmate in the same dorm or pod with him?
Probably 20, 19 or 20. I'm not
Okay.
sure about that.
All right. And in 2019, 2020, he was new to you when you first met him, obviously, right?
Correct.
And when you are doing your Bible study, can it be heard over the whole entire pod, the whole dorm?
Yes, it can.
All right. And how many people are in this group?
It varies. It fluctuates between 10 and 30. It fluctuates between that.
All right. And when the group breaks, I take it you in with a prayer?
Prayer.
And when the group breaks, everyone just disperses, correct?
Shake hands, dap up, hug, and then they go their separate ways. Put up their Bibles and go back to what they're doing. Get on the tablets and the phones.
Yes, sir. And when these either 10, 15, up to 30 people break, are you watching every one of them?
Not every one of them. I hug and dap up every one of them. I don't watch what they do after they leave.
So when you say leave the Bible study group, you agree with me, you cannot watch all whatever number are appearing on that particular day. You agree with that, right?
That I can't watch all of them after the service is over?
Yes, sir.
No, I can't watch all of them at the same
And when
time.
the service is over, if we're meeting over here in a group and you walk 10 feet away, you're no longer with the group, right?
Correct.
And as you get further away from where you're meeting, you can't hear what they're saying, right?
Correct.
Pretty loud in there, right?
Correct.
I mean, this jury's heard a wire. You hear banging on doors, correct?
Correct.
You hear that quite often in there, correct?
Correct.
You have no idea what any member of your group is talking about or who they're talking with once they leave your group. All 30 of them, can you, sir?
Yeah, I don't see what they're doing after they leave the service.
One moment, Your Honor. Nothing further, sir. Thank you. Just briefly, Your Honor.
Follow up on what Mr. Skinner had just asked you a minute ago, sir. Back a year plus ago, the way your Bible group met, you said it was in kind of a secluded off to the side area?
Yes.
Was that accurate?
That's accurate.
Okay. So although people inside the dorm can hear it, that you're doing this Bible study, when they were attending, it was like in a separate off to the side room or area, correct?
That's where we do church at.
Okay. Now, as such, it's kind of off, as you stated, off to the side. You can tell who's attending and participating in your church services, correct?
Correct.
And as part of that, if somebody states that they saw Dino and Jonathan Quilles together at the church service over there off to the side, they would not be telling the truth. Would that be accurate?
They would be lying.
Okay.
John didn't go to Bible studies. I mean, after church over with, I stay at church, walk everybody to the doors, leave them this way or that way. How they would do at a real church, you walk your members out the door. I would shake their hands and tell them God bless you until the last member gone because people want to talk to you after church. And so I stay. So if anybody else stay, I would see that. But if they go somewhere else, If they go to a room, if they go in the shower together, I can't see that.
Okay. Now, one last question. Anybody promised you to be here today? Promised you anything to be here?
No, actually, I feel threatened that if I, come forward with information, that they may respond against me. The state attorney's office may try to go hard on me for my charges. But, they trying to kill this guy, and the dude was lying on him. So I told him, I would agree to tell him that, man, that's a lie. The dude lying on him.
Nothing further, Your Honor.
All right, Mr. Dixon, have a nice day. Defense, you can call your next witness.
Your Honor, the defense would next call Kamar Humphrey.
Mr. Humphrey, good morning to you, sir. You just come on forward, and the clerk right here will swear you in. All right, Mr. Humphrey, come over here to your right. Just watch your step as you come forward. If you need a glass of water, let us know. Mr. Gray, staff will accommodate you. Do you want one? Yes, sir. Okay, Mr. Gray will help you out with that. The microphone can be adjusted to help you project your voice. You seem like you have a soft voice, so just try to project your voice with that microphone so everyone can hear you. You can scoot forward however you deem necessary. If there's an objection made during the course of your testimony, I just ask that you pause, let me rule on the objection, and we'll go from there, okay?
Yes, sir.
All right. Ms. Michelle, you may quite ready.
Yes, do you want a moment to get the water?
Really, really quick, y'all. This is the young man that lived across the street from Iyana Sawyer that was charged with the SA charges. He's a little older than she is. So the state didn't call him, but of course, hold on, y'all, I gotta get in there. Bitch ass Michelle called him to the stand because she's trying to raise reasonable doubt and the public's mind that this guy could have possibly offed Nazaya. Excuse me, not Nazaya. Lord, you see I got Nazaya on the brain. Iyana. But I just wanted to let you all know that this is the young man that they have been talking about throughout the case that was, Iyana's mother called the cops on because either she was having relations with him or, one minute they said they were having relations. Another minute they said that he SA'd her. Anyway, whatever way it goes. This is the guy, and they already proved that he was not around when this happened to Ziyah, and that he had moved away as soon as Iyana, and he had moved away as soon as Iyana's mother called the cops on him and put a case against him because he was older than Iyana. And this is the person that Jonathan is claiming that Iyana was mad with him, so she slept with him again. All of this, I think, is to try to damage Iyana's reputation. And so, anyway, if you see me put a thumbs down and it comes over next to my screen, it is for the attorney, the defense attorney, Michelle. She has a job to do. However, I don't like her. I think she goes overboard. And there has been agreements in the chat about her attitude and how she goes so hard at some witnesses when they're on the stand. But we did see with the first defense witness today that she can reel that in, and she can ask questions without badgering, without intimidating, or just with an aggressive tone. So I just wanted to give you a little background on Mr. Kamar Humphreys after we just saw philanthropist, pastor, the pastor that was on the stand, with all his very, very, very horrendous charges. He can remember about Bible study, but he can't remember about all of them daggone kidnapping charges in assault and everything else the pastor has on his jacket. Hallelujah. Hallelujah. Let's go.
Okay, I'll let you have a moment to do that. Thank you. You ready, sir? All right. If you could please, sir, start by introducing yourself to the jury, please.
Hi, my name's Kamal Humphrey.
All right. And Mr. Humphrey, how old are you?
I'm 25.
And where do you reside currently, just generally?
North Carolina.
Right. And back in 2017, 2018, where did you live?
I live in Jacksonville,
And where specifically?
7843 India Avenue.
All right. Sir, if you could, do you recall a time period around February and March of 2018?
What was your question?
Do you recall a time period around February or March of 2018?
Which time period are you talking about?
Where did you reside around February or March of 2018?
It's on India Avenue.
And sir, did you have neighbors at that time that you knew to be Iyana Sawyer?
Yes, ma'am.
And how did you meet IS?
Walking, neighborly, just walking up the street, picking up my little cousin from school, and she'll be picking up her brother from school.
And did you all talk to each other and have conversations?
Slightly, yes.
At some point in time, did you all start communicating more?
Yes.
And how would you all communicate?
We communicated through social media.
Okay, and what social media apps did you use specifically?
Snapchat.
On Snapchat, do you recall what your Snapchat was at that time?
No, ma'am.
Do you recall what IS's Snapchat was at that time?
No, ma'am.
Do you recall IS having multiple Snapchats?
No, ma'am.
Do you recall having a conversation with her about those Snapchats or anything about Snapchat at all?
No, ma'am.
How did you all exchange information?
Like I said, I met her while walking, so we were just neighborly like that.
Did you all exchange phone numbers at one point?
No, ma'am. No phone numbers.
Did you all exchange social media handles? Is that how you got connected?
The Snapchat, yes, ma'am.
And was that the only social media accounts that you used to communicate with IS?
Yes, ma'am.
All right. In March of 2018, did police come to your home?
I believe so, yes, ma'am. In March, yes, ma'am.
And what happened when police came to your home?
I believe this is the time I did the mouth swab, I believe,
And what did they tell you why they were doing that mouth swab?
for a rape kit or something like that.
Were you in a sexual relationship with IS?
Can you describe a sexual relationship?
Whatever you believe a sexual relationship is, were you in any sort of sexual relationship with IS?
Yes,
How many times had you and IS slept together?
once.
Have you ever stated anything differently than that?
At one point, what do you mean? Have I ever stated? What do you mean?
Have you ever said that you slept with her more than once?
No, ma'am.
Have you ever denied having slept with her at all?
Yes, I did. I did deny.
When was the last time you denied sleeping with IS?
With the deposition that we had.
Do you recall when that deposition was?
No, ma'am. I don't actually remember the days that we talked on Zoom.
Was it just last month?
Yes, ma'am. It was recently, yes.
In fact, it was just like a few weeks ago, in fact.
Yes, ma'am.
And a few weeks ago, you said you never slept with IS.
Yes, ma'am, I did.
That was not the truth, correct?
That wasn't the truth. At the time, I felt like you were attacking me when you were asking me questions at that time. So, yes, I did.
All right. Let me ask you about following that. You're saying you only ever slept together one time?
Repeat your question?
You just testified you believe you only slept together one time, correct?
Yes, ma'am.
Okay. Did you all have a continuous relationship thereafter?
No, ma'am.
Did you all continue to communicate on Snapchat?
No, ma'am.
How long, if you could, estimate for me how long you all were communicating on Snapchat? Are you having trouble hearing me?
A little. I'm just trying to make sure I hear your question as clear as possible.
And I'll elevate my voice that way I make sure you hear my question fully. Did you hear my last question without any issue? You're kind of leaning your ear towards them.
Could you repeat it one more time?
Of course. How long in total do you believe you communicated with IS on Snapchat?
Probably like a month or two. It wasn't that long.
After police came to your home and asked you about this sexual encounter that you had with IS, did you continue to see her?
No, ma'am.
Did you continue to live on India Avenue?
Yes, ma'am.
From the time that this occurred up until when did you continue to live on India Avenue?
Repeat your question again?
How long did you continue to live on India Avenue?
For a couple years until I think the year of 2020 when COVID hit. That's when my aunt and my uncle moved. I was living with my aunt and my uncle. We moved to St. Augustine.
So during the time period of December 2018 and the months leading before that and after that, you were living on Indiana Avenue across the street from where IS was residing.
Yes, ma'am.
At no point after you were accused of having sexual encounter with IS, did you move away until 2020?
Could you repeat that? You said a lot when you were.
I know. Let me slow it down. During the time period before December 2018 and immediately thereafter, you continued to live across the street from IS.
Yes, ma'am.
Did you see her?
No, ma'am.
You would not see her at the bus stop picking up her siblings.
No, ma'am.
Did you stop picking up your siblings?
Yes, ma'am.
Did you go outside of the house from time to time?
Yes, ma'am.
Did you see other family members at any point outside of your home of IS?
I wasn't really paying attention to the family. I was just focused on work.
Do you recall in December of 2018 being visited by police at your place of employment?
Yes, ma'am.
Where were you working at that time?
Popeyes off of Arlington?
And I know you probably don't remember her name, but it was a female detective that came to see you?
Yes, ma'am, it was.
Okay. And what did she ask you at that time, if you can remember?
And she just asked me did I see her or and if I had any thing to bring to her or any information just to contact her.
Okay. At that time, did she also ask you where you were on December 19th and 20th?
Did she ask me? Repeat that one more time. I'm sorry.
Did she ask you at that time where you were on December 19th?
I don't recall if she asked me. I don't recall. I know she just, like I said, I remember her asking me about, you know, if I've seen her and if I have any information or anything about that, just to respond back to her.
Okay. And do you recall, I know you don't recall her asking you that question, but do you recall volunteering the information that you believe you were out of town from December 19th until December 29th of 2018?
I was out of town between the times of December 18th. I left December 18th out of town.
And do you recall telling the officers that it was actually December 19th through the 29th?
No, I don't recall telling the officer December 19th. I don't recall telling her December 19th.
Okay. Have you ever stated that you were out of town on different days than those dates that you just provided of December 18th?
Yes.
Okay. In fact, just a few weeks ago, didn't you tell me that you were in town on the 19th and the 20th?
No, I did not tell you that.
Do you recall ever saying that you were only out of town from December 21st through December 23rd?
I recall telling you that because like I said, in the deposition that we had, I felt like you were attacking me and I gave you the wrong dates.
Do you recall telling me that you took a plane on December 21st to go visit your dad?
Yes, I remember telling you that.
Do you recall checking your calendar to figure out what dates you were gone around that time period?
Yes, I remember. And I didn't take a plane either. I took a bus.
Do you recall having any information at your disposal at that time to be able to verify those dates?
At that time, no, ma'am.
So did you, in fact, look at your calendar at that time just a few weeks ago?
Repeat your question?
Did you, in fact, look at your calendar a few weeks ago to figure out that you were gone the 21st through the 23rd?
I looked and found that I was gone between the dates of the December 18th through the 28th, I believe it was, or 29th, to go see my father in Harrisburg, Pennsylvania.
And let me ask you another question. Do you remember your response to when I asked you about what airline you used?
Again, no, ma'am, because again, like I said, when we had the deposition, I felt like you were attacking me when you were asking me questions. So I was not truthful with you, and I came back and I apologized because, you know, I should have been truthful. So, no, ma'am.
And I know this the incident's from quite some time ago. Is there a reason why you would feel attacked when asked when you were out of town or in town?
Because I was trying to get this situation behind me. You know, I've been focused on myself and getting my life correct, you know, and making a better life for me.
So someone asking you where you were, was that, you felt like that was an attack?
No, not that specifically, just the whole conversation of that we were having, and the way that you were, you know, coming at me and talking to me. Yes, I did feel like you were attacking me.
Was I talking similarly to how I'm talking right now, asking you these questions?
No, ma'am. You were talking differently.
All right. Let me ask you about your whereabouts during the 21st or the 23rd. You stated that you were where?
I was in Harrisburg, PA,
All right.
Pennsylvania.
And you're certain that you were not in Jacksonville during those dates?
I'm positive, yes, ma'am.
Do you recall seeing SS, IS's sister, on Christmas of that year?
No, ma'am.
If SS said that she saw you on Christmas of that year, would that be incorrect?
Yes, that would be incorrect. She would be lying.
One moment. Mr. Humphrey, outside of the female detective that came to your job, have you ever been contacted by police at all as it relates to your involvement in this case?
No, ma'am.
Has anyone ever followed up with you as it relates to your whereabouts around that time?
No, ma'am.
Did you ever provide confirmation of your whereabouts to police for your time period of the 19th or 18th, I'm sorry, 18th through the 28th that you gave us today?
Repeat your question?
Did you ever provide confirmation of your whereabouts to police from the dates that you provided, December 18th through the 28th?
At the time that they had asked me, or prior to like recent?
Yes, did you ever provide it to police?
When exactly are you asking did I provide this information?
Did you ever provide that information to police is the question.
No, ma'am.
Okay. Did they ever follow up with you to try and obtain that information from you?
No, ma'am.
Recently, you provided this information to the state attorney's office, correct?
Yes, ma'am.
And that is not a bus ticket, is it?
It is a bus ticket.
Does it verify that you actually got on the bus?
Does it verify I got on the bus? I did get on the bus. I did.
The question is, does that ticket that you provided to the state attorney's office verify that you got on the bus?
Yes.
Does it state on there that you actually used that bus ticket?
No. I'm trying to understand what you're saying.
Just asking, other than you stating that you left, is there any independent verification that you actually got on a bus and went to Pennsylvania?
I went to Pennsylvania.
And let me ask it again, is there any verification of that you have?
That I have.
Objection, Your Honor. Ask and answer.
Your Honor, he did not answer that question.
I think he's answered it, but I'll overrule it. You can answer this one last time, and we'll put the issue to bed. So you can.
I'm asking about verification. I'm sorry, Judge, I thought you were done.
No, it's fine. I was going to say if you needed to repeat your question or if you remember the question.
Of course.
I don't remember at this point. So why don't you go ahead and re-ask the question, and we'll see what the answer is, and we'll go from there.
Yes, I'm not asking whether you say you're in there. I said if there is any independent verification of that you have.
I mean, whenever I scan my phone for the ticket to get on the bus, yes.
All right. And you've provided that information to the state attorney.
Already, yes.
And that was just a couple of weeks ago.
Yes.
When this was asked of you about last month, you said differently, though, correct?
When I talked to you? Yes. When I talked to you, I did say differently.
Just a moment.
Good morning, Mr. Humphrey.
Sam, do you want a glass of water?
Good morning.
Okay. Okay. Go ahead. I just want to check on the juror. You're fine. Go ahead, state.
Yes, sir. Thank you. Now, Mr. Humphrey, counsel didn't bring it up, but did you talk to the news about this case?
Yes, sir.
In fact, after IS went missing, you went on camera, did you not, sir?
Yes, sir.
And you told the news that you were hoping for anyone out there to provide information, correct, sir?
Yes, sir.
You were being a good neighbor, weren't you, sir?
Yes, sir.
Trying to help find IS, correct, sir?
Yes, sir.
You knew her from before, your encounter before, correct?
Yes, sir.
Cooperating, putting your face on camera. You agree with that, sir?
Yes, sir.
In fact, when you spoke to the news, you pleaded for anyone to come forward for information, correct?
Yes, sir.
And you did that, obviously, after she disappeared. You agree with that?
Yes, sir.
And sometime later after she disappeared, I think the jury's already heard it's been some days before there was heavy media coverage, you willingly agreed to do that, right, sir?
Yes, sir.
Right. It wasn't until the deposition with Miss Michelle is when you started you were misrepresenting things, correct, sir?
Sir.
You didn't hit it off with her, did you?
No, sir.
All right. Now, Mr. Humphrey, did you have anything whatsoever to do about the disappearance of IS at all?
No, sir.
Now, these dates that we were talking about, you, in fact, were gone from December 18 of 2018 through December 28th of 2018, correct?
Yes, sir.
In fact, after that deposition, you went and pulled off your phone the exact dates and times of when you left town and when you returned, correct, sir?
Yes, sir.
And you provided it to our office, did you not, sir?
Yes, sir.
You apologized for misrepresenting yourself in that deposition, did you not, sir?
Yes, sir.
Sir, were you in Harrisburg, Pennsylvania from December 18th to December 28th of 2018?
Yes, sir.
Do you even recall sitting here today what times you got on and off the bus?
No, sir, I don't.
Requested for, I'm sorry, Your Honor.
He has to come forward.
Oh, I'm sorry.
You're fine. Just so the record for the juror asked me what you said as you went away from the microphone, Mr. Skinner. I told him you asked me permission to approach the witness.
Sir, is this the information that you provided the state attorney's office?
Yes, sir.
Did you pull that information off of your phone?
Yes, sir.
Is that from your records?
Yes, sir.
Will you tell us exactly what time you left Jacksonville, Florida on a Greyhound bus on December 18 of 2018?
It says leaving. I left from Jacksonville, Florida on December 18th, 5:30 p.m.
And what time did you arrive to Harrisburg, Pennsylvania?
Hold on. (1:00 p.m.)
Was that the next day on December 19th of 2018?
Yes, sir.
And what was the date of your return trip from Harris, Pennsylvania back to Jacksonville?
December 27th to December 28th,
You departed Harrisburg, Pennsylvania on December 27, 2018 at what time, sir?
4:20 p.m.,
And at what time did you arrive back in Jacksonville on December 28 of 2018?
1 o'clock p.m.
Thanks, sir. Your Honor, request to admit the next numbered exhibit, I think it's State 68. I have marked the State Exhibit Triple P for identification purpose and requested admit.
Any objection? No objection, Your Honor. Without objection, mark as state 68.
Nothing further, Your Honor. Thank you.
Mr. Humphrey, take a second. Go ahead. You ready?
Yes, ma'am.
Alrighty. Mr. Humphrey, you provided that information of that ticket to the state attorney's office a few weeks ago, correct?
Yes, ma'am.
So shortly after our deposition, right?
Yes, ma'am.
All right. During that deposition, do you recall consulting your own calendar and telling us the dates of December 21st through 23rd?
Again, you were very aggressive with me when we had the deposition. So I did and mess up with that deposition. Yes, I did.
Did you tell us that you were consulting your calendar at that time and verified that the dates you were out of town were December 21st through the 23rd?
I lied about the dates to you when we had our deposition, and I came forth and told the truth afterwards.
You also lied about whether or not you even had a sexual relationship with IS during that same deposition, correct?
Yes, because I felt like you were attacking me and trying to incriminate me at the time. Yes, ma'am.
You, in fact, had been charged and pled to this charge of that we're talking about from March of 2018, have you not?
I pled guilty to a battery charge, battery felony, and as a part of my plea was to take the stand.
Part of your plea was to come here and testify.
Yes, ma'am.
And is that part of the reason why it wasn't a lewd and lascivious battery charge as it was originally?
Repeat your question.
Is that part of the reason why it was dropped down from a lewd and lascivious battery charge to felony battery?
I'm not sure.
That negotiation that you made, that was between you and your attorneys, correct?
Correct.
And you're on probation right now
Yes, I am.
for that charge.
Yes, I am.
And yet, a few weeks ago, you denied having any sexual relationship with her and said it was false allegations.
Indeed, because of, like I said, when we were having our deposition, you were very aggressive, and the words that you were using, I did not comprehend. So, yes, I felt like you were attacking me at the moment, and that's how I handled that situation.
The question of did you have a sexual relationship with IS you considered to be an attack,
Yes,
and that caused you to lie.
yes.
And the where you were on December 19th and 20th, that was an attack.
What do you mean that was a
question
Yes,
that
you were.
was
I felt the way that you were asking me those questions and talking to me, I felt like you were attacking me as you
That
were
made you
asking
lie.
those questions. I'm sorry, I didn't mean to cut you off.
No, I cut you off. Go ahead. Go ahead.
No. I'm like I said, you were attacking me at that time. Yes, ma'am. Go ahead.
And that made you lie.
Yes, ma'am. I was under pressure.
Nothing further.
Mr. Humphrey, good to see you, sir.
That's it.
That's it? Ms. Michelle Mr. Davis, you can call your next witness.
Defense, Russ.
He turned out to be a witness for the defense. That's all I'm going to say about that. She shouldn't be so nasty and hostile. Maybe she wouldn't get these type of reactions. So at this time, I just wanted to take a moment to say hello to some new people that came in the chat. So Just Valencia, thank you so much for returning. I did see you say we are back. Thank you so much for that. We got Notre Dame. Thank you so much for joining us. You know, I like to say hello verbally from me to you. Little hospitality going on, little Southern hospitality. Just Lee, I want to say thank you for always being here and supporting the show. And our prayers do go up to you for your upcoming surgery. And I pray that all goes well. And we're going to put that out and speak that into existence, that you will have a speedy recovery for whatever your surgery is for. AOBD, always good to see you in the building with us. AOBD is family. And you know, I be feeling the type of way when I don't see AOBD in the chat, but I've seen you in here for last week, and I'm happy because AOBD is one of my day ones from when I started actually putting content on here. We also got Flex in the house. That is Flesh of the Gods. Now, if you are not sub to Flesh of the Gods, you do not know what you are missing. I need you guys to go over to Flesh of the Gods, my good brother, and sub up. He has a different type of content going on over there because he does all sorts of things with the screen, interacting with his subscribers and supporters, and for the people in the bushes and everything. You get to see a different type of experience over there with Flesh of the Gods. And like I said, Flesh of the Gods has his own soundbite over here because this is how I feel when I go on over there.
Humans weren't meant to perceive things like this.
So that's and I hope y'all can hear that because I do have it up. So okay, I hope y'all heard that. That is Flesh of the Gods, his sound bites. And so go over there and sub to Flesh. And also, as always, I'm going to tell y'all, shout out to No One for the background music. I just turned it down so you guys can hear the video. But shout out to No One for making this background track for Your Girl Survivor Speaks. I definitely appreciate him, and just keep an eye out for we should have some things coming in the works, and hopefully sooner than later. But just wanted to play that a little bit before I turn it back down and start the video. And I think I spoke to everyone in the chat. Free Flesh of the Gods, free Flex. Everybody hashtag free Flex. If you are a channel member, please drop his channel emoji in the chat. It is the red, black, and green goat because he is the goat. So we're going to get right back into the defense's next witness that will be taking the stand, and let's see how Miss Michelle go to hell. Let's see how she talks to her next witness, because she in that area. She has a lot to learn. Watch the Rise is in the building. Hashtag and free Flex. Thank you for coming. Watch the Rise. So let's get right back into it.
Members of the jury, it's 10:35. I need to talk with the attorneys outside your presence to determine our next steps.
Judge, I could have.
I have a couple options, just to be transparent with you guys as to what I'm thinking next.
Let's see.
I may merge the mid-morning break and our lunch break, and make it just an extended time. It depends what's next. I don't know. You guys mind just stepping into the jury room for about 5 minutes? I'll have more information. That way I can let you guys know what's going on. Please remember, don't discuss the case among yourselves or each other. Jury's outside our presence. I still have counsel for the state defense. Mr. Quella's present. You guys may have a seat. State, do you have a rebuttal case? Okay, so you're ready for closings then?
Yes, sir.
Okay, what I'm thinking of doing is I got to give them a break, and there's reasons for that.
Hold on. Wait a minute. How are we here? I thought the brother was. Yeah, hold on a minute.
Jury needs a break. What I'm thinking of doing is just giving them like an hour and a half break. Come back maybe just after noon.
Hold on, y'all.
For a lot of people, I get that.
Hold on, y'all. Because when I checked, there's no way we are letting them get to closing, and we didn't get to the brother. Now, when I checked this video, he was in here. So I thought he was the last witness. Just give me a moment, because there is no way we are going to be skipping past that. Hi y'all. There's no way we're going to be skipping past that testimony. And I know I did. So hold on, y'all. We gotta go back because I don't know how this. Oh gosh, we gotta go back because the. So was it at the end of what we did on Friday? Hold on. Just give me a minute. Yeah, because he was up there with these people for the longest. But I thought his brother was the last witness. Okay, y'all. So we got to go back. I know what happened. So we skipped past the rest of, well, we stopped at the end of himself snitching. It just got too much. And I thought that they ended it after that. So the brother is actually the last person that was testifying on the end of that day. So we're going to bring that over because there's no way we're missing that testimony. And then we can just go right back to the other live and finish up with and we could just start the closing today, which is awesome. Okay, so thank you all. I'm like, wait a minute, hold on now. We missing a little something. It's not what we doing. Let me make sure I got everybody that's in here, and I said hello to everyone verbally, and because you have to let everyone know. Say hi to everyone verbally. That's just me. I do that on here. So I have said hello to everyone. So let's get the this right back up here so we can hear his brother's testimony.
All right, Mr. Jackson, you testified on direct that you yourself never threatened Mr. Quilles, correct?
Yes, ma'am.
And you didn't hear Morris McClendon
So we'll hear the end of this.
threaten Mr. Quilles either, correct?
Yes, ma'am.
At the very beginning of that wire, you all were talking about razors. There's razors on the floor, and then you talked about razors again. That was a threat to Mr. Quilles, correct?
Well, I don't know.
You don't remember.
Yes, ma'am.
At the very beginning of that conversation, were you and Morris McClendon consuming illegal substances?
No, ma'am.
There were no drugs in that cell at that point in time.
Not that I know of.
You never held a razor in your hand.
Don't remember.
You don't remember.
No, ma'am.
You never threatened Mr. Quilles. You never gestured towards him with a razor blade.
No, ma'am.
There are a couple parts of that conversation, especially at the beginning, where we hear what sounds like jumping on that recording. Do you recall that?
I don't remember what part clearly.
All right. You testified during direct that it was Morris McClendon who had control over that recording device, correct?
Yes.
So you don't know when he started it, when he stopped it, if he jumped, when it's jumping, whether that's him stopping and restarting it, do you?
No, ma'am.
And so that would not reflect the entire conversation of what may have been said by you or Morris McClendon during those times when it was not recording, correct?
I'm confused.
It would not include the parts where Morris McClendon stopped and then restarted. We would not be able to tell what happened in that in-between time.
Yeah, I want to know if he stopped or started when he did it.
And so if the threats were being made on times when Morris McClendon was not recording, that would not be reflected in what we just listened to, correct?
Now they threatened him?
You also stated that you didn't have any control over that whatsoever. So you didn't tell him, give him any signals or anything like that. That was completely within the control of Morris McClendon as far as the recording device goes.
Yes, ma'am.
You also stated that you and him didn't have any information about the case or anything like that prior to Mr. Quilles coming into that cell. Is that correct?
Yes.
But in fact, you and Mr. McClendon had a conversation about what you could elicit from Mr. Quilles before he came in there. And is that not true?
I don't remember that part.
In fact, Morris McClendon had told you, hey, this guy's going to come in. We need to get him to say X, Y, Z. Did he not tell you that?
No.
On this wire that we just listened to, Mr. Quilles, in fact, denies doing anything as it relates to IS on several occasions, correct?
Yes, I heard him say
And then on these times when Morris McClendon could have been stopping and restarting that recording device, Mr. Quilles could have been denying in those as well, but we wouldn't get the opportunity to hear that, would we?
Our objection is speculation.
Sustained.
As it relates to some of the specifics, on that wire, we actually heard him tell you that the allegations from the younger sister were completely fabricated, correct?
Yes.
And that was used to get him into jail, correct?
Yes.
In fact, he told you that never happened at all. Absolutely not.
Yes.
Is it fair to say that throughout that conversation, you and Morris McClendon were prompting Mr. Quilles to answer questions about this alleged murder?
Yes.
You all were feeding him information beforehand, telling him things and having him respond to those, correct?
Not really sure.
Before he does not give you specific information on his own. You guys ask questions, he responds to them. Is that fair to say?
Yes.
And that's the great majority of the wire, is you all prompting and saying things and then him responding, correct?
Yes.
He didn't just sit there and confess and give you all this information freely and willingly. You all are pushing, leading, and giving him information to give back to you, correct?
Yes.
I want to talk to you, I want to talk to you about the length of time that you all talked. We're listening to about an hour and 56 minutes, correct?
Yes.
But again, if that recording is stopped and restarted, that conversation could have been much longer than that, correct?
I guess.
And again, we would not get the benefit of whatever is not on that recording, correct?
I guess so.
He talked to you guys about a landfill. He told you that it was going to Trail Ridge, correct?
Yes.
He never once mentioned the Otis landfill, did he?
I don't remember.
He was actually adamant that it was Trail Ridge that he was believing that the dumpsters would go to, correct?
I don't remember.
Even when you and Mr. McClendon were saying, that's not where that goes, that's not where it is, it's a different one, he still continued to say Trail Ridge, correct?
Yes.
Again, this isn't some sort of confession where Mr. Quilles just sits there and lays out all exactly what happened and how he did it and all of these things. These are things that you prompted him with, you led him to say, correct?
Yes.
And again, you and Mr. McClendon had to ask him over and over and over again. You had to keep going back to details, had to keep asking additional questions and prompting him in order for him to give you answers, correct?
Somewhat, yes.
I'm sorry, I couldn't hear you.
Somewhat, yes.
You didn't know Mr. Quilles before you guys were placed in the cell in order to try and get any sort of information you could, correct?
No, ma'am.
Outside of this one conversation, you'd never spoken to him before, right?
No, ma'am.
And you've never spoken to him again.
No, ma'am.
You stated at the very beginning that you are cooperating on several cases, correct?
Yes.
And so this is like a side job for you.
No.
You are hoping to receive a benefit of substantial cooperation in this case to help out your probation that you're currently on right now, correct?
Somewhat, yes.
And you, in fact, you've received benefits in the past, so you know how the system works, correct?
Yes.
You said you're a 3-time convicted felon. Please correct me if I'm wrong. I believe that's correct.
Yes.
Okay. And the current charges that you are facing for from the probation are what?
Schemes to defraud.
It was just schemes to fraud?
Schemes to defraud. Or organized fraud, I think. I'm not sure exactly what it is.
All right, thank you. And I know that you testified at the very beginning that you can only attest to the things that you personally saw. But there was a time period, in fact, where you were not inside that cell while Morris McClendon was in the cell with Mr. Quilles, correct?
Yes.
So during that time period, when you were not in the cell, Morris McClendon was having conversations with Mr. Quilles, was he not?
I mean, possible.
So those threats that you didn't hear, Morris McClendon.
Sustained.
Nothing further.
Mr. Jackson, good to see you, sir. Have a good rest of your day. Okay, you can call your next witness.
State of Florida calls Joseph Quiles.
Okay, so he is the state's last witness, but the defense, that's different. He's the state's last witness. On the stand is going, Joseph Quiles is going to be on the stand. This is Jonathan Quiles' brother.
sir. Good afternoon to you. Watch your steps as you come forward. If you need a glass of water, let us know. We'll do our best to accommodate you. The only thing I ask if there's an objection made in the course of your testimony, just pause, let me rule on the objection, and we'll go from there.
Okay.
And you can adjust the microphone to help your voice project.
Okay, thank you.
You may inquire, you're ready.
Thank you very much, Your Honor. Good afternoon, sir.
Good afternoon.
Will you state your name, please?
My name is Joseph Quiles, Quiles.
What state do you live in, sir?
I live in New York City.
And where are you employed?
I work in
General.
Staten Island.
What kind of work do you do, sir?
I drive trucks.
Who do you live with in New York?
And me and my wife.
Have any children?
Yes.
How many?
That live with me?
Yes, sir.
4.
The total number of kids that you have?
No, I have 8.
8, I thought it was 6.
How long have you lived in New York,
Majority of my life.
sir? Now, specifically in December of 2018, were you also living in New York permanently at that time?
Yes.
Living with your wife?
Yes.
How old are you today, sir?
I'm 40.
So approximately in 2018, how old were you?
35.
Sir, who is Jonathan Quiles to you?
My brother.
So your biological brother.
Yes.
Is he your only brother?
Yes.
Do you have any sisters?
I have like stepsisters.
Who's your father, sir?
Joseph Quiles, but he's no longer in the picture.
Was he ever involved in your life?
A small amount.
All right. And how about your mother? Who was she?
My mother is deceased. Name was Annette.
And what year did she pass away?
In 2000, the ending of 2010.
Do you see your brother Jonathan Quiles in this courtroom, sir?
Yes, I do.
You describe where he's seated and what he's wearing.
Sitting to my right, he's wearing glasses, ponytail, and a blue shirt.
Your Honor, may the record reflect he's identified the defendant.
So reflected.
Do you, sir, and the defendant share both of those same parents that you just described?
Yes.
Will you first describe your relationship with the defendant while you were growing up?
We grew up together, but we weren't. I did a lot of moving around, and so he mostly grew up with my mother and aunts and stuff.
Was your relationship okay between the two of you as you grew up?
As we grew up, yes, but we weren't always together.
Did you become closer with him as you grew older?
Yeah.
Can you describe that a little bit, please?
As we got older, I became more settled, and he became more settled. We reunited and definitely spent a lot more time together. Well, mostly through phone and Texas. Yeah.
That's where I was going next. As you got closer, did you generally communicate via electronic devices?
Yes.
Did you get to see him often?
Not often.
What is the age difference between the two of you?
2 years.
Is he older or younger than you?
Younger.
Now, directing your attention back to the latter part of 2018, would you describe your relationship with your brother, the defendant, as close at that time?
Yes.
Are you talking routinely?
Yes.
Are you texting with each other routinely?
Yes.
If the records show you and your brother talked and or texted some 200 plus times on your devices in December, would you agree with that?
Yes.
Would you consider yourself close as brothers could be in December
Yes.
of
Definitely.
2018?
Yes.
Would you say you spoke almost every single day?
Just about, yes, every day.
Did he share with you any details about his job at Ace Pick-A-Part at that time?
Yes.
Did he just give you sort of a description of what he did for a living there?
Yes, but he transitioned from multiple jobs, so we always talk about how fast he would climb up the ranks in the job. So, yeah,
At different jobs?
at different jobs.
Did he ever show any video of himself on Facebook or anything like that with him while working at Ace Pick-A-Part?
No, not on social media. We would FaceTime.
All right, even on FaceTime?
Yeah, we would FaceTime while he's like doing his duties at the job.
Did you guys engage in communication during this the FaceTime?
Yeah, we can say that. Yeah.
I no longer pray, God, give me what I think I need. But
Now,
give
sir,
me
are
what
you
you
good
know
with
I
dates?
need.
Depends. Yeah.
All right. I want to direct your attention back to December 19, 2018, leading over to December 20 of 2018. Do you recall just sitting here now what day you spoke with your brother about what we're here to testify now about?
I remember speaking to him in that time.
Day?
Which day? Not so much, but I know between those 2 days, yes.
All right. If your phone records that this jury has seen reflects that you either called him or he called you on 4 occasions on December 20, 2018, would you agree with that?
Yes, I would agree with that.
Now, in December 19, 2018, or December 20, 2018, were you in New York City at that time?
Yes,
When you had these conversations with your brother, were you at work or were you at home or elsewhere?
I was at home at the time.
On December 20, 2018, when the first call was made, best you can recall, who called whom?
I don't recall who called who.
Fair enough. Did you first speak with him on that particular day? And if so, will you first describe his demeanor, how he was acting on the phone?
When we spoke, his after normal greetings, his demeanor was a little off. It was kind of like he was nervous or a little panicky about something.
Have you heard your brother sound panicky to you on previous occasions?
No.
Did it surprise you how he was acting?
Yeah, always very confident.
Did he appear to be concerned when he was talking to you?
Yeah, more of a concern, yeah.
Was the tone of his voice different?
Yes.
Was he making sense, or was he more talking to you in a rambling manner?
It was more, I wouldn't say rambling. It was more like, I need to do something. There's something I need to do.
All right, we'll talk about what he said in a moment. Is there anything else that you could describe about his demeanor or how he was sounding on your phone calls?
No, just he was worried, just concerned, yeah. That's it.
Worried and concerned?
Yeah.
All right, now would you now explain to the jury what did he first start telling you about that took you by surprise, sir?
The first initial conversation that we had, I don't recall. After that, getting closer to what was his worry, he was more concerned about what is he going to do with the young lady in question, that she might be pregnant, and what is he going to do? He doesn't want to ruin his family and mess up what he has already going on.
All right. Did he in fact tell you she was pregnant?
Yes.
Did he tell you who she was to him?
Yeah, his wife's niece.
Did he use her name to you?
Not that I could recall. It's mostly in that term.
When he told you that she was pregnant, what, if anything, did he tell you about what he was going to do about that, sir?
He said that he needs to. She's pregnant, and what is he going to do? And then outside of that, there was no conversation at that particular moment about what is he going to do.
All right. Did the conversation end shortly after he expressed that to you?
Yeah, at some point in time, we had another conversation where I started questioning him a little bit more about what he was going to do, or what he did or didn't do. And
So just so we're clear, let me stop you there. Was this next phone call on the same day?
same day. I don't know if in the order of the calls for the conversation. And after we had a small conversation, he then said that he already handled the situation. He already took care of it.
Were those his words? He took care of it?
Yeah, he took care of it.
All right, sir. Now tell this jury what he told you with respect to how he took care of the situation.
I'm obsessed with being the best version
Another
of me.
conversation, same day. He then said that he took the young lady and he had her sitting in a vehicle. He picked her up. He had her sitting in a vehicle, waiting. He tried to strangle her. It didn't work out. He couldn't stomach it, and so then he later went shot her in the chest, and then he proceeded to discard the body by taking the body and putting it transporting it into a dumpster, and destroying the vehicle.
Mr. Quiles, did he tell you where first he had the niece in the car? Where was he?
So in the conversation, I said it's unrealistic that you would choke a girl, have her sitting in a car waiting, and she's just sitting there. And he then said, no, but she is. And he then said that he had her sitting waiting in the back of his job, at the back of the place where there's nobody really goes there. It's just cars sitting back there, and so she's just waiting. Yeah, she's just waiting.
All right. Did he say the area that she was sitting was in the back of his current job at Ace Pick Apartment?
Yeah, there was a certain part that They just had like vehicles just sitting there, and they would take them to get dismantled or crushed, and no one really goes back there. You would need like a permission to go back there.
When he said he strangled her, did he say that was inside the car or outside the car, if you can recall?
No, it was definitely in the car. What car? I don't know.
All right. Did he say where he shot her? Was that inside the car or outside?
Same answer. Yeah, it's in the car, but I don't know if it's in the car that he brought her to or the car that was sitting there.
Did he say where he shot her on her person?
A chest.
Did he tell you how he was able to get her and or encourage her to come to his job? What, if anything, did he tell her to get her there?
Just a process of like explaining to her that they were going to run away together. They were going to be together.
He told you he was telling her that they were going to run away together?
Yes, them two.
And that they would be together as a
They would
couple?
be together, yes.
What specifically did he tell you, if he did, to her body after she had passed? Did he tell you what he did with her?
Yeah, he said he wrapped her up in carpet and then transported her.
Did he transport her to where?
The dumpster.
The dumpster at his work?
Yes, at Ace Pick Apart, yes.
Did he say how he was able to transport her wrapped in carpet to that dumpster? Did he tell you that
Yeah.
detail?
Yeah, he used one of the machineries.
What, if anything, did he tell you that he knew about that particular dumpster and how long it would be there?
Well, that was a conversation that we had. How would you just leave her sitting there, you know? And he said, no, the dumpster gets picked up today. Well, he gets picked up. And so this is going to be one of the days that it gets picked up because it's full.
Did he tell you he knew that dumpster was full?
Yeah. No, he knew that it was going to get picked up.
What, if anything, did he tell you if his niece had that baby, what it would cause to his family?
No, he would lose his entire family. And, you know.
Yes, sir. What, if anything, did he tell you with respect to the weapon that he used? What was it?
His gun.
What, if anything, did he tell you he did with his gun thereafter, if he did?
He didn't tell me anything that he did with his gun afterwards. He said that he went to the shooting range. If you were talking about the usage of the gun,
Yes, sir.
afterwards he went to the shooting range, and that's it.
And why did he tell you he went to the shooting range?
To just blow off, I guess, whatever steam he had left over, any anxiety.
Did he tell you, Mr. Quiles, how long he had been planning to do this?
Yes, he said he's planning it for months.
Now, if he did he tell you anything with respect to what he did with her phone? Start with that.
The phone, he said he took it and threw it into like a neighboring water, a river or something, a body of water.
What about any of her belongings? If he said anything about like a bag or bags, anything of that nature, did he tell you what he did with those items? If he did.
No, I don't recall asking him about her belongings.
Now, Mr. Quiles, were you surprised by what he told you?
Absolutely.
Did it shock you?
Yes.
First, I want to ask you, staying with that day, December 20, 2018, I know there was 4 calls. Did you put the phone down the last time for that day, let's say after the 4th call, and call the police right then?
No, I didn't.
And just, if you would, sir, just tell us why not.
I just didn't believe him. You know, I thought he was joking. He tells a lot of elaborate stories. Most of them are not true. So I definitely didn't believe him. I just thought it was one of his little concocted stories.
Now, did some time pass thereafter, Mr. Quiles, moving forward for some days where you learned through family members that your brother had a niece by marriage that was in fact missing?
Yes.
Right. Will you tell our jury how you learned about that?
I went to my grandmother's house.
And if you went to your grandmother's house, can you give us an estimate about how long after that conversation was on December 20, 2018 that you went to your grandmother's house?
I'm not sure how long.
Right. Let's start this way. Was it more than a week?
I'm not sure.
Was it within a month?
Within a month, yeah.
Okay,
Sure.
it was shortly after.
Yeah, shortly after. Yeah.
Yes, sir. And where does your grandmother live? You don't have to give us an address, but where was she?
Yeah, she in her residence in New York City.
Okay. Did you go over to her house or did you call her?
No, I went over to her house.
All right. Is that where you learned that your brother had a niece by marriage that was missing?
Yeah.
First you learned that.
Yeah. So she told me that.
Don't tell us what somebody else told you. So thank you, though. But I just want to make sure when and if you first learned that she'd been reported missing.
Yeah.
Is that where you learned?
That's where I learned this from. Yeah.
Okay. Now, once you heard that, did you start wrestling, sir, within yourself about whether you should call the police about what he told you?
Yes.
Was that a difficult decision, sir?
Yeah, very difficult decision. Because I love my brother, so it was very difficult. But I didn't just call the police then. I gave it time, and I tried to speak to him more about seeing if he would change what he said, and giving him the opportunity.
Okay. Did you say you love your brother?
Yeah, I do.
Did you want to call the police?
Absolutely not. But we don't tolerate anything that has to do with abuse of women and children. You know, we don't tolerate that kind of stuff. That's not the cloth that I'm cut from.
Yes, sir. And when you say we, you're talking about your family.
I'm talking about myself, women specific.
All right.
I don't deal with that kind of stuff.
All right. From when you verified at your grandmother's house in New York, his niece was missing, and now grappling with what he told you, how long did you wait to then call the police after that, approximately, if you can remember?
It's definitely within that month time frame.
All right.
Yeah. I didn't go into February. I know like into January.
You're certain it was in January?
Yeah.
Now, the police have reported and the jury has heard that was January 8th. Would you agree that's the approximate date?
Yeah, I would say, yeah, approximately.
Okay. Now, you mentioned just a minute ago that you were trying to talk to him some more and try to get him to tell you it was either some sort of joke or you were going to, you tried to pursue him. What did he tell you when you called him and said, hey, listen, I'm grappling with this?
Yeah, at first, I didn't come really direct. I told him, are you sure that this is something that happened? And he would brush me off and say, I can't talk about that over the phone, which got me a little more upset. And then when I readdressed it again, we had like a little back and forth. And then I think the final straw is when the last conversation we had, and he said, basically, I don't know him, and I don't know him, and that am I willing to risk our brotherhood, for a situation like this? After I told him that I think that I'm gonna report this and call the police, he then said, how are you gonna jeopardize our brotherhood based upon something that I was just joking about? But my decision was already made.
All right. And on that day that you decided to call the police reported, and the jury's heard January 8th.
Right.
You recall that date, approximately?
Yeah.
Did you send him a text?
Yes.
Sir, I want to read to you State's Exhibit 33, and I want you to confirm to this jury this was a text from you to the defendant, okay?
Okay.
Did you write the following, sir? Quote, I can't talk to you right now. I have to stay firm on my decision. What you told me isn't some joke or something you like about, so yes, I told the police because they needed to know. If you was lying, then you will be cleared and free, but if you wasn't, then you won't. I'm sorry I have to do the right thing for that girl and her family, not the right thing for you and your selfishness. I hate to lose you, but I'd rather that the girl's family have some peace. If you're innocent, then you don't need to worry, and they won't find her body, but if you're not, they're going to find her, and in that case, I already lost my brother. I'm sorry. Sir, did you send that text to your brother?
Yes, I did. I think that's the last text I sent him.
Sir, after that text, was there any further communication to this day between you and your brother?
Yeah, we communicate still.
You still love your brother?
Of course I do.
You don't want to be here doing this, sir?
Absolutely not.
Will you tell the jury in general why you made that ultimate decision to call the police?
And I made the decision based upon, it's not about the brotherhood, it's about a missing young girl. So if this was an opportunity for her to be found, if this was a direction that she could have possibly went, and I wanted to give the family that option. Yeah.
Thank you, sir. One moment, Your Honor.
No, sir. Thank you.
Nothing further.
Good afternoon.
We're coming into evening now, so.
Oh, yeah.
All right, thanks for being here. I just have a few questions to kind of follow up with you.
Okay.
You just stated a few minutes ago that essentially if you had a choice, you wouldn't be here testifying, right?
Right.
You feel like you kind of forced to testify against your brother today?
And that's like a yes and a no question answer.
Understood.
I made the initial call to the police, so the responsibility of it, yes. As like a duty to my brother, yeah, I feel like I'm forced to be here based upon that.
And based upon that decision to call that day, that's what you feel has led you to here at this point?
Yeah.
And that's the part that you feel is like, hey, I have no choice. I already made that decision. I have to just deal with that.
Yes, ma'am.
Okay, understood. I want to kind of go back. You and John talked fairly often. You testified to that during this time, like in that December month.
Yeah.
Jury's heard that you guys were texting and calling more than 200, I think it was 228 times during December. And you said that sounds totally normal because you guys were in contact that often.
Yeah.
You guys would text, call, you said you even FaceTimed, and that would be throughout the day.
You mean like every day? Like that was like a pattern?
Yeah, not every single day. I'm sure you didn't do all three of those things, but that would be something that you all would regularly do, text, call, or FaceTime each other.
Definitely, yeah.
And you even stated that when he was at work, you guys would FaceTime and talk then as well.
Yeah.
And so while he was working, were you able to kind of observe the area that he was working in as far as when he was working at Ace Pick-A-Part?
No, not in that manner. Like he's showing me around. It's more FaceTime. My phone's down. He's operating a vehicle, or I'm doing something in my house, like regular. I guess it was regular now.
Yeah, I don't mean he gave you a tour, but you could see that he was at work and that type of thing.
Yeah.
And he would explain his job to you, what he was doing, that kind of thing.
Yeah.
And he liked to talk about work, and like you said, he'd move up quickly, jobs he would do.
Yeah, we would make jokes about that, but it's just general life stuff. What I'm going through, what he's going through, and we just have a regular conversation.
Right. And kind of going towards a little bit more towards this conversation that you have talked about today, as best you can recall, that day when you and your brother talked, this wasn't just some one conversation. He laid this whole thing out to you. You said it was kind of broken up into several conversations.
Yes, ma'am.
And originally when you all called, when you guys connected on the phone call, you guys were just having a regular conversation, right?
A brief conversation, yeah. Just, hey, what's up? What's going on? I don't think we spoke. I think for a day or so. I'm not sure. We didn't speak. I was caught up with something in my house.
Gotcha. And so it was just kind of catching up at the beginning of that conversation. Hey, how you doing? That kind of thing.
Yeah, brief. Hey, what's up?
I'm sorry, go ahead.
Yeah, no, that was just a brief, like, hey, what's going on? What you doing? Things like that, just general stuff.
So after you guys exchanged kind of what was going on with you and that type of thing, that is when Mr. Quiles, your brother, went into this story.
Yeah, most after, like, I asked, like, hey, what's up? What's going on with you? Why you're not engaged? Like, with me, he wasn't engaged with me.
Understood. And was that part of the reason why you were describing his demeanor as kind of nervous, or I think you used the word nervous or concerned?
I'm sorry.
Sorry, let me finish that. Is that the reason why you described his demeanor as nervous or kind of concerned?
After the general statement, after the statement that he made.
Understood. I wanted to ask you a little bit about that conversation because of a couple of things that you described. You stated that at one point he told you that he tried to strangle IS, and then he left her.
Yes.
And you were questioning him about that because that just didn't make sense to you.
Yeah.
And, go ahead, I'm sorry.
Oh, I'm saying yes.
Okay. And that didn't make sense to you because why would IS stay in the vehicle and sit around if someone just tried to strangle her, right?
Right.
Okay. And in that description to you, he tries to strangle her, he leaves her for some period of time, although you don't know how long.
Right.
And then he comes back, and at that point he tells you he shot her.
Yes.
And that story to you just didn't add up.
Yeah, it didn't make sense at the time.
And that's what he said to you, though.
Yes.
Did you question him any further as it relates to kind of things that didn't make sense to you?
Yeah, somewhat, yes.
So when he started talking to you at that point in time, were you completely focused in on this conversation, or were you kind of distracted, busy doing other things?
I really don't recall. I don't recall.
Right. And I know you said that when you first kind of were listening to this conversation, you were thinking more of, what's he talking about, trying to figure it out, right?
Right.
And you also said that you didn't believe what he was telling you at that time at all.
Yeah, right.
When you also stated that part of the reason why you didn't believe him is because he is known to kind of make up stories. What do you mean by that?
Like he would, for example, he would tell like elaborate stories when we were younger, all the leading up until we were adults. One of the stories I can possibly say that he said was that he was smoking weed when he was younger, and my mother caught him. And instead of just saying, "Hey, I was just hanging out with the fellas and I got high," he came up with this whole elaborate story that how he's a drug addict, and he does angel dust. So my mother ended up sending him all the way away to a facility, drug facility. So he spent more than a year in a drug facility and never did a drug in his life.
So in that time period, that story that you just told us, that was a situation, he actually went away to a drug rehab facility for an entire year.
Yeah, he wouldn't admit that he just smoked a little bit of weed with his friends.
And you stated that he never had any drugs in the system.
No,
And how do you know that?
because we would check on him. My mother would check on him. She's a drug counselor. So she would check to see what his urine was coming up positive for drugs, anything. And he's the only one that kept testing negative.
And he kept up with that story for an entire year.
Yet to this day, he says that he's a recovering drug addict.
And you knew that to not be the truth.
Yeah, it's not the truth.
Is that the type of thing that he would do? Just make up these wild stories?
Yeah.
And was he convincing with those? Did people actually believe him?
Oh yeah, he's very convincing.
Would you say he was the kind of person who kind of like performs or gets into character and you know, does that?
Yeah.
So as he was talking to you about this particular story, were you in your mind thinking, here he goes again?
Yeah, yeah. Majority of the time, yeah. He's always in a story.
Have you heard him ever talk about being a part of the NYPD?
Yeah, yes.
Has he ever been an NYPD officer?
Absolutely not.
Is that something that he would say often?
Yes.
What about him being a bounty hunter?
We thought he was a bounty hunter at one point, but we come to find out he wasn't a bounty hunter. He was an assistant to a bounty hunter.
So is these type of things of him inserting himself in situations and saying things like that, making up stories, embellishing things, is that par for the course for how you know your brother to be?
Yes.
Is that part of the reason why, when he first told you this, you didn't call police?
Right.
And you waited quite some time. It wasn't until you found out that there may be some connection to a real case that prompted you to actually have some questions.
Yes.
I know you know him fairly well because you grew up with him. If you didn't know him and you heard this type of story, you would believe it.
If I didn't know him, there would be.
Just give me a legal basis.
Because you know your brother, you did not believe him, correct?
Yes, I didn't believe him.
As far as kind of growing up, even into adulthood, the things that you've described in the couple of situations that you provided, did you believe that he was doing and saying those types of things in order to seek attention?
Yes.
Insert himself in situations?
Insert himself in what situation?
Just in general, I just mean kind of I know you gave me one example and I kind of prompted you with a couple of others. Was that par for the course for him?
Yeah, that's normal behavior.
Even if it didn't even make sense?
Yeah.
When you were asking him how he could have done these things, he always gave you an answer, didn't he?
Yeah.
If you had a question, if you prompted him in some way, he would respond to you, correct?
Yes.
If you led him down a line, he's going to give you an answer no matter what.
Right.
Is he the type of person who, he's not going to let a question go unanswered?
Yeah, for sure.
He's going to give you some sort of response,
Right.
even if it's not the truth,
Yes.
even if it's a made-up part of his story.
Right.
So is he the type of person who, once he gets onto a story, he's going to keep going with it?
Your Honor, object is again calling for speculation.
What was the question?
Your Honor, he's the type of person that once he gets on with the story, he's going to keep going with it, not just asking that based off of his experience with him.
Okay, wrap it up. Overruled.
You can answer.
Yeah. Yes, he's like that.
I know you've given us some insight into the way your brother is. And let me just ask it a different way. There's still that question of why would he make something like this up, correct?
Yes.
We know you didn't call right away when that original phone call was made, correct?
Yes.
Is that because you really didn't believe he was telling you the truth?
I object to taking the province of the jury. It's improper calling for speculation.
What was the question again?
I asked him if he didn't call the police because he didn't believe he was telling the truth.
Objective proper.
Okay. Rephrase the question. The objection is overruled. If you still wish to address the question because there's a disagreement as to what the question was asked, you can re-raise your objection.
Okay.
I think you covered the area though, but go ahead.
You didn't call the police right away because you did not believe your brother was telling you the truth, correct?
Yes.
But once you found out that there was someone actually missing, for you, it was, I have to call.
Objection asked and answered.
That is correct, but I'll overrule it.
You can answer.
Okay. Let's repeat the question, please.
My question was, once you found out someone was actually missing, you said, I have to call.
Once I found that a young lady was missing, I needed to be sure before I called.
And was that part of the reason because you said, hey, if there's any possibility that there's some truth to this, I need to at least check it to make sure. Let police know to go and look.
Yes.
In fact, you told police at the very beginning you did not think your brother was telling the truth, correct?
Yes.
You just wanted them to search, see if they could verify what story he told you, if there was any truth to it, right?
Yes.
Once you heard that that search had ended and did not find anybody, once you heard that there was no physical evidence found at Ace Pick-a-Park, did you then start to question or have doubts about calling the police?
Your Honor, I object. They're calling me speculation. It's been improper. The facts not for the jury. She's asking for speculation. What would have happened?
I just need a legal basis.
Improper speculation.
You covered it. Any other legal basis?
Yes, sir.
Any other legal basis? Sustained.
Did you hear that no body was recovered?
Through the media.
Once you found that out, did you begin to have doubts about calling the police?
Counsel, I hold on a second. Counsel, I ruled on the objection. Move on from that line of questioning. Overruled. I sustained the objection.
Okay, no problem, Judge.
Please.
I didn't know if it was because of not laying the foundation. That's why I asked.
I sustained it.
All right, let me fast forward a little bit past that. Before you called police, you said you tried to talk to your brother, correct?
Yes.
And you said when you tried to call him, he wouldn't tell you what you were expecting him to say, which was that this was a made-up story once again.
Right.
And so at that point, you said, I'm going to call police, and you made that decision. You said in your text, I'm firm in my decision.
Yes.
You had decided to call police, and there was really nothing that he could say to change your mind at that point, correct?
At that point, yes.
But when you finally had that conversation, you said, and let me back up just a little bit too, you actually said that when you talked to him those couple of times after, you didn't come at him direct and say, hey, I'm calling the police, I'm going to do this, tell me whether that's the truth or not.
I didn't come at him direct with direct questions, like, give me details about what you did or what you didn't do. I didn't cover that. I just try to give him the benefit of the doubt to say he didn't do this, he was just joking, but he's really concerned about the girl or anything that said that he didn't commit this, he didn't do this.
Understood. And you're the type of person that once your mind is made up, there's no going back.
In this case, yes.
When you told John, your brother, that you had decided to call police, he came clean and told you, I was making it up. It was a story, correct?
Right.
And he said that he thought that you knew him, right?
Yeah, he said that, and he also said, I don't know him.
And by that, did you believe that he meant he would never do anything like that?
I don't know what he meant.
You said that, I believe that after he said that, don't call the police, it's going to ruin my life, that kind of thing, because this wasn't real.
Right.
He's continued to tell you that to this day.
We don't actually discuss the case when we talk.
Let me ask you just a couple of quick questions about your brother. Is he an overly affectionate type of person?
Yeah.
How is he when he sees you?
He's real huggy. He wants to hug me. He wants to, be on my shoulder. And he wants to stay close to me.
All right. Is that typical for him?
Yes.
Is that how he is with most people that he knows?
That he knows, yes.
Is he the type that calls people baby and other pet names, things like that?
Yeah.
Is he pretty typical with the compliments and things like that?
Yeah.
Is he known to kind of give kisses as part of his greetings even?
Yeah.
And all other types of kind of overly affectionate types of behavior?
Yes, yes.
Is it, as far as interpreting his behavior, if somebody were to see that, or if you were to see that, is it easy for you to understand how that may be misinterpreted? And by let me rephrase that question, sorry. Is it something that you find easy to understand why his overly affectionate behavior could be misinterpreted for something more serious than that?
Objection, call for speculation.
Sustained.
He's overly affectionate with most people, correct?
Yes.
To this day, you do not believe your brother is capable of committing these crimes, correct?
Hey, hold on. Members of the jury, can I have you wait in the jury room for about 5 minutes? jury's outside the presence. Mr. Quiller, do you mind waiting outside for a few minutes for us? We'll call you back in. It'll just be a couple. That's fine. I'm still not done yet. All right, so the jury and the witness is now outside our presence. So what are you trying to establish? What he believes? How is that relevant? How is it relevant what he believes? The witness believes. I'm trying to establish facts to argue in closing. How is it relevant when I sustain the objection multiple times what this witness believes, other than trying to input improper character evidence in front of the jury? But that's what that entire cross was about. Oh, shit! How is that proper? I understand to an extent. I get that. But the entire, for a large portion of that cross, putting in front of the jury improper character evidence in front of the jury. That's what that was about. And I sustained the objection. I gave you some wiggle room because the facts of the case are unique given what he said on direct, and it was opened in that regard. But I sustained it, and you kept going back to the same issues of what he believed. Okay, then argue it in closing. What does it matter what he believes? This is not argument. Cross or direct is not meant to be argument. It's meant to establish facts elicited from witnesses that can be argued in closing to the jury. That's not what you asked him. He said why he didn't call police. That was established. No one's disputing that fact. You asking him now. Now what you know, do you believe him? I used the word, do you believe him? Yes, you did. And what relevant do you think the defense is capable of? That's not what you established. That's not what you were going after. Okay, that's not what you were going after. The objection is sustained. It was improper. Are you gonna? You're done asking questions in front of the jury? Okay, I'll sustain it in front of the jury, and then I'll go to the state. We can bring the jury back in, please. Oh, I'm sorry. Hold up. Can you hold Mr. Gray up? Can you bring back the witness real quick, please? I'm sorry. Mr. Quilla, sorry, or Mr. Joseph Quilla, sorry for the interruption. We can bring the jury back in, please.
Oh my God!
Chill.
Members of the jury, welcome back. Sorry for the brief commercial break. You guys may have a seat. The state's objection is sustained. Any additional questions, Ms. Michelle? State, any redirect?
Mr. Quilla, just a couple follow-ups. The counsel just asked you about your brother and then you embellished the story, so you call that line of questioning?
So, I'm sorry, say that again?
All line of questioning counsel brought up about your brother telling you the story.
Yes.
One of those stories I think you cited was that he was telling people he was a bounty hunter,
Yes.
but I think we caught you saying that he actually was an assistant to a bounty hunter. Is that correct?
Assistant to the bounty hunter, yeah.
He actually worked for a bounty hunter at one point.
No, he didn't work for them. He was just assisting a person who does work for the bounty hunter.
Okay. Is it your testimony, sir, that that's embellishing, that he did any work at all for a bounty hunter?
Yeah, he wasn't telling the truth about it.
The other story I think you cited was that he played as if he was on drugs in a rehab center.
For a whole year.
But you started that story, did you not, by saying he was caught smoking weed, right?
Yeah, he was high. Not that he smoked weed. He was caught being high.
Okay, but no matter what we think about marijuana today, back when he was a child, it's an illegal substance, correct?
Yes.
Right? It was a drug.
Yeah, it's a drug.
Nothing further. Thank you.
Mr. Joseph Quilla, good to see you, sir. Have a good rest of your day.
Thank you.
State.
Your Honor's time, the state rest.
Members of the jury, that's going to end our work here today. The state of Florida's rested their case in chief. I will then turn to the defense tomorrow. We'll go from there.
Okay, so we're going to jump right back into the closing arguments. We couldn't miss that testimony from Jonathan Quiles, his brother. He's his brother. He knows him better than anyone. The fact that he embellishes stories, that's sort of on him. That's his problem. But regardless to that, the evidence is overwhelming. The evidence fits this crime. And it took a lot of guts and heart for him to get up there and testify against his brother. I know how everybody feels about snitching, but in this case, it was necessary, or he may have gotten away with it. And they were trying to put it on the other young gentleman that testified, Kumar Humphreys. And you see the defense attorney, she didn't care about putting it on the other Mr. Humphrey. She only cared about, I'm just to put it plainly, defendant lawyers for the defense and prosecutors on the state end, they both want the same common thing. They want to achieve the same common goal, and that is to win the case, to have another case under the belt and under their belt. And that's it, and that's all. In the end, what should matter is Iyana Sawyer, baby Hazel. That's all that matters, in this case. Miss Michelle, as they call her, is disgusting. I understand she is defending her client, but she knows how to turn it on and off. She knows how to turn that nastiness on and off, and I don't respect her at all. That's my thought. Those are my thoughts, my opinion, and yeah, I'm just wondering that if the tables were turned and it was her niece or family member, would she feel differently? Would she approach things differently? And so I'm not going to bring up and read and go through all of the hoopla from what they're saying leading up into closing arguments, but we're just going to watch a little of, before that, and let's see what the judge is talking about here. I think he's possibly reading jury instructions, but let's see what it is. But F attorney Michelle, and where she got her law license, and who gave her the attitude to go ahead and re-victimize victims, because that's what she did in this case. She needs to go and learn she needs to take a class, because I understand you defending your client, but you don't have to go that hard. And especially like I said, I understand you're defending your client, but you got to understand that some of these people are victims, and you can ask questions and get the truth out without being nasty. And I understand you was trying to impeach them, but a lot of victims don't come out and say what happened to them when they got a monster like your client that's threatening them. Don't tell this one that. You heard the text messages, the snaps that Iyana started to save, how he was manipulating her and stuff like that. So, just an extra FU to the attorney Michelle. And I said it. And that's just it. Like, yeah, it's not what we doing here. Like, it's just crazy. I just think that she was her. I just think that her like I'm just glad the judge just ate her ass. I'm glad he did because he saw what was happening, bitch. I told you, don't go down that line of questioning anymore. You already, I gave you one. You want to keep going. You're not controlling this courtroom. I'm the referee. I am. So this is what we're not going to do. And I appreciate him for being, stern like that. He's a stand-up judge in my book. Like I said, he's added to one of the #1 judges that is currently, on my list, how I feel about judges and how I feel trials should be ran. No nonsense. This is what it is. He very much cared about the jury. He very much let them be a part of this case. If you have things to do, we could end it, but if you could stay a little longer and you don't, we want to get through the case, is that okay with you? Just a little bit of hospitality, care, and concern for people's personal lives, understanding the fact that they have children that they need to attend to, or they need to make arrangements for their children and things like that. It's just all types of things like you get from a judge, understanding and realizing that these people do have lives going on of their own, and they do have children, husbands, families that they need to take care of. It's just a lot of judges. He can do a whole class. Y'all know how I feel about Fulton County. He can go on to Fulton County and give them a whole daggone class on how to be a judge, how you could be stern without being like so nasty. And he's not biased. And he's not biased in any way in this case. He's sitting there as the referee, as he has learned to do professionally, and he's not taking a state or the defense's side. If the state says something that he tells them, no, no, that's not how this is going. And the same thing with the defense. And I'm going to bring him back on. Let him continue on with this case. We're going to go right into closing arguments or whatever he's saying before this. But I love this judge. Take my hat off to him, and I thank him for his professionalism, because we have had our fair share of judges being unprofessional in the YSL case. So, other than that, let's go.
Backdating the conception date from the December 13th appointment to July 7th. That's when she was 15. So we know we're not going to be able to argue what dates PBI occurred otherwise. So our position is not to give that lesser, to make the jury have to make findings of dates when we won't even be able to argue other than the July 7th date.
It's a category 2, so defense, are you in agreement with not giving it then?
We are, because it would, in speaking with Mr. Skinner, create some issues.
Okay, that's fine. So what I'm going to do is I'm just going to remove those 2 pages from the jury instructions. What I do need, though, is a new verdict form for count 3. And I'm fine getting that later on this afternoon during a break. That's not an urgent request. But the jury instructions, though, wouldn't be correct because I just removed those 2 pages. Verdict forms for count 1 and 2 remain the same, and actually an amended one for count 3. We'll take care of that at a break, though. Is there anything else we need to take care of prior to the jury coming in first from the state?
Your Honor, may I just check my PowerPoint, make sure those slides are out. And other than that, we're ready.
Anything from the defense perspective?
No, Your Honor.
Okay, and just to be clear, since we're now taking out that lesser, the defendant is in agreement with the lessers for counts 1 and 2, which we talked about, and then not having any lessers for count 3.
Correct.
Okay.
As much as I'd like the lesser for count 3, I think it creates an issue.
Understood.
All good, Your Honor.
But with that, though, your client's in agreement with not having it.
Judge, I actually was speaking with Mr. Skinner. Let me explain to my client why.
Okay.
Judge, we have consulted with our client. He understands because of agreement.
Mr. Queller, can you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? All right,
He
so
lied.
So you were present the entire time we went over the jury instructions and the verdict forms in this case. do you have a full understanding
I
as to
think
what's being read to the jury at this point? Yes. You understand the charges and any lesser included crimes being read to the jury for all 3 counts of the indictment? Okay, are you in agreement with not having any lesser included charges read to the jury for the sexual battery count 3? And then you're in agreement with second-degree murder and manslaughter with a firearm being read to the jury for counts 1 and 2. Okay, and your attorney's been able to answer all your questions in that regard?
Okay, so you know what? I think we watched this earlier because we had to go back to get the brother's testimony. Let me skip past this. He agreed to everything, and his attorneys were great because she's a biatch and all that. So we're going to just skip right on to the closing argument. So we don't want to hear about what he thinks, what he believes. We don't give a got ram about Jonathan Quiles, F him, in the jail that he's housed in now. We don't give it. We don't care. I'm sorry, y'all. Just rant while I, go ahead and speed up the video. We already went. We went through all that.
With that said, State, you have the floor.
Can I please the court?
Yes, ma'am.
Defense? I forget you're carrying our child, and you're oversensitive. I'll kill you and cry. You're stuck with me until you die. Shot her in the head? No. She just went into a bag. Several bags? No, 2. Just folded her. You know, adrenaline of strength of 10 men. She was dead. Her body went into a dumpster. I'm hoping the holiday and the rain will help at that landfill. That houses will be built over her by the time anyone realizes. Ladies and gentlemen of the jury, Mr. Skinner and myself, we appreciate the time and attention that you all have given during the trial portion, which I know we are on day 6. It's been long, and it's been a lot before you all, and you all are going to be tasked with weighing the evidence that's been presented over the past 6 days, the law that Your Honor will instruct you after closing arguments, and I'll touch upon that in some of it during my closing, and then common sense. And that is when we are going to ask you all, and something you heard all the way back just about 10 days ago. Hold on 1 second. Stop. Sometimes you have to get just a little closer. What does everyone have to do unanimously? Again, this was brought up even during jury selection. Did a crime occur? Was the defendant the one who committed the crime? And again, we've talked about the law, the evidence, and using your common sense. Now, of course, that is simplified. And I'm about to go over the material elements, because I know Mr. Skinner had talked about that as well during jury selection, that every crime here in the state of Florida has elements. And that is what the state of Florida has to prove beyond every reasonable doubt, are those elements, not additional elements, but those elements. And also in this case, we have charged 3 crimes. So we're first going to talk about date and venue. I know throughout the trial, you all heard, is that in Duval County, Florida? That is part of the state's requirement to prove that a case occurred here within this jurisdiction. So that is why you all kept hearing, is that in Duval County? That is why. We have 2 different venues. We are stating for counts 1 and 2 that the venue of the murder of Iyana and her unborn child was at Ace Pick-a-Part off of North Main Street. And I have put an image on the screen, which is state 67. Then I'm going to show you some photographs a little bit later on. We believe, and we are going to argue, that the venue then for count 3 involving the sexual battery occurred at a defendant's residence. And I'll talk about that testimony. And that would have been during the time frame, because it's different. So we have December 19th through 20th, 2018 for counts 1 and 2. In count 3, we have a larger range based upon the nature of the case, that chart, specifically the sexual battery. That it occurred on or between, on one or more occasion during December 1st, 2017, and then up through December 20th, 2018. So that is why you all will see the different dates during your jury instructions. So, roadmap. I'm just going to briefly touch upon justifiable excusable homicide, and obviously we don't have attempted homicide in this case, so I apologize for that one. I'm just going to brush through it because it's a standard requirement in your jury instructions, and so I just want to point it out, that's not the case in this one today, ladies and gentlemen. You can look at it, but you can move on. Because I submit to you, there's no evidence before you all to consider that the murder of Iyana and her unborn child was justified or excused. But again, it's part of the norm requirements, that's why I always like to touch upon it. The elements of our crimes charged, lesser included crimes, and then the evidence that the state is going to argue we believe shows the defendant is guilty of these crimes beyond a reasonable doubt. I apologize, it's an issue with the clicker. So again, when thinking about the evidence, what is not beyond a reasonable doubt? Speculative doubt, imaginary doubt, forced doubt, a mere possible doubt. Those are not reasonable. And if those start to occur, you need to wipe that away, because that is not reasonable doubt. So again, I told you all that we would, can you go back just one? One, two, thank you. So again, this is about the introduction where it's talking about the justifiable, the excusable, and again, I'm going to go through this very quickly. I'm not reading this to you. Again, it's just to address. Again, no evidence of justified or excused. You can just go the next couple. All right. So we have 3 crimes charged before you all, and each verdict of each count should not affect the other one, because we have brought before you 3 charges that involve the same set of facts. So each charge needs to be determined by you all independently of the other. And that is the reason why, and Your Honor will instruct you on this as well. Thank you, sir. So what does the state of Florida have to prove in murder in the first degree? So I'm just going to touch upon them, and then later on at the end of my presentation, I'm going to show you how we have done that. And what I've done, since counts 1 and 2 are identical except for element 1, and that involves who is the victim alleged in that element. So element 1 is IS dead? Is her unborn child dead? Was the death of IS and or her unborn child caused by the criminal acts of the defendant? Was there premeditated killing of IS and her unborn child, meaning that there was premeditated killing? Now, so in thinking about killing with premeditation, there is no time requirement in the state of Florida. When Your Honor instructs you, it's not going to say, has to be 10 minutes, has to be 1 month, has to be 1 year. It could be as simple as a snap of a finger. The person has to have the intent to kill at the time of the killing. Again, so I always want to point that out, because sometimes through watching TV, etc., just rely on the law that Your Honor provides. But there is no time requirement in the state of Florida. However, they have to have that intent at the time they kill. And again, this would be some further definitions. So if you all find that the defendant is guilty of count 1 and or 2 as charged, and also lesser included as well, regarding a firearm, you would ask then at that point to make a further finding, meaning during the commission of that first-degree murder, did the defendant actually possess and discharge a firearm, actually possess and discharge a firearm with great bodily harm or death, actually possess a firearm, or did not possess a firearm. So that would be a further finding if you found as charged to murder in the first degree, and you would actually ask to do that as well under murder in the second degree, which is a lesser included crime of first degree. And there's another further finding under manslaughter, but we'll get to that. It's a tad different from the further finding if you get to that point, which we believe you all will under counts 1 and 2. Again, now Your Honor is also going to instruct you. You are, if you believe the state of Florida has proven beyond a reasonable doubt, it is to the highest crime that you all should find the defendant guilty for. So what are some of the lesser includeds here? So it's like a building block. It's like that funnel. You start off with the lowest layer, and then the layer comes up like an opposite triangle. Because when you start out with manslaughter, it's not to the same degree of elements. In fact, it's only 2 elements. It's a different degree of intent. And then you get to second degree. The difference between second-degree murder and first-degree murder is premeditation. So second-degree murder does not require premeditation. So the element is the same as first-degree murder, dead. Criminal act is the same. But again, it comes down to element 3, that's the difference. First-degree murder, premeditation. And then in second-degree murder, it talks about a depraved mind, demonstrating a disregard for human life. So when an individual decides, I'm going to shoot my gun and a crowd of individuals, not intending to kill one specific person, that could be second-degree murder. Because I actually decided I was going to fire that gun. These are some definitions as well that Your Honor instructed you to help you in making your determination. And then like we're talking about that law, manslaughter is only two. Again, element one is the same, that the individual is dead, and then it's intentionally committed an act or acts that cause the death. It does not require premeditation, does not require that depraved mind. And it's a tad different, but it's still involving the firearm. In that instance is whether the person carried, displayed, used, threatened to use a firearm, if you all were to find that lesser included crime of manslaughter. Sexual battery. There are three elements in regards to sexual battery. That defendant engaged in any act that constitutes sexual battery. Sexual battery is the sexual organ of the defendant penetrated or had union with the female genitals of IS. Go back just a second. Thank you. So, in regards to this one, two is easy. And it says IS was 12 years of age or older. December to December 2018, she was the age of 15 and 16 years old. Therefore, state has proven beyond reasonable doubt. There's no dispute about her age. Element 3. Again, I submit there is no dispute about element 3. That the defendant was in a familial relationship with her. He was her uncle. So it comes down to, I submit you all, element 1. Whether you all believe that the state of Florida has proven beyond reasonable doubt the sexual battery, the actual physical act of that penetration. Again, we'll talk about that later. Go ahead. Thank you, sir. So again, the witnesses from the, because you can believe all someone's testimony, some your province of being a finder on this jury. Talks about opportunity and notice. Honest and straightforward with the attorney's questions. I think there's 3 as well. Thank you, Mr. Skinner. Interest in how it should be decided. Does the testimony agree with other witnesses? Was there an inconsistent statement? So, there was a lot of witnesses that came to you all. I've had 6 days to think about what everyone and think about also what they stated. But I just wanted to break down who's actually been before you all the past 6 days. Well, family, Kimberly Mobley, Willie Sawyer, we got dad, we got mom, Juanella Haynes, maternal grandmother, Nancy Ware, paternal grandmother, Meisler, SS, her sister. And then we got aunts, right? Jametta Mobley. And then we know the wife of the defendant and also aunt. We had some friends called. As you all learned, IS had a very close-knit friends, either from elementary school or middle school. Because again, she was only IS a 10th grader at the time that this happened. Work-related, we have, of course, the Ace Pickup. We've got Billy Brown with All-American Garbage at the time. We have Ed Schmalfeld with the Otis Road landfill that we'll talk about. Then we had a series of law enforcement. We had Detective Abbott, lead homicide detective. We had Detective Liller at the time, the lead crime scene detective. Detective Lane, who did the Don Quay and the parsley from IS and SS bedroom, India Avenue. Detective Savage, who did the swabbing of those bottles. That conducted this investigation, and he was the one tasked with putting the wire on. Detective Hamilton, she had gone to 2 different locations. She had gone to Ace Pickup Park to look at that GMC Envoy. She also went to the defendant's to get that 9mm firearm. Detective King came in. He went to Ace Pickup Park. He also went to the landfill as well and told us about that and the alerts that Knox had, and we saw photographs as well. Detective Quintana. The purpose of him, ladies and gentlemen, obviously was very brief when he took the stand, but it was important that we got the state of Florida get this information out that when they get records from a company, and they put these records on these platforms like Cellbrite, Oxygen, that those records are not altered. They're not changed. They are as is at the time data is downloaded. Surveillance.
I don't know.
From school when she went April Day in December 19th, almost 5 years ago. JSO aspect of missing persons investigation on December 20th. Experts are JSO. You heard from Dr. Thomas how she had done a IS. The irony of that, ladies and neighbor who was 20. So happy. Her interior. What a surprise. Put in a year-old and we get back a 30-something-year-old who's your uncle. And another thing. Injury. Of prior sexual activity. And then we heard Lord Biden that are operated in poorly, consistent with over. Dr. Atchu, she was the one that met with 2018. And that's when the bomb was about to explode because there were no more secrets. And not just pregnant, but 5. They heard confessions of those Damon Hatch inmate, George Jackson inmate, and obviously the defendant's brother, Joseph Quiles. We heard from a bunch of different people regarding records. Nicole Phillips with Navy Federal Credit Union, Jack Brown with Chick-fil-A, Anthony Knitsch with Verizon, Ryan Nestor with the public safety analyst supervisor, Barbara Johnson, who was with the owner of Gun Gallery back at that time, Susan Johnson, the T-Mobile records. And then we heard this morning, actually, from a couple of defense witnesses. We heard from Kamar Humphrey. Again, Kamar Humphrey was the neighbor. He had sex with IS when she was 15. State of Florida, someone under the age of 16, not equal to, but under the age, cannot consent with someone over the age of 20, equal to 24 and over. And that's what we have here with Kamar Humphrey. We had a 20-year-old and a 15-year-old, and it was illegal. And Ms. Mobley called. Again, following through and trying to protect her daughter. I submit to you that Mr. Humphrey was afraid during that deposition, thinking it was going in some way make him be criminally liable again. There's been zero evidence put before you all. Zero. I submit to you that that would be speculative, forced, imaginary, or mere possible, which all four are not beyond reasonable doubt. Zero evidence that Kamar Humphrey is involved in this case. And Carol Clipp, a good Samaritan, trying to help. And thankfully we have people like that in our community. But I submit to you all that seeing someone almost at nighttime while you're driving for 5 to 7 seconds, she was just mistaken, but trying to help. Ulysses Dixon, he's a 5-time convicted felon. He's known defendant now for several years, and he has 13 pending charges. And it's just a coincidence. He's charged with human trafficking and sexual battery. So I submit to you all, again, it's up to you all to find if you believe him to be credible or not. Now, physical evidence. We've gone over the witnesses a little bit. We've got the firearm. We've got crime scene photographs. We've got video surveillance from Terry Parker. Cell phone records, either from T-Mobile, Verizon, because we never were able to get IS's phone. As was told to Joseph Quiles, the defendant threw it in a body of water. But we were able to get the defendant's phone and do what's called a cell bump. The Ace pick-apart video, her bank records, Snapchat records, Google location data of the defendant, the Donquay and the parsley pills, the khaki bra that Miss Mobley identified, the pink bra that Miss Mobley and SS identified, the lips panties that was identified, the Terry Parker book. Now, it's true, ladies and gentlemen. We cannot say 100% that that book came from IS because there was no record at Terry Parker who took that out. And no witnesses stated, I know for a fact. But it was a coincidence. Out of all the high schools, middle schools, elementary schools, all of Duval County, it's a book from Terry Parker High School, the same school where IS was last seen. We've got the rain suit. We've got the sexual assault kit, the Amazon purchase records, the defendant's timesheet, the DNA from that sex kit, and then the wire. Now, this is just an image from Stage 25. Sadly, this is the last time at approximately 11 a.m. on 12/19/2018 that she is seen alive. And we know by looking at that, again, if you see something different, ladies and gentlemen, any of these photographs, any of those video surveillance, you rely on what you believe you see, if it's different from what I am stating and arguing to you all. She's on the phone. That call, I submit to you all, is not on her Verizon records. And what did we hear from Mr. Konech? Go to a third-party app and make a call on that app, and it not show up on the Verizon records. And I submit to you all that shows the planning. Don't want to be tracked. Why else use a third-party app when you have a phone? That planning had commenced before she made that phone call, before she left school. The van. This is the van the defendant was driving during this time frame. This is the van that would fit all the kids. This is a Stage 21 composite. This is the van that the defendant was driving the day IS went missing. This is the van that had been used to take them to the beach, etc. And oddly enough, that van gets sold 9 days later, when that's the vehicle that your family uses the most. Now, I agree, and we concede, and we understand. That vehicle was processed. Detective Abbott found it. He got his crime scene detective there. They went there. They processed it, and they found nothing. But again, I submit to you the timing. Talk about coincidences. At some point, those coincidences aren't just coincidences. We talked about the venue in regards to count 3. This is our venue locations on our 16th Street and Trout River Road, where the defendant had lived with his ex-wife, Naomi, during the 2017 and 2018 timeframe. And next, I believe, this is just a screenshot. So I'm going to talk a little bit about the ACE video. You heard that the ACE video is approximately anywhere from 4 to 5 hours off. Do not know exactly if it's 4, 4:15, 4:30, 4:45, or 5. But we believe comfortably that it's between the 4 and 5. So if we see that 12:53:30, that means it's anywhere from 7:53 a.m. to 8:53 a.m. that the defendant is arriving at work on 12/19/18. And what I did, ladies and gentlemen, State of Florida had done during its case in chief part of a merge document to kind of get an understanding. However, within that same exhibit is the actual individual clips that have the time. So as indicated on my PowerPoint is the time associated with this clip, which is 12:53:30. And this clip is a Channel 8 video. So the next thing we know, and if you put one more time, thank you, sir. I'm now playing 15:17:41. So we are now approximately between 10:17 a.m. and 11:17 a.m. And we see the defendant leaving. Even though he had told Detective Abbott, I never left work that day. Even though he put on his timesheet, that indicates I never left that day. And just happens to be during the time frame that IS leaves school. Again, coincidences added up. And two, the reason why I was saying about the 4 to 5, because what we know for sure, this is the correct time on the Google location data, where the defendant, if you'll hit play, sir, thank you. We know that between 11:15 and 11:39, that the defendant is going to that parts store location near the airport. And you also heard from Detective Abbott that he drove these locations. He said it was approximately, depending on traffic, between a 7 and 8 minute drive one way from around Ace Pick Apart to the parts store. And then he had stated as well that it was like a 38-minute trip, round trip from Terry Parker High School to the area of Terry Parker. And then he stated that that parts store to Terry Parker High School was approximately 18 minutes one way. Another thing we heard about this is that when the almost 11:40, it's 11:39 and some milliseconds after that, that GPS goes off. As you remind Nestor, doesn't come back on until 4:04 p.m. the next day again. A coincidence? I submit no. Because you know what else we heard? We heard from Naomi Mobley, defendant's wife. She said, I went back and looked. We always share locations. During that same time frame, he turned it off. Again, coincidence? I submit no. Next one, please. So think about time, just even in reference to what the actual video shows. At 15:17 and some seconds, the defendant leaves. And we only have a video of that 25-minute time frame. Well, the defendant comes back at 16:30. It's gone an hour and 13 minutes. You can hit play. And also, again, make your own observations, but I submit to you the defendant drives back. He drives back in that new area that Ace Pick Apart has acquired, where that was the old concrete factory where there's no video surveillance. We submit to you that is when he takes IS back there. Again, he's gone for an hour and 17 minutes, and that GPS Google data only is for 25. So we have 52 more minutes. Another thing we heard that's important about this time frame, Naomi Mobley stated, the defendant didn't come home. I had to bring him lunch, and he didn't come home. 52 minutes. Again, coincidence? No. Now, did we hit play? Thank you, sir. The defendant then is back in that area where you've heard from the Lindroses. He's not allowed to drive his vehicle back there. I mean, he works back there, but can't drive his vehicle back there. Now we see him finally coming out from that area with no camera surveillance. Go ahead, the next clip. 3 minutes and 39 seconds, approximately, is how long he is back in that area of his vehicle. Go ahead, sir. Now, at 18:46, so again, if we're doing our math, that would be 6 p.m. if we take off the military time, minus the 4, it's around 2:46. If we do the 5, 1:46. So sometime between 1:46 and 2:46, again, the defendant is getting duct tape. Duct tape. Jonathan Lindros was asked, is that something normal for you to have a task to work with? Jonathan Lindros said, no, it's not. And another thing I want to point out to you all, again, if you hear something different, in the wire, defendants asked, were there strings on the bags? The defendant said no. Therefore, submit to you, a way to get those bags to stay shut, since they have no strings, is duct tape. Now, we know that at the end of the day, the defendant leaves at the 22:06:44 second mark that's indicated. So that would either, again, be around the 5 o'clock area or the 6 o'clock area, between those two time frames. We know that he comes back to Ace Pick Apart at 12:44:01. And I know that Mr. Lindros had felt more confident with this date probably being closer to the 5-hour minus time frame. So that would be 7:44 approximately in the morning. Now, another thing I just wanted to point out to you all, again, these coincidences. In the 12:19:18 video, the defendant has braids. Naomi Mobley had stated that he would wear his hair in braids, or he also would wear his hair with no braids. But I submit to you that in 12:19:18, the defendant's wearing braids. However, in 12:20:18, no braids. Coincidence? I submit no. Now, another thing in regards to the video comparisons of 12:19 and 12:20. And again, 12:20, it is raining. Raining a lot. It's pretty heavy. And on this particular day, the only time, and this is also for 12:19, the only time the defendant is seen bring a vehicle from one side where that concrete factory area to the area by the crusher, the area by the container. It's only one time. And that one time, not long before the container arrives. Coincidence? No. That's 18:52. Again, it appears to be an older maroon four-door sedan. Go ahead, the next one, please. And then, at some point, too, during that day, defendant gets another rain suit. Submit to you, that's odd. He has a rain suit on. But again, another thing, coincidence? Submit no. And that was just early in the day, and I apologize, it's a little bit out of tune for timing purposes. Then, if you'll hit play, Mr. Skinner, at 1852-53, and I'm going to show you all. It's hard to see in this video, and it's covered in parts. However, there is a red blurb right under this red car. That is the edge of the container. I just wanted to point that out. And in the 1852-53, we're looking at camera angle 11. And in this angle, I submit to you all, this is then where we see the defendant bringing that sedan to the area of the container and the car crusher. You'll go to the next one, please. Now, about another 8 to 10 minutes later, the defendant is now in his front loader. Again, he's changed out the forks for the bucket. And Jonathan Lindros even kind of stated, I'm not really sure why he's getting the bucket. Well, in thinking about this at the 1902 approximate time frame, the bucket is actually up. It's not facing forward. So I submit to you, there's something inside that bucket. And this happens shortly after the car is taken. The only car taken in that 2-day time frame. Then, in the next clip, approximate same time frame, at 11, I just did a screenshot, there's a video of it, it's taken to the container. And yes, it's the only container on the property, but there's other garbage receptacles closer by. However, this is taken straight to the container. After the container, the bucket, I submit to you all again, you can look at it, is downward. It's not upward. Now, in 1908-34, this is where we submit the All-American garbage has arrived. The defendant is in his front loader, and he goes straight to him. Now, this is after he's brought the car over. This is after he's brought something over in the dumps and in the bucket. And I submit to you again that he is actually not walking, but in a hurry to get to that driver. We can move on. And I submit to you, you'll see him get back in, and then next, he then will take them to the location of where the container is to swap them out. I submit in the first one is a screenshot from 1912-52, where again, if you look closely, you can see the red container coming down at an angle to actually slide off. You can see that in the video. And then the All-American is clearly displayed at the 1921-05 time frame, exiting the property. Camera view 5 at 1921-32. Is it? The All-American container is seen exiting the property. And it's a state submission that that's when IS is exiting the property. Now that time frame, 1921, was when we saw All-American container leaving. 24 minutes later, who do we see leaving? Will you hit play, sir? However, he doesn't go straight out. He goes back. I submit he's going back to make sure got everything taken care of. Nothing left. Hit the net, please. And then what do we learn? We learn he goes to the gun gallery where his ex-wife had identified his signature, and it's on line 10. Now, something else that was kind of interesting about the gun gallery, the GPS, Google location data comes up. But what also did we hear? We heard from his ex-wife, they always go to the gun range. So I submit to you, is it a coincidence that you're putting in GPS when you always go somewhere? Submit to you, what, you know the address? Again, coincidence? No. The defendant talks about going to the gun gallery in The Wire to his brother. Somehow thinking if they can figure out this gun's been shot recently, well then I submit to you, our argument is, well, I went to the gun gallery, I just shot it. You saw my good location data, I went there. Again, coincidence, part of the plan. Timesheet, another not coincidence. That Ace video refutes that timesheet, refutes what he told Detective Abbott back in December of 2018 when he first met him. Refutes. Well, the next question would be, well, why did he then go to a parts store? I submit to you plan B. They find out that I leave. I went to a parts store. Mr. Lindros asked me to go. But then it still doesn't add up. If we still have 50 minutes unaccounted for with no location data that's been taken off. The gun. The defendant says in The Wire, I used the gun at my house. The police haven't even gone and get it. He even says it's a 9mm firearm. Police go to the house, do a search warrant, they get it. So we submit to you this is our murder weapon. Now the landfill, yes, it was a lot. But that's what JSO did. They were 16 grueling days at that landfill. Did they find her remains? No. But what did we hear? What did we see? And just so you know, the picture on the left is from day 1. The picture on the right is from day 16. What was it? Over 5,500 tons JSO went through. But again, needle in a haystack, looking for her. We saw the vultures, indicative of remains. We had the canine out there in Ox, or learning as well. Again, needle in a haystack. We did find some items, again, we talked about the Terry Parker book. We had the pink bra identified, the lip paint is identified, and we also found some paperwork from Ace Pickle Park during that time frame. Snapchat messages. I just want to point out some of those to you all. Again, we submit those messages are from the defendant and IS, and that IS saved those messages. She was the owner of both accounts. Again, because this is a secret. This is an underage relationship with a niece. This is not something that is wanting to be known. In fact, IS lied until the day she died for him. And what did he do in return? He killed her for her loyalty and love. I'm too jealous with you. I couldn't even sleep last night. I need to separate myself from you. Not yet. I need to calm down. I put the dates beside them, August 3rd. You know what? I'm going to give you last piece of dick in the AM and cut all ties with you completely. August 7th, 2018. You, Aunt, and I was getting a divorce, and you and I, once you hit 18, was going to break out. August 7th. I'm not going to have you stay the night anymore. Anyway, so whatever you really did this time, August 7th, 2018, and we know the IS was over there all the time based upon all the testimony. I love you too. We can't risk your future. I promise I'll give you 2 kids. But you need to finish up college so you can be very successful in life. That's August 14th. You just make it all so easy for me to just leave you alone. Goodbye, Iyana. Just like he did between December 19th and December 20th. I think you should take the bus back home from now on. Again, we heard that the defendant would go to that school, pick her up, pick up SS, and then his son when he came. And that's what we heard from Haley Chimper. She had seen the defendant's van there before. And that's what we're hearing right here as well. You seem to have it all figured out. That's August 20th. I don't like nobody hurting you but me. Who do we also hear that the defendant was quite selfish from? Oh, and that text message from the defendant's phone from Joseph Piles about selfishness of his brother. I'm sorry, I forgot. You're carrying our child and you're oversensitive. I do love you very much and don't want you to keep going through this drama, but we have plans, and if you act off your emotions, you will hinder our plans in the future. If that doesn't predicate why we're here today. IS hindered the defendant's plans by not having an abortion. Very hard to see now, but it's the truth from August 22nd. Again, for only purposes for count 1 and 2, motive, intent, plan, opportunity, absent mistake for count 3, and then motive only for count 1 and 2. He also admits to Maya. Now, there's a thing that could potentially, well, when we listen to the wire, the defendant says 100%, I never messed with SS. Well, I submit to you that's because he's not going to admit to that because she's alive. He's admitting to IS because he thinks he's going to get away with it because he thinks that there's no evidence. He even says that they got nothing on me. They don't find that body. So I submit to you that he lied about SS because she's alive. She's still around. IS is not. That was August the 23rd. August 26th, LOL, you will be my best friend once you're pregnant. I'll cook for you until you can't eat no more. Again, what do we hear from Naomi, his ex-wife, about the cooking? More cooperation. Next, please. I've been kicked down there so much, I'm not sure how you're even pregnant. From August 29th. So that's interesting. By the end of August, the defendant already knew she was pregnant. So we know the family doesn't find out till December. August. There's still time for that abortion. Yeah, so I need you to be like 100% with me all times. I'm just so in love with you. I'll kill you. And cry. That's from 3 months before she's killed. You're stuck with me until you die. How pathetic. Because IS was. She was stuck with him until her final days on this earth. I loved you way too much to let you go, so you're not going to have no life. And she doesn't. Now, in going into to highlight a few of the things of the wire, I know it was 2 hours long, that's why I just wanted to point out a few things. She was 16 when she came out that she was pregnant. It was a possibility that was mine, you know. They already was accusing me of it. Yeah, she got shot. There ain't no ballistics. No, it was just that I got. Everything's clean. No, nothing. I went to the gun range the same day. Taurus, a 9mm. It was a roller dumpster. That's all they got over there as far for garbage. 40-yard. And that's what we heard, is a 40-yard container. Next one. If she gave birth to that baby, I've been sitting right here with y'all. Adrenaline give you the strength of 10 men. So the same day she went missing, the same day you dumped her? Well, no, it wasn't. It would be the next day. So where are the F you had? You had her the first day. She was dead, man. She was dead. It's loud over where I work at. And this was, I submit, in reference to the gunshot and the noise. Again, part of the planning, part of the preparation, part of that premeditation. You did say you were in the yard. Yeah, and I submit to you that's in reference to where he shot her. And yes, ladies and gentlemen, is there some discrepancy? Was it in the car? Was it outside the car? Yes, it is, but it doesn't change where he's at ultimately, which is Ace pick apart in a secluded location. Her name was Iyana. A unique name. She was actually scholarship. She was fixing to graduate 2 years early and go to college. You heard from Naomi, she was the one that they thought could be president. You think they'll give you... Oh, I'm sorry, I thought I heard something. You think they'll give you the needle? Well, 1, that premeditated murder. 2, a young adult with an unborn child that was in 5 months. So they can consider it like 2. But the only thing that I might have on my side is due to the accumulation of garbage. He's talking about how, well, selfish me. Thank goodness it's the holiday season, so I can get away with this murder even more. It was a holiday. And then with all the rain that we had within those days. You know what I'm saying? Shot her in the head, no. Heart. Yeah, she was dead. She just went into a bath. You poured some water where the blood was? Yeah, no. It's just, it's dirt. You just scoop it up. I can move it. Scoop it up. Y'all fixing to run away? Yeah. You faking it? Yeah. Boy, you, and the defense says, lime boy. Shit. Again, with that planning, that premeditation, using that authority over her, that manipulation over her, that is clearly seen in those Snapchat messages, the mental abuse that he has over her at juvenile. It's your wife's sister's kid? Yeah. She was my little baby. Yeah, been acting how long? Probably maybe a year, or probably less than a year. My theory behind it is that since I had no connection to anything, she can sit there for a whole effing year And they'll build houses on top of that. That's how the defendant sees his niece. Shit. Now, in regards to the brother, his biological brother, we know that there was 4 calls on December 20 based upon the records. He was nervous, panicky, concerned, something to do. What is he going to do with the young lady? It's going to ruin his family. The young lady is pregnant. It's his wife's niece. The next call is, took care of that. Had her in the vehicle, strangled her, couldn't stomach it, shot her in the chest, what's also in the chest, the heart. Had her in the, discarded her body, and then transported in that dumpster. Next. Destroyed the vehicle she was in. Well, what did we see in the video surveillance? We saw one vehicle, 19th to the 20th, being taken by the defendant through the crusher. Shot her in the car, in the chest. She came there on the premises that they were going to run away together and to be a couple. That manipulation, that love, that loyalty, taking that secret to her grave. How the defendant repaid her. Wrapped her in carpet, used machinery to do it. That front loader, front and center on that video surveillance. Knew the dumpster was going to be picked up, which it was. Would lose his entire family, his baby was born. Because what do we all see about Naomi? All his children look just like him. All. And then went to the shooting range. Planning it for months. She wouldn't have that abortion, I submit to you all. That's one of the reasons why I asked Nicholas Q2, did you do fetal remains? Can you do DNA on paternity? And he said they could. When she wouldn't get that abortion, the defendant was left with the choice of killing her and destroying that evidence. Put her phone in the neighboring water, tried to speak with his brother to see if he changed his story. The brother wouldn't speak to him, so that's when he made the decision to call. Why told? Does not tolerate abusing children and women. So just kind of getting closer to wrapping up, we also heard about the Dante and the parsley, that the defendant had given these to IS and SS, and then Detective Abbott was able to dig into that. He didn't just take the word of Miss Mobley, ISSS, he reached out to Miss Mobley and said, hey, you just check some accounts to see. October of 2017, lo and behold, parsley and Donquay. And lo and behold, what do we hear? Gives you miscarriages. Now, this is just more specifically in how we proved, and again, coming down here to the wire. Element 1, again, element 1 is the same except for which victim. IS is count 1, unborn child is count 2. Dead. So the reason why the family was called, ladies and gentlemen, and that was to show her world was done. Mom, dad, grandparents, aunts, sister. Nobody has heard from her since she left the high school at 11 a.m. on 12/19. Friends. She's a teenager. Teenagers talk to their friends. That's their life, usually, at that time, is their friends. She never returned to school. She never used another bank charge. She never had another phone communication. She never picked up her checks. Over $150, and it's right before Christmas, a teenager? And then the admissions to the brother, the admissions to the wire, admissions to the hash. That is why, ladies and gentlemen, we are submitting, we have proven beyond a reasonable doubt, based upon that evidence and exhibits that corroborate, that IS is not with us. She is dead. And in the defendant's own words, she was dead. Next one. Death was caused by a criminal act. He said he shot her, couldn't stomach it. He was at work, said no cameras. The activities at work regarding the forklift, getting the duct tape, lying about leaving work, turning off the GPS data location between those fateful time frames of 12/19 and 12/20. Cell phone records. His cell dump, he deleted his records from December 2016 through December 20th. Coincidence? No. Container, the landfill, the video from Ace, the timesheet. He didn't go home that day. His actions, because what did Miami also tell us? Before IS went missing on that 12/19, he was fidgety, he was nervous, he was restless, he wasn't getting sleep because he knew she wasn't having abortion. Because think about that short time frame. He's known since August that she's pregnant. Mom finds out December 3rd. Family finds out December 6th. Accusations by aunt comes December 6th. Baby's confirmed December 13th. And then Iyana is killed 6 days later. The pressure was on. she turned her phone off. Brother, wire, hatch, Snapchat messages. We submit this shows that he shot her and what he did with her and why he did it. Now, it might be a question. I'll just go ahead and just address this very quickly. Well, we don't know if he was the father of the child. Well, ladies and gentlemen, it doesn't matter. There's not one element under murder in the first degree that says we have to prove by DNA that the defendant was the father. That's not one of those elements. Because, if we even think about the defendant's own words, it was the chance alone that the defendant killed. The chance alone. So it doesn't matter if that child ultimately was or was not. We submit to it was, but it doesn't matter. That's not one of the elements. And in the defendant's own eyes and own thoughts, his own statements, the chance alone had him commit pre-planned, premeditated murder for his own selfishness so he would not get caught. Next one. And the last one, the premeditation. Again, we've heard planning about a month. We've heard planning months, pressure on the family. Tricked her to come to work. Said he would even kill in Snapchat. The dates, I already told the 3rd, the 6th. Cues, the baby confirmed. Not getting an abortion. The omissions, the Snapchat. Now, in regards to the sexual battery, encourage or entice her to have sex. Well, she's pregnant. Common sense lets you know how a pregnancy occurs. We have the Snapchat messages where he talks about, I've been hit so many times down there, you're carrying our child. You've heard SS state it was the defendant too. You've heard the defendant admit that about the sex and the wire into his brother as well, and to Hatch. The DNA, the hymen, the limited purposes of SS and ID, as well regarding the motive, the grooming. Like he had told ID, she's a new girl on the block. She just came into the picture in 2017. New niece on the block. I've already had 2 nieces. So are you a virgin? Oh, you sure are pretty. Oh, you know how to put a condom on? That's what you need to go further with ID because she didn't allow it. That's the difference. She was older, more mature, different personality, than a 13-year-old. All right, next. And at the time, again, so this was another easy one. We talked about age, her date of birth. We heard from mom and sister that she was, thank you, that she was under the age, it should be 18, I apologize. That should be 18, that's my bad. We rely on from the law from your honor. She was under the age of 18 at the time. Apologize for that error, it's a big error. But again, the limited purposes, again, and I just touched upon this, is the sexual abuse of SS, and ID for count 1 and 2 motive, and count 3, motive, intent, plan, opportunity, absence, mistake, or accident. Okay, next. Now, did a crime occur, and did the defendant commit the crime? I submit to you, ladies and gentlemen, after hearing all this evidence and seeing all the exhibits, yes, the defendant not only committed 1 crime, but 3. And I talked about in opening how there was going to be a lot of different pieces in this case. And after all these pieces were put together, there was going to be a picture. So let's look at those pieces. The DNA from the crotch and the panties. The 3rd confession that was made to Damian Hatch. The 2nd confession that was made in the wire. The sister Samad, because she sadly was there during one of the defendant's sexual abuse acts on her sister. And also saw different various forms of kissing and touching and groping. She's pregnant. Came from having sex. Cell phone records again. Deleted data, turned off locations. Go ahead. Iyana as well, too, turning off her phone. The Snapchat messages. Confirming the relationship, the sex, the nature of the father. Go ahead. The gun. Got that. The donquay and the parsley. Again, not wanting to obviously get an underage niece pregnant. The AIDS video that contradicts the defendant leaving, but corroborates the defendant's omissions. Google location. The defendant leaves, but we still got 52 minutes unaccounted for. And lastly, what started it all, his brother, Joseph Keelius. So, ladies and gentlemen, go to the next one. We're asking you for Iyana and the unborn child, who is going to be named Hazel, to find the defendant guilty of premeditated first-degree murder of IS. She was pregnant with his child, or the chance of being the father of the child. And then also for the unborn child. And we submit to you that the evidence before you is beyond a reasonable doubt, that the sexual battery as well, regarding all the evidence and find him guilty as charged to all 3 counts. Thank you all.
Members of the jury, I told you I'd give you a break at the conclusion of the state's first close. I'll do so. It's 1:31. It's 20 minutes that time.
So, what a powerful closing. I love the way they, humanized Iyana and Baby Hazel. I love the way she put the puzzle pieces together, like to show the jury, after this trial, after all of this, here are the pieces of the puzzle that the state, and depending on the evidence that they do have, although it be circumstantial, very, very strong circumstantial evidence, the 2 confessions, one in his own words with his cellmates, podmates, whatever you want to call them, and then 2, the confession to his brother. So we're not gonna I love the way they did this. The way they put all the pieces together was a way that we all would be able to understand, just in case we were lost in translation while the trial was going on, while all this stuff was being translated, and the defense attorneys trying to raise reasonable doubt, which they have none. So up is going to be the demon, Miss Michelle. In this case, the demon in this case. I don't want to say she's a demon all the time in her regular life, because I did see an interview after this where she kind of like, it was kind of like mellow, and she's just doing her job. As I stated, we understand that you're doing your job and defending your client. It was the way you went about it. It was the way you kind of attacked the victims. It was distasteful. And I just think that you need to take a class, especially when you're going to be defending someone who has multiple victims, and a child that you not only essayed, you impregnated her, and because she wouldn't comply with the fact that you wanted her to terminate this pregnancy, you went ahead and wiped her off the face of the earth. You said it, either she's liquefied or mummified by now, that now that they're just starting to look and putting the pieces together. Disgusting. So he had it all planned out. He just didn't count on his brother calling in, but still the time in which he was given the physics class to the other inmates on the wire. Yeah, that's exactly what happened. All right, so we're going to get into the closing. Michelle is going to be handling the closing, and then we're going to bring to life and shout out to No One for his special channel emoji that I just was working on and just published. So now, in order for us to get a new emoji, I think it says we need 15 more members, but that'll come in due time. Like, it is what it is. But he was up next, and then we completed that. So y'all just drop No One's emojis in the chat. No One, he has his channel emoji, and I think we got Jazzy and Jason Hodges. When we get enough members to go ahead and create new emojis. So we're gonna just go ahead and let's start this closing from the defense. That's all I got to say about that. I just gotta laugh at that one because, she gets on my nerve. But y'all all know that by now.
All right, members of the jury, welcome back. Seat. We're gonna continue. Now it's the defense's turn for a closing argument, and I'll turn to the defense. Ma'am.
Ladies and gentlemen, I always start every closing the same by saying thank you to you. thank you for your time. Thank you for your attention. This has been a long, almost 2 weeks. And so I just want to take a moment to say thank you. I don't get another opportunity to say that to you. So again, thank you very much for listening, for paying attention, for being on time, for just being excellent at wading through all of this. Question everything. Question and weigh the evidence that you have observed over the last 6 days of testimony. Question what you've been shown. Question what you've heard. Question everything. Why should you question everything about this case? When you look and start to make the determination of whether or not Mr. Quilez is guilty of first-degree premeditated murder, 2 counts, and the 3rd count of sexual battery, you have to make the determination of whether what you've been told has happened and the way that it happened, if that makes sense. So question, weigh that evidence. Does it make sense to you? Are there holes? Are there things that just don't add up? Are you left with questions that lead to reasonable doubt? Let me talk to you about the charges. We'll start there. The charges are first-degree premeditated murder. You've heard from the state. They've gone through this with you, so I'm not going to spend a whole lot of time going through each of those. But I want to just point this out. State told you, we told you, this has been said many times, that each and every element of these crimes has to be proven to each of you beyond and to the exclusion of every reasonable doubt. That's a high standard. That burden of proof lies with the state. They have to prove each of these elements to you in order for you to be able to find Mr. Quilez guilty of anything. The state mentioned some lesser included as it relates to the first 2 counts. You have the option of determining a second-degree murder as a lesser included or manslaughter. And Ms. French did a great job of explaining those differences to you. I'm not saying anything different. The difference between first and second degree is that premeditation. And the judge will instruct you on those details in full at the very end once the state has had their chance to rebut. Listen to those instructions. Think that through. Think through the premeditation portion. Think through what second-degree murder might mean for you if you do not find beyond and to the exclusion of every reasonable doubt that there was premeditation in this crime that they have alleged. Count 3 is sexual battery. Again, this has already been gone through, so I'm not going to spend a whole lot of time. But again, you must find that each and every element has been proven beyond and to the exclusion of every reasonable doubt. So what is reasonable doubt? You were told what it's not. So let me tell you what it is. If after carefully considering and comparing and weighing that evidence, questioning what you've heard, if there's not an abiding conviction of guilt, or if you have that conviction, but it's not stable, if it wavers, if it vacillates, if it's not something that you feel is an abiding conviction, that is not a thing that you can find guilty. You must find him not guilty. That would be reasonable doubt. And if you find that there is reasonable doubt, if you are wavering back and forth, if you're not sure, if you're left with those questions that lead to that reasonable doubt in the end, you must find Mr. Quilez not guilty. Now, where can you find reasonable doubt? In what you've heard. The evidence. Conflicts in the evidence. The lack of evidence. I submit to you that all 3 will lead to reasonable doubt in this case. There are conflicts left and right. There are inconsistent statements. There are things that just don't make sense. That is what will lead you to reasonable doubt.
What's inconsistent?
We told you at the very beginning that Mr. Quilez was carrying something with him when he walked into this courtroom that very first day of jury selection. We said then, you must presume, you have to presume that he is innocent. And that has stayed with him through every stage of this trial. He is innocent until it's proven beyond and to the exclusion of every reasonable doubt as to every material allegation in the indictment. And that's counts 1, 2, and 3. If that has not been overcome, he is not guilty. Weighing the evidence. This is what you're tasked with. This is what I started out talking with. This is your duty. This is what you have to do. You have to weigh the evidence. It's you. Mr. Davis told you in his opening, you all are the triers of fact. You all determine who's telling the truth and who's not. Just because the state says it so, doesn't make it so. It's you all. You all get to decide what evidence is reliable, what evidence should be considered by you, what is the best evidence that's come up. And you heard a few of those things that you can consider when you're weighing the evidence. and those questions that you should ask yourself as you think through the evidence. And I'm going to read a few of them. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering our questions? Was the witness honest? Did that witness have some interest in how this case should be decided? You heard from people who had things to benefit from sitting on that stand and talking to you. Weigh that evidence. Determine if it's credible or not. Determine if that's something you can rely upon. Does the witness's testimony agree with other testimony and other evidence in the case? And finally, did the witness at some other point make a statement that's inconsistent with the testimony that was given in court? I would submit to you that several witnesses changed what was said from before to now and in between. Inconsistencies, this case is rife with them. Who did you hear from? I didn't know that Ms. French was going to do this, but I did a very similar slide of who the family is, just so you could get an idea of the players, who came to talk to you, and to refresh your memory, because I know it's been some time since you've heard from, especially from the very first day, of the people that you heard from that day. So let's go through a few of the things that you heard and give you a few reminders. You heard from the family of IS. You heard from Kimberly Mobley. You heard from Willie Sawyer, mother and father of IS. You heard from Jametta, Margie, and Naomi. Those are aunts. You heard from SS, IS's sister, ID, IS's cousin, and you heard from grandmothers, Winella Haynes and Nancy Ware. One's a maternal, one's a paternal grandmother. The paternal grandmother is the one that lived in Georgia. What did you hear from them that sticks out? What did you hear from them that needs to be considered as you weigh the evidence and make your determination? You heard from Naomi Mobley, Mr. Quillez's ex-wife, and that was just yesterday. She told you that December 6th, the family got into a huge argument about Jonathan Quillez being Jose. She told you that she had heard these rumors among the sisters. It's 5 sisters. It's a lot of girls. That comes with talk. Those sisters started those rumors in early 2018 when Kamar Humphrey sexually battered IS. She told you, Naomi Mobley told you, she confronted her nieces. She said, I went to both of them. I didn't just go to one, I went to both. And I went to them away from Mr. Quillez. They spent a lot of time with her. They were close. She asked them, has there been anything inappropriate, anything of a sexual nature, anything whatsoever at all? They both told her, no, never. He would never do anything like that. Mr. Quillez wasn't around when those denials happened. Mr. Quillez didn't influence that in some way. That was a conversation between an aunt and nieces. And what happened after that? After those accusations first came up in early 2018, did IS, SS, and their 2 younger brothers stop going to the Quillez home? No. They continued to go to their house. If those rumors had been around and there was any truth to them, if there was any indication that that was actually happening, those children would not have been at Naomi and Uncle John's house. Naomi Mobley herself said she would have taken her child and left him. Those rumors were put to bed because there was no truth in them. Why? Why would Kimberly Mobley continue to allow her children to go to Mr. Quillez's home if she suspected that there was some sexual activity going on, if this rumor had any truth to it whatsoever? Why would Naomi Mobley stay with Mr. Quillez if there was even a modicum of truth to those allegations? I would submit to you that the answer to both of those is no, she would not have. Those kids would not have continued to go there. Let's talk about the Snapchat. Naomi Mobley told you yesterday she knew Mr. Quillez would communicate from time to time with the children on Snapchat. There was no secret. That wasn't something that was being hidden. If he's on the phone, she says, what are you doing? He said, oh, I'm Snapchatting my niece, Snapchatting so-and-so, or whatever he was doing. He wasn't hiding that from her because there was nothing to hide. What did you hear from SS? She maintained for years after her sister went missing that Mr. Quillez never sent anything on Snapchat that was inappropriate. Just normal conversation. These messages that we saw, we don't know who wrote these messages. We can see that there are messages that are about Mr. Quillez, not from him. We don't know who set that account up, who was using that account regularly, how many people were using that account, who had access to that account. It's a one-sided conversation of some saved messages. The context is not there. It's not complete. You don't know who is on the other end. There are messages contained within there that could be from anyone she was in a relationship with. So who else was she in a relationship with during that time? We've heard from her best friend that she was in love with Kamar Humphrey. She was in love with Jose. That relationship with Kamar went on for months. Her best friend from kindergarten told you that. Jose, she was in a relationship with for quite some time. What did the friends of IS tell you? Alberta Vey, she came and she talked to you all. What did she tell you about Jose, IS's boyfriend? She told you he was Hispanic and black. He was 20 or 21 years old. He lived in Azalea Ridge Apartments, same apartments that Willie Sawyer, IS's dad, lived in at the time. And she had talked to SS the day that IS went missing and told her, hey, maybe tell your mom about Jose. And what did SS say back to her? I don't know what you're talking about. SS didn't know anything about Jose. And what was the last thing that Alberta Vey told you all? She had heard that IS was seen in Azalea Ridge Apartments. What did Willie Sawyer say? Willie Sawyer told you that he heard Jose was there. He let police know. They didn't follow up. They didn't investigate it properly. What did Haley Shempert, the best friend from kindergarten, tell you? She told you about being in love with both Jose and Kamar Humphrey. She also told you Jose wasn't a code name. That was his real name. Alberta told you the same thing. She asked her and said, oh no, Jose is his real name. There were officers who were involved. I'm going to go through a few of those as well. You heard from Detective Porter. Detective Porter went to Mr. Humphrey's job to ask him where he was during the time that IS went missing. He told her that he was in Pennsylvania. They never verified that. They went off of that and they left it there. It wasn't until just a few weeks ago that he provided a bus ticket that shows he was supposed to go to Pennsylvania. But guess what? When I asked him about this, I didn't prompt him. I didn't ask him, oh, were you there from the 18th to the 28th, or were you not there during those days? I said, when did you go out of town? He told me, I was gone from December 21st to the 23rd, and I went there by plane. What aggressive question could possibly cause you to lie like that? Where were you? That's what I asked him. I didn't force him to say that. I didn't badger him. I didn't ask him 10, 12 questions and then get him to trip up and say another date. He volunteered that information. In fact, what he said was, let me check my calendar. He checked his calendar and told us the dates that he was gone was December 21st to the 23rd. Only later, after realizing, oh shoot, let the cat out of the bag, I was in town on the 19th and the 20th, did he go back and produce this bus ticket to show that he wasn't in town. 4.5 years later. The other thing Detective Porter did was try to follow up on some of those leads. Later, once the family finally fesses up to Jose being something that they knew about earlier, Detective Porter asked, hey, why would you not disclose that information to me earlier? Why are you just telling me that now? She asked SS that. Because SS was the only one who could say that Jose could possibly be someone else. She was the only source, the only witness who says that she knows that Jose is Jonathan Quillez. But think what she told Alberta Vey on the day her sister went missing. I don't know anything about Jose. She didn't have that information. She was forced to tell that information. We also heard from Detective King. He's the K-9 who came and testified. And a lot of the evidence from the landfill, Ace pick-apart, that you all have seen is not related to this case. Has absolutely nothing to do with this case. The hits on that blue GMC Envoy at Ace pick-apart that the Detective King talked about, that's not related to this case. What did Gary Lindros tell you? He thought it was weird. Like, why are you all taking this vehicle? Why are you examining a vehicle that just got here a week ago? This vehicle wasn't even here on the dates that you all are questioning. Waste of time. His hits that he said, the picture that you saw of that dog laying down, that was a picture of a training material, getting ready for the day. Not a hit on something random, not a hit on a body. Detective King found nothing at the landfill that could be sufficiently connected to IS via DNA or anything along those lines. The evidence technician, Officer Lillard, they never located a body. They located some items, again, never connected to IS via DNA or anything along those lines. They talk about some underwear. Those underwear that have lips on them that Kimberly Mobley testified, those are IS's. You heard that testimony. Those underwear are a large. IS was a small. She was tiny. She was thin. Never even heard of someone upsizing underwear before. It's absolutely ludicrous. She wasn't pregnant at the time in February of 2018 when these underwear were purchased. You don't upsize underwear. That's not what happened. Those are not her underwear. And the testing done on it shows that there was no evidence, no DNA on that to connect that to IS. Similarly to those two bras that mom says, oh yeah, those look like hers. There's no DNA to connect those to her either. None of those items found in the landfill that they pulled out could be connected to IS in any way. Terry Parker book. You heard from Ed Schmalfeld. I'm going to talk about him a little bit more later. I just want to mention it right now. He told you that items get dumped there from all over. But where did he tell you about the clothing? He told you Goodwill dumps in that same area. He told you that he saw clothing. Officer Lillard didn't want to admit that. Oh, the only clothing we saw were these. But what did Schmalfeld tell you? No, there was clothing. Detective Bidlick. I'm going to go into some of this later, but Detective Bidlick is the one who wired Morris McClendon. He's the one who set things up, told Morris McClendon, we've had several cases together, you know what to do. You know what this is about. And then Detective Abbott. Detective Abbott, on this stand, admitted to you all that without the confessions and the conversations with his brother, there was no evidence, no physical evidence to connect Mr. Quillez to the murder of IS, to an unborn child, or any sexual battery. It was through those confessions, statements to his brother, that led them down that path. And guess what? Once they heard that, there was no further investigation. There was no further looking into anything. They didn't question Mr. Quillez to find out what was going on. Mr. Quillez's brother told them about that confession. He told them. I don't believe him. He told that to police at the very beginning. That wasn't something he just came up with when he came and talked to you all yesterday. He's been saying that from the beginning. You also heard from Dr. Atchu. Dr. Atchu is the one who confirmed IS's pregnancy. And what did she tell you? She said she was looking down. IS was looking down. She couldn't really get a read on her. She made a note about wanting to speak to her next time she came into the office alone and to tell that to the front office at the beginning so Kimberly Mobley, her mom, would not come back. She noticed signs of abuse. And that wasn't just related to her being pregnant at 16. Rachel Thomas. Rachel Thomas told you. IS reported that she was a virgin, and her physical examination was consistent with that. She said, maybe there was something there, I wanted to get a better look at it, not sure. She never got a chance to look back because she did not get a follow-up appointment with her. But based on what she saw, she wrote in her report that what was reported by IS was consistent with her examination. Laura Draga, that was the evidence technician who did ballistics on the gun. No evidence that that gun was used in the commission of this crime. None. Only thing she could tell you was what? The gun works. It was preserved with preservative oils. She never stated that it was cleaned. She said that the oils that were left over looked like the type of oils that you use to preserve a gun. Regular usage. And then Nicholas Kutu. You heard from Nicholas Kutu. The majority of the evidence that you heard from him not related to this case in any way, except for those pill bottles. Those pill bottles came back with whose DNA? Kimberly Mobley's. Those pill bottles were found where? In SS's closet. 4 months after IS went missing. What did Naomi Mobley tell you? I've never seen those at my house. No other DNA is on that besides Kimberly Mobley's. Nothing to connect Mr. Quillez except for what besides what SS said. The credit union. Oh, let me go back. Those underwear from the rape kit with Kamar Humphrey. I want to be clear what he told you all. He could not tell us definitively if it was from 2 donors or 3 donors. He said he put both because he was not sure. If it was from 2 donors, there is no connection to Jonathan Quillez whatsoever. None, assuming 2 donors. The credit union custodian that came in. The card was used several times, and you saw that. Several times after IS is alleged to have been murdered. No longer able to use that account. There was a transfer, an internal transfer done on that account. The other internal transfer said what next to it? Nancy Ware, correct? That is what was put on there. Those transfers were done by Nancy Ware. This internal transfer does not have that information. Who was the other person who had access to that account? IS. There were some charges after that as well. Some games played. Those charges are on IS's own account, and Nancy Ware did not testify to using that account at all. I'll remind you of a few things that you heard from Jonathan and Gary Lindros. John Quillez was a great worker. Went above and beyond, would do what was necessary, saw something that needed to be fixed, he would do it. He's working diligently, never noticed anything out of the ordinary on those dates in question. You heard from about Google location. What were you told by several witnesses? He Googled Fastenal. Fastenal is a place to go buy parts. Detective Abbott told you that. Oh yeah, those places where you go to buy parts, same kind of parts that we used at Ace Pick-A-Part. Jonathan and Gary might not remember asking Mr. Quillez to buy parts. That was a normal part of his job when they needed him to. And he went to Fastenal that day to buy parts. What else did they tell you about this area that was kind of restricted in that area at that time? They told you that where he was going, they did have cars that were for storage. They had a dirt and gravel pile that he would use for work purposes to fill in ruts and fix roads. And they were also fixing a fence back there. You heard Detective Abbott talk about that. There were several reasons to be in that area. After returning from buying parts for the business on company time, Mr. Quillez heads into that area. Completely normal. In fact, Gary Lindros said, it looks like he just parked right outside of the camera's view. They can't tell you whether he went into some secluded area or anything like that based off of that video. All you know is that he goes into that area for a few minutes. And that's supposed to be enough time to do what? Teams of people worked to process vehicles at Ace Pick-A-Part. You see Mr. Quillez picking up a vehicle on the 20th. What did Gary Lindros tell you all? Oh yeah, that's going to go get processed. Team of 2 people come and they do the first part. Take off this, empty the trash. Team of 2 people then go do this. Take it to the crusher, do this, remove the battery. All that process of production that he told you about. That wasn't a vehicle that just gets crushed and nobody takes a look at it. That vehicle was processed just like normal. And why was that the only vehicle that got moved that day? You've been told several times. It was raining. What did Gary Lindros tell you? He said, on that day, if people weren't able to work, they went home early. When did Mr. Quillez leave that day? Around 2:45 p.m. It was hard to work in the rain out there. There wasn't a whole lot that they could do. No problem. Go home today. Using that bucket versus the forklift. When first talking about that, he's like, it's a little strange. Then when asked, okay, well, doesn't he have to fill ruts in the roads? Doesn't he have to fix the road lands? Oh, yeah, okay, yeah, there's dirt and gravel over there. That makes sense. It's a totally normal function of his duties, things that he would do on a regular basis. I encourage you all to look at those videos. You'll see Mr. Quillez walking around, talking, doing his job, going in and out of the office, getting things for people, doing his job as he normally would. Look at him and see if you can tell his demeanor. If he looks like he's suspicious, as if there's something going on. I would submit to you when you look at that, looks like he's working. I talked to you about Ed Schmalfeld a few seconds ago. Clothing items. Clothing items from Goodwill are dumped at that landfill. What else did he tell you about that search? That 16-day search at the landfill? He told you they went through 5,500 tons of garbage. He told you the dimensions, and I can't remember them. He told you the dimensions, 20 feet deep, 3 to 4 acres wide, if I'm not mistaken. He told you he overestimated to make sure that that dumpster that they were concerned about was included in that search. I asked him, would that 5,500 tons of garbage, would that have met your overestimation to include that? He told you yes. Yes, he believes so. They searched. They did not find anything. Billy Brown. Important information from Billy Brown. They only dump at the Otis Road landfill. They don't dump anywhere else. When you're listening to that wire and you're wondering, is what he's saying truthful? He's talking about Trail Ridge landfill. That's not even a landfill that American garbage dumps at. He claims that someone told him that from American Garbage. I would submit to you that he's making that up. The other witnesses you heard from. Damian Hatch. Damian Hatch claims that in 2022, February, let me be specific, he arrived in the same dorm as Mr. Quillez on February 11, 2022. Started going to a Bible study that Brother D, Ulysses Dixon, runs. Started going to that Bible study on a daily basis. But you know who wasn't going to that Bible study? Mr. Quillez. You know what Damian Hatch told you all? They were going to that Bible study every day together. What did Ulysses Dixon tell you today? That's a lie. They're lying. Damian Hatch is lying. Mr. Quillez and Damian Hatch, Dino, as he's called, never attended Bible study together. Mr. Quillez didn't even go to that Bible study until the end of 2022, maybe the beginning of 2023. And how did Ulysses Dixon know that? Instead of even trying to get him to come. Really good guy, doing trustee work, helping out people, but he wouldn't go to church. Ulysses didn't get anything for coming here and testifying. He even told you he was actually worried that's going to hurt him. But he came here to tell you all the truth. Tell you all that was a lie, what you heard from Damian Hatch. George Jackson. George Jackson told you all that he was not in control of the wire device. You heard at the beginning of that wire, it jumps. It jumps a couple of times in the beginning. You don't know when it's being turned on. You don't know when it's being turned off. You don't know when it's being restarted again. Mr. Quillez, you heard this from George Jackson, was left alone with Morris McClendon. Morris McClendon, who is an expert at doing these things. He knows how to do what he needs done. He knows how to get information in the way that he needs to, by whatever means necessary. George Jackson wasn't in there when Mr. Quillez and Morris McClendon were having a conversation. But what do you hear at the beginning of that wire? There's razors on the floor. Talk about a razor again. It wouldn't take much to threaten someone, to get them to say what you need them to say. Think about what you heard. Every answer is prompted. It's led. They're feeding information. They're telling him, signaling to him, what needs to be said. What did Mr. Quilles's brother tell you? He makes up stories. He's known for it. He is known for coming up with elaborate, wild stories. Joseph Quilles told you, in the family it's a known thing. He did it when he was younger. He was caught supposedly high. Instead of telling his mom, oh hey, just tried it out, he said, I'm a full-blown drug addict. He was sent to a drug rehab program for a year and kept up with that. He was never a drug addict. What did Joseph Quilles tell you? He said he was the only person in that drug rehab program who tested negative for drugs the entire time. He never had drugs in the system. But that's what he knows of his brother. He knows him to run on with these stories and go on even to his own detriment. He told you, if you ask him a question, he's going to give you an answer because he can't help himself. When he gets into character, he commits. He's going to perform for you. He's going to give you that story. He's going to keep it going. That's what Joseph Quilles told you. Carol Ann Clip. Why do we call Carol Ann Clip? You've already heard some evidence that activity was going on IS's accounts after the date the state alleges she was murdered. But not only that, she was seen. Carol Ann Clip saw her the day after Christmas. She saw her walking. Carol Ann Clip has nothing to gain by coming here. She didn't want to come here. But why? She told you why. She said she called because she believed in her heart and mind that that was IS. And that was the right thing to do. Same reason she came and testified here today. Kamar Humphrey. I've already talked to you about him. But he lied. He admitted he lied about his whereabouts. Just about a month ago, not even a month ago, he denied even having sexual contact with IS. Why? You've already been charged and pled to a felony battery, so why would you lie? Why would you try to distance yourself from that? Because you got asked? You didn't want to be asked what happened? Again, nobody forced him to say the information that he said. What else is he lying about? Kamar Humphrey and IS communicated via Snapchat. He told you that. Now, of course, he wants to make it seem like they didn't communicate for that long. He's not dumb. He's not going to sit here and say, oh, yeah, I was in communication with her for months and months and months. Oh, yeah, we had a sexual relationship for months on end. But guess what? IS told her best friend that that was the case. They had been in communication for months. They were in a relationship for months. IS was in love with him. Jose. Who is Jose? Hispanic and black male, or mixed, 20 or 21, living in Azalea Ridge Apartments. Willie Sawyer told you all that Jose was in these apartments. The state talked to you about puzzle. They said each of these pieces, and they gave you a little graphic, each of these pieces is going to add up. When you look at all the evidence, you weigh the evidence back and forth, are those puzzle pieces really all there? Or are there things missing? Are there puzzle pieces from another type of puzzle that don't fit? Are you forcing those puzzle pieces in? Or does it truly make sense? Because let me ask you, IS is murdered at Ace Pick Apart, December 20th or December 19th. There's zero evidence of a crime occurring at Ace Pick Apart. No blood, no DNA, no cameras catching this happening. She's supposed to have supposedly been there overnight. According to Joseph Quilles and the supposed confession, he tried to strangle her and then left her there. Does that make sense? She just sat there waiting on him to come back? So much of the story doesn't make sense. Where is the physical evidence of this crime occurring at Ace Pick Apart? How could someone be shot in the chest, bleed, and there be no evidence whatsoever? He said to his brother he did it in the yard, or that comes out on a wire. The yard is where everybody works, not some secluded area off to the side. How How could you do this in the middle of the day where everybody's working and no one noticed anything? There are people working in teams all over that place. You heard Gary Lindros tell you. There are people working in different stations, spread out around. You'll see the video, review those videos. You'll see people coming in and out all over the place. It's a busy place. I think he said that they see 300 plus people a day. On the weekends, it's more. That many people going in and out and all over the place, and no one notices anything? There's no physical evidence whatsoever? You heard on the wire that she was put in a bag. You heard Joseph Quilles tell you, oh, she was in a carpet. Can't have it both ways. We're just making up details now. So much of it does not add up. You'll see video of Mr. Quilles driving the forklift with a bucket without a bucket. You can see into the bucket. You can see on those camera angles. Look at that video. It doesn't make sense the way it's been told to you. Question that evidence. See if it does make sense to you. Let me talk to you a little bit about SS and her testimony. SS's testimony is rife with inconsistencies. She's changed dates. She's changed what's happened, how it happened, when it happened, how many times it's happened. She went from saying there was nothing at all that ever happened to describing in her own sexual abuse story of several occasions. But originally, what did she say? She said nothing happened at all. I don't know anything about Jose. She was asked these questions on December 19th and December 20th. She was asked several times by police, hey, tell us about that conversation that you had with your sister at the picnic table. Tell us what happened. She kept saying it was nothing. So many inconsistencies in her statements to you all. So many things that now she can't recall. I don't recall. I don't recall. I don't recall. You don't recall the things that you don't want to admit. SS is the only person who has said there was some code name for Jonathan Quilles. And what did she tell you about those code names? She actually added one. She said, oh yeah, he was also known as Eugene. SS's testimony is contradicted again and again and again by her own words. Why? If your sister is missing, would you not tell police everything you know? Everything you possibly know. Same thing goes for the family, because according to Naomi Mobley, December 6th, they were saying Jose was Jonathan Quilles. That didn't even come out to police until December 27th. Why would you wait 2 weeks after your sister is missing to say that type of information? She was protecting her? That's her excuse? That's her reasoning? She wasn't telling the truth. She had been told to say what she said. SS says she was told her sister was going to stay with her grandma, and that's why she didn't say anything. She knew immediately. She learned almost immediately that IS was not at her grandma's house. Her grandma, Nancy Ware, was informed. And yet, she still didn't think to say anything. But oh yeah, by the way, I'm being sexually abused, and I've overheard my sister, and I know that Jose is Jonathan Quilles, but I'm not going to tell anybody that information, because that's protecting my sister. What other information did she withhold? She waited 4 months to talk to police about alleged sexual abuse. She waited 4.5 years to ever mention that she, on one occasion, was laying on a couch and overheard Jonathan Quilles and her sister having sex. 4.5 years. That never came up. She actually never even reported that to police. That was something that was said in a deposition. When they couldn't find IS, sister group is circling those allegations and accusations. They turned to SS. You're malleable. Go along with this narrative. This fits it. Now all of a sudden, this family is, oh yeah, we knew. Oh yeah, we saw the signs. But nobody reported anything for weeks? I saw this terribly inappropriate hug. I didn't like the way he looked at her. But you all did nothing? The hard part with SS is so much to keep track of, so many things to keep straight, so many stories to try and line up. It's hard to keep track of all of that. Inevitably, you get caught up. Let's talk about those pills that were found 4 months later as well. 4 months after IS goes missing, Don Quay and parsley pills are found inside Kimberly Mobley's house, inside SS's closet. Naomi Mobley testified that her Amazon account was used. But what else did she tell you? She said, I had Amazon on my phone and on my laptop. This was in October of 2017. Mr. Quillez's femur was broken. He was recovering. IS and SS and their siblings would come over to the house. They'd help out. They had access to their Aunt Naomi's laptop. She said that they would use it often, play games. She claims no one had her password to her Amazon account. The Amazon account is up on your computer, and it's not signed out. You can have access to it. And we know that they used her laptop. Her credit card is saved to her Amazon account. All you need is for that Amazon account to have not been signed out, and anyone could purchase whatever they wanted on that. And don't forget whose DNA was found on those pills. Think of all the physical evidence that's been listed out to you. It's not connected to Mr. Quillez. There's no DNA that comes back to him. No DNA that comes back to IS. Let me talk to you about the red van. The red van was a family car. No one's denying that Mr. Quillez drove that car or anything along those lines. But what did Naomi Mobley tell you? She said, I told him to get rid of these cars. Our house is looking like a parking lot. So what car is he going to get rid of? A broken down
He
vehicle?
should have got rid of the
Mr. Rego
truck.
that he's put a ton of money into, and what Naomi Mobley described as his baby car? Or the vehicle that she said, don't sell my car. There's only one vehicle left to sell. Nothing nefarious about that.
No, you're leaving out the Intrepid. You're leaving out the Intrepid. You're leaving out the Intrepid, bitch.
The video surveillance. The video surveillance from the dates that IS is alleged to have been murdered are so critical. The area that the state alleges Mr. Quillez took IS is right in an area near a fence that's opened. A fence that's opened and you can see from the office. Gary Lindros told you, oh yeah, you can see right into that area from the office windows where I sit. Not only are there people working there, not only are there people fixing a fence, but it can even be seen, that area can be seen from the office. And this horrific murder is supposed to have happened right under their nose? A person's transported in there and kept there overnight and nobody notices? What did he tell you? He said that's not even likely. Highly, highly unlikely for that to have happened. Not that anything isn't possible, but I'm just asking you what's probable. Police didn't investigate this fully. They set their sights on Mr. Quillez. He was their target. All the tips and leads and other possible routes they could have gone, they left hanging. They failed to properly investigate. They failed to follow up and check to make sure. The state gave you a list of things that they believe prove premeditated murder. But I would submit to you that those very same things are contradicted left and right. Mr. Quillis's own words contradict himself, especially for somebody who makes up stories and elaborate and goes on and on with it, especially if he's been threatened to provide information about something he didn't do on a wire so that Morris McClendon can make a case. They claim that cameras, his activity at work, is going to prove something. I submit to you it doesn't prove anything. The fact that he left work, he had a legitimate reason for leaving work. And if he's on company time, it's no surprise he didn't clock out. I asked him if he went to go buy parts, would he have clocked out? He said no, he'd still be on the clock.
He didn't go and buy parts, though. That's the damn thing. He went to lunch and didn't punch out, bitch. She get on my nerve, y'all. I'm sorry. Woo.
As you all are weighing the evidence, questioning it, I ask that you would hold the state to their burden. That burden that we've talked about so many times over the last couple of weeks. Each and every element of the crimes charged must be proven beyond and to the exclusion of every reasonable doubt. I've gone through with you tons of reasonable doubt, tons of questions, things that don't add up, things that don't make sense, that leave you plenty of reasonable doubt that Mr. Quillis committed the crimes that he's been charged with. Talked about that puzzle. How many of those pieces have reasonable doubts to them? Because each piece of that puzzle that they showed you should be proven beyond and to the exclusion of every reasonable doubt.
Sit down, Michelle.
All the elements, all of the pieces, they have to fit together. And I would submit to you that when you look through, you weigh the evidence, you're going to find those doubts. As you come back to that, if you're left with that question, if you're not certain, if you don't have that abiding conviction of guilt, that is reasonable doubt. You all have options here. You have options for the first and second counts.
Excuse me.
There are lesser included. So if you believe, even after looking at all of the reasonable doubt that's been presented to you over the last 6 days of testimony, Mr. Quillis committed this murder, look to his words then. He talked about it being a spur-of-the-moment thing on the wire, not something planned out. That's the difference between first-degree murder and second-degree, that premeditated portion. There are lesser included options for you all, if you get there. But I would submit to each of you that when you weigh the evidence, when you go through, when you question what has been presented to you, and you determine what's reliable and what is not, I submit to you that you will find Jonathan Quillis not guilty. Thank you.
He's guilty.
Members of the jury, feel free to stand and stretch if you would like before the state gives their rebuttal.
Child, that guy, let me tell y'all something. Excuse me, but that daggone damn Michelle, she is a piece of freaking work. If she has daughters, she should go send them to live with Jonathan for a year or two and not let them say anything to her. I don't like the fact that she, and within her closing statement, lied. She misstated a lot of the evidence, a lot of what was said, victimizing the victims. Then you're gonna throw a shot in there at Iyana's mother, like, oh yeah, let's remember whose prints was on the Don Quay. Of course, her prints was on the Don Quay because she searched her daughter's room. She was trying to figure out where her daughter was from day one. So I thought it was quite disingenuous of Michelle to get up there and do that closing statement, repeat things that were lies that she knows are lies. And I can't wait for the state's rebuttal so that they can get, clear up all of that bullshit she just got up there and said.
Why the fuck you lying? Why you always lying?
Yeah, that part. Why are you lying, Michelle? I don't like that. I didn't think that it was, right at all. Like I said, I understand she has a job to do, but she went too god on far. And that's all I'm gonna say about that. And we're gonna get through this next part because here comes the defense with their rebuttal closing. But I just didn't like that about her. I just did not like that about her. Anybody that has ever dealt with victims, especially victims that are threatened, victims that are told to do X, Y, and Z, he would lay in the bed next to his young daughter, who was what, 3 or 4, in SA. One of them, I forgot which one it is, so I'm not gonna, put out any falsehoods right there. Was one of them, either Iyana or Samaya, and your daughter is laying right there. Naomi needs to take her daughter to be checked. And the fact that these weren't the only two that he had relations with them too, but you see, he attempted to have relations with the young lady that's now a correction officer, and it just didn't happen. And she told her father, I don't like the way he looks at me. He's sending me these, he's sending me these weird messages. I don't like them. They make me feel uncomfortable. You're going to tell that girl to come to your house so you can show her how to put a condom on? And because he's supposed to be the old loving Uncle John, she has a father in her life. So why does she need you to talk to her about safe sex? Whether or not she's a virgin or not. These are all conversation that he should not have been having with anybody in that family. But you mad at Iyana because you think, you don't even have any proof. You think she has an attraction to your son. You think her and your son did anything. You kept accusing her of this stuff over and over and over again. That is crazy work. You're jealous of your son without proof. So Miss Michelle, like whatever the hell her name is, I don't know what her last name is. I didn't go to try to look it up. I didn't like her when the trial was going on. I still don't like her now. She has a lot of nerve. Defend your client, but you don't get to defend your client by dragging victims through the mud. This is why people don't talk. This is why victims don't tell. This is why they don't speak up. Yeah. All right, just calm down. Let me woosah. Breathe in, breathe out. Okay. All right. I'm over that. I'm over her already. We know that was a lie. You know they lying. We don't know who wrote those messages. Who is married to her aunt that's getting a divorce then? Fuck out of here. Oh, they told them to say that.
Say whenever you're ready.
Thank you, Your Honor. May I please report?
Yes, sir, of course.
Counsel. Ladies and gentlemen. Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence. In 1770, the second president of the United States, who was a lawyer at the time, said those words, John Adams. He stood in a courthouse not like this one, not with air conditioning, not with our comfortable seats, and stood up for hours in front of a jury of people. And he said that. One of our greatest founding fathers, who helped wrestle with and create our founding documents, as this court so eloquently said, right after we picked the jury, to this day, we're still adhering to that great document called the Constitution, written in 1787. Facts are stubborn things. Here's a fact. The defendant confessed 3 times to killing Iyana. That's a fact. And what's even a more important fact to note is the similarities between those statements of gentlemen that do not know each other. Joseph, who lives in New York, gave consistent facts about what happened. They go point out one. Oh, she's wrapped in carpet versus she's put in bags. All say she shot. All say she shot at Ace. All say he summoned her there somehow. All say she's pregnant. All say he wanted that baby dead. The consistency of those 3 consistent confessions should make me sit down right now and give you this case. And stop insulting your intelligence. Because those 3 facts, to match like they did, of 3 gentlemen that do not know each other, have never discussed anything before. One's in jail. These other 2 guys, Maurice and George Jackson, on a wire. And some man in New York who's the defendant's brother never confers. Ever. Those 3 confessions mesh. That's a fact. And it's stubborn. And it's hard to argue around, but you just heard it. Counsel gets up here and says, well, there's holes in the state's case. The only holes came from this man right here. Those hands right there. He scooped up dirt, or covered up dirt, wrapped her up. Whether it's a carpet or whether it's 2 bags, doesn't matter. We don't have to prove that. He told all 3 of them he put her in a dumpster at work. And they just happened to get that right. It just happenstance. Don't let the defendant get away with holes that he created. He tried to get rid of the body. He tried to get rid of the blood. He tried to go shoot his gun, make it look like he shot her recently. You know, he couldn't kill her anywhere else. You know why? Because his wife and him share their location. If he goes running off way out on the west side or out to Bayard or out to wherever and dumps her somewhere, she said, we share our data. And guess when his is off? Guess when his cell phone is off? Guess when he leaves work? Guess when this happens? Guess when he lures her from Terry Parker? It lines up with the cell phone data. It lines up with her data. She has no communication whatsoever. She leaves Terry Parker at 11:05 a.m. Guess when he leaves his work? 11:15. They could come up here and argue, well, he ran an errand at work. That's a 25-minute ride. Where are the other extra 53 minutes? That's why we had Detective Abbott testify to that, to show he most certainly had time to go meet with her. But the defendant, he made a grave mistake. Even though he tried to clean up, even though he tried to get rid of evidence, even though he tried to get rid of the body, even though the Dong Hui is on his wife's account. By the way, it doesn't, listen, if the girls got on the mother's account, which they did not, there's no evidence of that. Okay? If those girls got onto that account, where did they get that idea? The Snapchat alone tells you there's a lot of sex going on between the defendant and IS under everybody's nose. But he's the one sneaking around doing that with IS. It's a horrible secret to put on a 14 and 15-year-old child. It's despicable. Mm-hmm. Despite that, despite all the Snapchat messages that he chooses to communicate with them on, that automatically deletes. But he doesn't talk to his wife that way. He talks to the nieces that way, both IS and SS. And oh yeah, now he's taking a run at another niece, ID. Guess how he spoke to her? Snapchat. He knows how to delete evidence. But he made a grave mistake. He ran his mouth. He told his brother. Facts are stubborn things. And that brother sat here yesterday, and he, the defendant, put him in a horrible position, just like he did with SS and IS. But you could say all day long, as counsel just tried, well, he didn't really believe him. He picked that phone up and called the police. He said, and I'm sure you heard it from that witness stand, when when I'm around him, he's confident. He's himself. And on this call, he's frantic. Why? Well, then out comes what he tells them. I got this girl. She's pregnant. She's got knees. I don't know what to do. I tried to strangle her. I can't stomach it. She's back in the car. By the way, they ask the defense, that doesn't make any sense. It doesn't? Newsflash, folks. When you strangle somebody, they can pass out. You strangle a little girl, that man, he can pass out in a car. And he calls his brother back on the same day. I took care of it. Those are chilling words. He calls his blood brother and says, I took care of it. After just telling him, she cannot have this baby. That alone convicts him. That fact is so stubborn. When you add that the second confession, the wire comes along and matches it almost perfectly. Almost perfectly. You're having sex with your niece? Remember that one? Well, yeah, what about your wife? Well, yeah, she's pregnant, and the doctor says she's high risk, so we can't have sex anymore. We even know why he's having sex with SS and IS. We know why. He got her pregnant. It's all over the wire. Your ears got to... Listen, we apologize for the language and the things that you had to hear. Your ears heard some chilling words about right out of his mouth describing how he killed that little girl. And talk of the facts, almost like everything that you see here, they talked about. Landfill. She's pregnant. Listen, DNA in the underwear. Facts are stubborn things. We don't even have to prove motive, ladies and gentlemen, but we sure did. He could not let that baby be born. And he was determined to make sure that Hazel did it. As he said on the wire, I think it's a girl or something. That little girl's a human being. She had a name. And he killed her. Now, we're talking about puzzles a lot. My boys were little. We bought an alphabet train. The alphabet train was something you came really two ways. You have a puzzle, but they also had little cars that connected together. And little wheels on them. But they were these little shapes. They were like about that big. And they were in the shape of the letter. And you would connect them to learn your alphabet. You'd line it up on the floor. My boys did. That's how you taught them the alphabet. But each one of these had shapes on them. They had the shape of themselves, whether it was an A or a B or an H. What we just did for you is lay out all those alphabet pieces. We're asking you to put them together. What Ms. Michelle just did is she took an individual letter and said, well, I'm going to take this I out, and I'm going to hold it up and say, well, couldn't it be a 1? Or I'm going to take the W out, and I'm going to turn it over, flip it over, show it to you, go, well, it could also be an M. Isn't that possible? How many times did you hear that question from counsel on cross-examination of all the state witnesses? Well, isn't it possible that? Isn't it possible this? Isn't it possible that? Isn't it possible? Isn't it possible? Isn't it possible? Do you know what reasonable doubt is? It is not a possible or speculative doubt. Then why ask those questions?
Get out.
The counsel comes up and says, well, there's no DNA that connects the defendant to this. Did she just say that to you? Are you kidding? What in the world is his DNA doing on the inside of these? I don't care if that's spit, saliva, semen, touch DNA. It has no business being on the most intimate, private areas of a 15-year-old little girl's underwear in March of 2018. This alone tells you what's going on. We spent, I don't know how much time asking whether this particular DNA was, well, do you know whether it's sperm? And he said, the expert said, well, it's a sperm cell fraction. I don't care what it is. What he was certain about was that it was the defendant's DNA on the interior. You hear what he said? A yellowish stain? Now, come on. It wasn't enough. Tell us whether it was a sperm cell or a blood cell or a saliva cell. That does not matter. That's trying to create possible doubt. And that is not reasonable doubt. And Nicholas Cotu, he explained it. He says, listen, he goes, it's just not enough to call one way or the other. And he spent all this time on it. And he says, listen, it was a sperm cell fraction. That's what he said. But setting all that aside, what the defense just did with that DNA is they held it up and go, well, it's not really a Z in the alphabet. If you pick it up, pull it out, turn it on its side, it's now an N. That's not what your job is. Your job is to take all of this evidence, put it together, and render a true and just verdict. Ladies and gentlemen, that evidence right there is the most inculpatory piece of evidence that exists on the face of the earth. And it existed in a place, the last place a 33-year-old man's DNA should be, is in a 15-year-old girl's underwear.
Yep.
And then they bring up, well, these Snapchat. Counsel says, well, it's only half the the way the records come in. We got half the conversation. Listen, you can read it 100 times, and there's no other conclusion. We were asked, and we made it clear, please use your common sense. You can't read those Snapchat messages and draw any other conclusion rather than it was between this defendant right there. Yes. No other way to read it. He names her. He uses the sister's nickname. He uses your aunt. He uses, one time about the whole kiss goodnight. Oh, well, kiss you goodnight. I'm in your house. It's clear. If that's not who this is, then this defendant and IS have an exact similar scenario going on at some other house somewhere else, and there's some other girl named Maya, Iyana. Folks, that makes no sense. None. And then counsel makes a big deal about, well, Naomi asked him, hey, what are you doing? I'm on Snapchat. She says, well, it's no secret. Well, you know what she didn't do? She didn't go over there and say, listen, husband, I'm going to go get your phone and make sure that's what you're doing. She didn't do that. Ever. Then they argue, well, there's no body, there's no blood, and all the... Listen, we established she does not exist on the face of the earth, and we know it took a long time. And we greatly, greatly appreciate your patience. You all have been, as the court said repeatedly, your attention has been unbelievable. Your promptness, your attentiveness. But let me make this perfectly clear. We had to do that. In homicide cases, usually body laying there. Okay? This is a homicide case. We had to establish the body doesn't exist. And we did that. Not one shred of existence. Counsel can get up here all she wants. Says, well, there's more charges on that account. Go look at them. Did you remember what he said in the opening statement? Well, she went to Wendy's that day. She went to Wendy's that day. Mr. Davis sat right here and said to you an opening statement. Remember what lawyers say. That's not evidence. When I had the custodian on the stand, tell me about that Wendy's trip. Oh, no, that wasn't December 19th. Look in the body of the transaction. It's December 13th. It was posted on the 19th. Why are they up here saying that to you? Reasonable doubt is not
lying.
Then why say it? They got the same records we do. Why come in here and ask questions about this Wendy's? Oh, no, that wasn't on the 19th. She made that perfectly clear.
Mm-hmm.
Then they make, well, there's no blood. We talked about that. He got rid of that. There's no murder weapon. Yes, there is. Yes, there most certainly is. Why? Number one, because he said so not once, not twice, but 3 times he said so. He's my gun. He even talks about it extensively on the wire. Yeah, the police haven't even gone and got it yet. They start laughing about it. Are you kidding? This girl is thrown to trash, and he's laughing about the police haven't even gone and got the gun yet. Counsel in the opening statement, they just argued it again. Oh, the state's assuming this happened at Ace. The state's trying to make this into their crime scene. The state's not doing any such of a thing. The state pressed play on a wire. And that's what he said. That's what their client said. He said it to Joseph. He said it to Damian Hatch. Are you kidding? Is the state just sitting over here, we're just dreaming stuff up? He said it. And they have, the state's assuming Ace is the scene. Really? I killed her at work over off in a remote area over there. They're in bags. Put her in the trash. But they take this video and they say, oh, well, you know, we're taking the B out of the alphabet. We're holding it up from afar. It kind of looks like an 8. Right? That's what they're doing. That's what she did in her whole closing argument to you. Pulling pieces of evidence out and isolating and holding them up to you and say, well, this isn't really a number 1. It's not really a letter I, it's a number 1. Are you kidding? 3 different times, I killed her at work. And they're telling you, they're assuming where he killed her was an Ace. Use your common sense. Now they bring up this red minivan and they say, well, there's no evidence in it. You know, the state, what else is he supposed to sell? All his wife asked, Naomi Mobley said at the time, I said, we got too many cars in the driveway. You pick which one. And he sells the one that you see he goes to work in every day. He sells that one. And I got news. You can sell a broken down car. What do you think Ace Pickup Art is? What do you think car lots are? What do you think junkyards are? You can sell that other Dodge. He picks the one that was reused in getting that girl Ace Pickup Art. Shortly, she said, she told him that like mid-December. It was sold in like 8-9 days. Got rid of that pretty quick. And then counsel argues about that. Well, what else? What else can he sell for money? Broken down cars. You can get. That wasn't even the issue. You heard Naomi under oath say, "No, I just wanted too many cars out there. Our driveway was looking like a junkyard." Then she really took a lot of time picking on IS in her testimony. Ladies and gentlemen, let me make this perfectly clear here. For the defendant to put a 14-year-old girl in the situation he put her in is despicable.
Mm-hmm.
The weight that was on that little girl's shoulder. She knew what was going on. She's not going to tell. And she says, oh, Naomi pulled them both aside and said, is anything going on? And the defense wants you to believe that both these little girls go, yeah, we're having sex with your husband. Are you kidding me? That realistic? Or again, they try to force doubt on you and create this forced doubt. You bet those little girls carried around a horrible secret. It put them in a situation that no 14-year-old knows how to handle. And she says, well, once she figured out that she didn't make it to her grandma's, why didn't you tell SS? Folks, again, the answer is very simple. She's carrying around a secret that's like, oh my God, if I tell, I'm going to lose my sister's friendship. She's got to be run off with him. Maybe he's got her in a hotel. Who knows? There's so many ways for a 14-year-old to interpret that. Oh my gosh, imagine that SS's position that she was in. SS is saying to herself, if I tell, I'm going to forever lose my relationship with my sister. And she's missing, oh, please come home, please come home, please come home, please come home. It's a horrible position that he created. He did this. Now they want to come in and go, oh, SS should have disclosed this quicker. Easy for them. Then we hear, I think they took a shot at Dr. Atchie. They said, well, she's looking down at the floor. She looked concerned. I think there was testimony she wasn't talking. She wouldn't make eye contact. Dr. Atchie's the one that confirmed the pregnancy. Listen to this. You know what Dr. Atchie said? 22 weeks, 5 days pregnant. That's huge. Why? 22 weeks and 5 days backwards of December 13th, which is the date of the appointment, was July 7, 2018. Do you know what July 7, 2018? There was a family get-together. When they came back from, do you remember, way last week? The 2 little girls went to spend time with Grandma Nancy Ware up in Columbus, Georgia, come back. SS goes home. IS, on that night, for 2 nights, went to spend the night with him. Wow. That's why the family blew up in early December 18. They figured it out. Then they up here criticizing, Miss Michelle says, well, these aunt, grandmother, I don't like the way he hugged her. I don't like the way he looked at her. Oh, they didn't do anything? Well, first of all, it's not a crime, okay, to give somebody an inappropriate hug. And it's also, I don't like the way he looks at her. That was an aunt and a grandmother. Remember those? And both said, counsel just argued to you, by the way, they didn't do anything about it. Yes, they did. The grandmother went to Pam and said, don't let him around the nieces anymore. You remember that? Those are little details that over the week and a half that you've been here, you may forget. Remember, they did do something. And number two, don't ever question a grandmother's intuition. I learned that a long time ago. The grandmother walks out to a backyard at a family function, and it's just the two of them, the defendant and IS, and he's startled, he pulls away, and it made that grandmother concerned enough to go tell Pam, not about the hug, but hey, listen, you probably want to keep him away from the girls. You need to give permission if he comes over, and you need to be watching out. They did do something about it. They just tried arguing with you that they didn't, and they did. Forcing doubt. Don't forget the timesheet. This timesheet up here with the defendant. Listen, he leaves for an hour and 13 whatever minutes. He doesn't clock out. And you can say, well, it's the parks run to the store, whatever. What about those 53 minutes? Another. He knew what he was going to do. Told his brother he'd been planning it for months. He knew what he was going to do. He blended in at work. Violated company policy, as I asked both the Lindroses. If he leaves for a long period of time on a personal issue and leaves and doesn't clock out, is that allowed? That is not allowed. I think they made a couple more arguments about, well, you can't ever see IS on the cameras at A's. Of course not. Of course not. What is the expectation that, listen, well, he's going to put her on his arm, just go walking through his work with this 50-year-old girl? Are you kidding? 16-year-old girl by that time? Of course not. You bet she's not on the cameras. But what does he say on the wire? Them cameras are crappy. You heard it. George Jackson. Yeah, it's crappy camera systems. I know where the cameras don't show. They really argued to you also about the landfill and clothing. I just touched on this briefly. But listen, when the detective, who's got, 30 years of experience, Detective Shannon Lillard, she's worked major crimes, homicide crime scene unit detective, when she says, look, I was out there every day. I know what I saw. They want to throw, well, Goodwill dumps there. Got to be out of clothes, right? No. Yeah, so what? Ed Schmalfeld said that there's Goodwills there. That doesn't necessarily mean that the area that they were checking had clothes. And by the way, these clothes, isn't it odd? Forget the fact that it's Victoria's Secret that bombs Ziyah, that's hers. Forget that. It's found in the same isolated area. It's a big area, don't get me wrong, but the same area that the engineer, Ed Schmalfeld, says this is where you need to search if that's when that truck came here. 20 feet down, these 2-3 acres. What's in that 20 feet down, 23 acres? More Victoria's Secret underwear. By the way, it's not in bad shape. Okay, people don't just throw that. It's expensive. People just throw that out. And isn't it odd that it's there near a Terry Parker book? Oh, don't forget this. This is the trashiest of trash. Ace pick apart paperwork in the same area. What in the world is Ace paperwork doing near a Terry Parker book, near clothing is Victoria's Secret items? What is that stuff doing there? And they keep saying, no evidence, no evidence, no evidence. This is evidence, this is evidence, this is evidence. Yes, Ace pick apart dumpster was dumped there because you see stuff like that. We also know, so a girl packed a whole bunch of Victoria's Secret stuff. We know that's missing from a room. We know that. That's there. Doesn't have to be the same size. So she grabbed a pair of her mom's or her sister's or whatever. It doesn't matter the size. It doesn't matter the size. There's a Terry Parker book there. What's that Terry Parker book? Of the 50 or 60 schools in Duval County, the Terry Parker book is there. Notice all this evidence screams that. It screams who did this. The circumstances show who did this. The evidence, the phone, the Snapchats, and I haven't even mentioned wire in this statement, or the statement to his brother. The circumstances alone show who's in trouble. He got his little niece pregnant. The motive is there. Then they call Kamar Humphrey, right? They call Kamar. Well, we need to get along in the depot. That was clear, right? And then he says, I lied to you. Then I come up and I'm like, wait, you lied to her. You weren't getting along with her. But I'll tell you what, they could get on the news. They didn't bring it up. The defense didn't bring it up. We did on cross. Then you get on the news pleading for the public to come forward with information about this girl. Yeah, yes, sir, I did. And they called him. Now that wire, I'm not going to look through all this. Let me just make this very clear about the wire. There is only one conclusion to draw from listening to it in its entirety. And again, we apologize, 2 hours. You had to hear it. It is littered. It is filled with incriminating statements that lead to one conclusion. Here's a couple examples. Man, if the body's dumped with book bag and stuff, then it's easier to find the defendant. No, it was all separate. This is straight from the defendant. When my wife got pregnant, she's so high risk, they cut us off from sex. Why not get rid of your gun? That's in there. You're well, it's registered to me. But that's all taken care of. I took it and shot it at the gun range. Blow off steam. Didn't need to blow off steam that much because, as his wife said, he slept like a baby after she disappeared. The whole family's in a tizzy, and he's curled up sleeping like a baby. That's offensive. So we went and blew off steam. Why? Thought he got away with it. Boy, that pressure was coming down. You see it in the Snapchat text. Oh, you see it. A man talking to a girl like that. Manipulative. Then on the wire, man, you cleaned it all up. And that's what he said. Yeah, I even went to the range that day. Man, did you kill her one day and dump her the next? Yeah. Man, you made her sit in a car when she got shot? No, she went into a car. How long has she been dead? Well, he didn't actually went into his little Discovery Channel explanation. Remember that? He said she's been cooking out there. She's been cooking. That little girl laying up dead in that dump somewhere. That's the words that come out of his mouth. She's been cooking out there. Man, where'd y'all have sex at? You sneak around? Well, yeah, random spots. Like we went right up to the store or in a car. And counsel stood here and tried to argue they let him. Did she just really say that to you? You sat here and listened to 2 hours patiently, a long audio, and not once is there a threat. She says, the razor's on the floor. Are you kidding? They're laughing it up. 98% of the time of that audio. They're just sitting back talking, casual, hanging out. Man, well, how'd you get rid of the body? There's laughing going on. And they come up and argue to you, again, trying to force this doubt. Folks, that's you know what to do with that. So I come to a close and talk a little bit about that Don Quay and the parsley. Listen, it's not just like the confession. You say, well, listen, I'm going to be frank with you. One confession alone convicts him under these circumstances. Well, one of those alone is enough to prove beyond any doubt who did this. For your ears to hear a confession and get a confession from a blood brother is just that much more compelling. But think about these pills. It's not just the fact that these pills existed. They were ordered on the defendant's wife's account, and she came in here and swore under oath, and let me tell you, convincingly so. I didn't order them. Did you notice the count on these? These are 100 counts. Both of them. When the detective collects them, they put every one in here. There's nowhere near 100 of these. And they're sitting at the top of the closet of the victim, IS. And they tie back to one account. The defendant and his wife's. By the way, she's pregnant at the time. Did you catch that? She doesn't need these. Who are they for? It's clear who they were for. Then they come up and ask you, well, you remember Barbara Johnson? She's with Gun Gallery. You don't know whose signature's on this. Well, it says Jonathan J. Quillay's. There's his signature. Yeah, but you don't know he signed it. Forcing doubt on you, trying to create possible doubt. So I call Naomi Quilton, Miss French and I call Naomi Mobley and say, and we walk it up and show it to her. Is that your husband's signature? That's his signature. Why are they asking these kind of questions to you? And by the way, the whole thing about Ace and like, how does he know this property so well? How's he going to do this with all these people around? He knows it better than everyone. Why? Don't forget that map. The Lindroses say he brought us this map unsolicited. He'd only been an employee there for about 90 days. So somewhere in the middle there, they say he brought this map, showed all the weaknesses in the fence. He's been all over the back of that property. Joseph Quillay's. He took the stand. And he testified. These are the things my brother told me. I said, sir, do you want to be here? No. You love your brother? Yes. I'm going to describe the brother like this. There's a quote from John Wayne's biographer, a guy named Scott Eyman, E-Y-M-A-N. And he wrote that John Wayne is this kind of a man. Quote, he had a spirit that makes firemen rush into a burning building because it's the right thing to do. End quote. Joseph Quillay's did the right thing. it was the right thing to do. Joseph Quiles broke one of the strongest bonds that exists on earth, and that's a brotherhood bond. He came into a court of law, and he raised his right hand, and he said, this is what he told me. I couldn't stomach it, so I shot her. I had to get rid of that baby. Counsel stood right there and tried to get him to say, you don't believe that. You don't believe that. You bet he doesn't want to believe that. Bet he sure as heck picked up that telephone on January 8th of 2019, called the police. On January 8th, 2019, remember this, he calls the police. On January 10th, on January 10th, 2 days later, you heard the words right out of his mouth on the wire, matching what Joseph Quiles testified to. Taking the witness stand and doing the right thing. And I asked him why. I said, Mr. Quiles, I said, you tell this story why you're doing it. He said, it's the right thing to do. We don't tolerate the use of women in our family. I wanted the police to have this information so they can go look for her and maybe bring this family peace. Joseph Quiles' testimony alone convicts him. With all these circumstances surrounding, all the evidence that surrounds that confession, that alone convicts him. Lastly, the defense just argued to you that we don't have any evidence, right? They said because there's all these holes in it. Look at your video board and look at the evidence that you've heard in this trial. I'm not going to read every one of those to you. There is a mound of evidence here. There is evidence overflowing here. There is evidence that will bring us to phase 2 of this trial. There is evidence that the defendant is guilty of first-degree murder of Iyana Sawyer. There is evidence that he is guilty of killing her unborn child. Proof beyond a reasonable doubt. And there is evidence we have proven beyond a reasonable doubt that sexual battery occurred on IS by the defendant. That presumption of innocence that you have done nothing but adhere to and pay attention so attentively, you can now just strip that off of them. This case is now where it belongs, and that's with the people. We talked about those 3 branches of government when we started this, the judiciary, the executive, and the legislative, but it's the people that make decisions. It's the people, you as a jury, that brings justice, which is so needed in this case. We now ask you to go back and convict him of all 3 counts, guilty as charged as to all 3, and carry us to phase 2 in this trial. On behalf of Ms. French and myself, we thank you for the last week and 4 days. Thank you. Nothing further.
Members of the jury, I'm going to give you a break before I read you the jury instructions and charges in this case. It's 3:49. Come back at 4:15. I'll read you the jury instructions.
All right. So we just heard the rebuttal case to the state's rebuttal closing. And first, before I move any further, shout out to Caddy Gang that's in the building. Cat Not Williams, Queen Slime. If you're not subbed up to Cat Not Williams, what are you doing? She's covering the ASAP Rocky case. I'm glad that she is coming over here doing as she does. Just threw 5 channel memberships on me. I love Cat Not Williams because she loves on a lot of different channels and always shows love to everyone. And so it is no pressure when she's not over here. I know that she's either covering a story or she's trying to, she's spreading herself thin across YouTube. But we are Caddy Gang over here. She's Queen Slime. And Survivor Nation is a hybrid gang of Cat Not Williams. So she's covering ASAP Rocky. Flesh of the Gods is covering at ASAP Rocky in the way that he does it. And you know, he has all sorts of things that, you know, happens with the screen. He's very interactive with it. And so if you're not subbed to him either, go on over there. But let's give a shout out to Cat Not Williams. Not only did she just show up, she threw 5 memberships on your girl Cat Not Williams. I always appreciate you. Thank you so much for all of the generosity and help that you've been given to me and my channel. And I can't say thank you enough. So if you received a membership from Cat Not Williams, please say thank you to her. Please at her, because we like to name people by names. And y'all can go ahead and drop some Cat Not Williams special channel emojis down in the chat. Yes, she has her own channel emoji. She's a wrench over here, but I don't expect her to be over here doing any wrenching. But anyhow, so that's the Sacred Artist. Please say thank you to Cat Not Williams and add her, and then drop her channel emoji. It's in the chat. It's the green cat with the boss green suit on. That's Cat Not Williams. Thank you for growing the family, Cat, and adding another one. Here we got, oh boy, you just received a membership from Cat Not Williams. Please say thank you to her. Please add her, because we like to mention people by name over here, and drop some of her emojis down in the chat for turning you green for 30 days. So you have access to the members only emojis. So drop her emoji down in the chat, because she just turned another person green. So we added another one. And then shout out to if you know 777. Please say thank you to Kat. Please add her and drop her emoji down in the chat. Thank her for turning another one green and adding to the Survivor Nation family over here. Thank you. And we got Tribe of Levi, Miss Belinda. Please say thank you to Cat Not Williams for turning you green, making you a member of Survivor Nation for 30 days. Please drop her emoji down in the chat, and please add her when you do say thank you. We like to name the people over here who donate gifts. Another one. Yeah, we got Kendra Haynes in the building. Kendra, Cat Not Williams just gifted you a membership. Please say thank you at Cat Not Williams, and please drop her channel emoji down in the chat. We definitely like to say names when we are thanking people over here on the channel. And yeah, you know what, Cat? So what the funny thing is, when I look at my chat, when I look at my screen in the back, it's just me, but they won't let it go out into, they won't present it that way to the audience. My X is like this too. So my all of my colors where YouTube would have whatever colors they have is pink. So I was able to do that with the that enhancer that you know, the enhancer video that you the guy shared in your chat, because we was having so it's an enhancer for YouTube, so you're able, but it doesn't show on your end, it only shows on the back end. So I love looking at the back of my studio, or if I'm watching a regular video, it's pink when I'm on when I'm online. So I thought that was pretty cool, and they have a lot of great features within that. If you didn't download it yet, I truly enjoy it. So shout out to FFS. I don't know what I would do without FFS. FFS is a model here. You know, he's over, watching Cat Not Williams. I believe he's a model as well. And then also, Flesh of the Gods. Like, we're one big family. That's Queen Slime's Cat Not Williams. We the hybrid games. Like, yeah, we the hybrid gang over here. That's a little insider for all of the people. I don't know, Cat, were you 30K strong at the time? But I don't know. But if you was there during YSL, you know. If you know, then you know what we're talking about. So yeah, so she turned FFS turned 5 people green. FFS is I like all my moderators. FFS is one of the favorites. Like, he's like, me and him, we're here. KIO, he know what that means. So anyway, Thank you for always supporting the channel, FFS, for always being here and everything that you do for the channel, even when you're trying to be two places at one time. Like we all try to show support, even like I'm covering this and Kat's covering ASAP Rocky right now, and Flesh is going to just do a whole bunch of other stuff. ASAP Rocky, he going to throw some other stuff in there, screen flaring, everything growing. Cat Now Williams popping up, talking about, I love that one. But anyway, Angie Face, please thank at FFS for turning you green. You have access to the channel emojis. He does have a special channel emoji here. Please add him and drop his channel emoji down in the chat for turning you green. We have
Another one.
Nisha W. Thank you for stopping by. But FFS done threw a membership on you, so you have access to the special member channel member emojis and the members only content when I do drop it. So please say thank you to FFS. Please add him, drop his channel emoji down there in the chat, but make sure you add him because that's important to me. Thank you, FFS, for adding
Another one.
Oh, then we got Sierra Linda Jackson. Welcome, and please say thank you to FFS for turning you green for 30 days. Please drop his special channel emoji down in the chat. Please add him when you say thank you, and thank you, FFS, for adding
Another one.
We got Plotter over here. What's up, Plotter? Plotter, Plotter, how you doing? I'm glad that you're, here. If you're still in the building, shout out to you, Plotter, and please thank FFS for turning you green. You'll have access to our channel emojis for 30 days. And FFS, please add him. We like to, add the person that gives memberships over here. And drop his special channel emoji down there in the chat. He has it's FFS. You can't miss it. I think he's the only other green emoji that we have, and it says FFS. So thank you, FFS, for adding
Another one.
Thank you so much. I do appreciate you so much. And let me see. And anybody else that's not a member, you can go ahead and drop some umbrellas down in the chat. We thank Kat and FFS for coming over here and just doing just this. Just stay over here, just making it rain on your sister. Thank you so much. And I do appreciate you. And hello to everyone that's just joining. Normally, I like to speak to everyone individually, but we are almost to the end because we're going to watch this right now because it's not too much longer. So in this case, we are going over the Iyana Sawyer case and the similarities that it has to the Ziyah Harris case. It has so many similarities. It is just scary. And so we have been watching, going over this, and now we're at the end of this trial. I will definitely let you guys know what I'll be covering next until the court hearing for Ziyah Harris in the case of Detroit versus Jarvis Butts. He has a pretrial and calendar conference on March 7th. 2025. I will definitely let you guys know, as we move closer to that date. And on March 7th of 2025, we should be learning what day they are starting the trial. And of course, your girl Survivor Speaks is very invested in this case, and I will let you know. But I'm only going to speak to you from a place of integrity and things that I can, confirm. You know what I'm saying? I'm not one of those channels. I'm not going to just put something out here just for clickbait. I don't think that. I think it's disingenuous. And no, they have not found Ziyah Harris's remains. No, nothing was burned and charred. No, they did not find her remains in a shallow grave. So I'm not reporting any of that stuff over here. I'm just going to keep it true with you. And if I share any interviews that were conducted by Seven Mile Radio, shout out to him, go follow him. In 2024, when Ziyah first went missing. She went missing January 9th of 2024. He is from that area. He has interviewed a lot of her family members, and then you have the disgruntled family members that have been calling in. And I like to hear what they're saying from their mouth. And then I like to put all the contradictions that I've been finding together. And it's just not, the math is just not mathing. And so I do have a petition on my community wall. If you don't want to sign it, that's fine. But the petition is to arrest Shannon Harris, which is Naziah's aunt. The children, she has 5 children by Jarvis Butts, and her mother, Annette Harris. If you watch the preliminary hearing, they both got on the stand and perjured themselves. And if you listen to these interviews, Annette Harris hasn't done too many interviews, but if you listen to Shannon in these interviews, how she contradicts herself, it's crazy. Not only that, Jarvis Butts did tell her about his status before they started dating. He did tell her he was an essayer on the registry. She decided, she made an uneducated decision, because it was a dumb one, to go ahead and date him, because she said if society can give him another chance, then so should he. So should she. I have never heard such BS in all of my life. And the thing about this whole case that perturbs me the worst is that on January 8th of 2025, Jarvis Butts appeared on the XA offender registry list as compliant. What are we doing? That I don't know what bothers me most. I think this case brings great awareness to the things that, people in different cultures, and it's not just the African American culture, it is in all cultures. At some point, some family members are like, what goes on in the house stays in the house. Oh, no, don't say that. No, we don't want, like, we've handled it in-house. No, you didn't handle it in-house. You didn't help heal anyone. You didn't get anybody any help for being essayed so that you can break this curse. It is not a thing. And this girl, and the school felt her, CPS felt her, the cops felt Naziah Harris. They all did. They felt her. She could be alive today if the school would have listened to her. She was on the floor rolling around saying she needs to speak to a counselor. And I am very passionate when I am speaking about these stories. I don't care what other content creator is covering it. Everybody can cover it, and everybody should be covering it, because things like this needs to be brought to the community. But my subscribers and my supporters may not be your subscribers and your supporters. So if you report on it, I don't care. Subscribers have the right to go sit wherever they want to sit. Nobody owns this content. So if you if you're coming under my video or anything that I put up, live stream video with the nonsense, it's going to be deleted. I'm just telling you that. And you might be blocked. So, I have a managing moderator. We're here. We, feed off of each other, and that's what we do. So she already knows. She's on that more than I am, and then all my other moderators that are in the chat, they're on it. So anybody trying to come over here and infiltrate the Carter, you can't. So yeah, just sit back and just enjoy whatever the content and interact in the chat. We love that. We like a peaceful chat. Your opinion is welcome, even if it's different from the masses, as long as it's respectful. We don't care over here. You can give your opinion in the chat, but it's just how you say what you say. If you're coming over here disrespectful, then the mods are, we don't like that type of stuff over here. They're going to handle it the way they handle it. So shout out to my FFS for the super chat. He says, sorry about the all caps. Yeah, my iPad caps lock is stuck. Now, what is FFS? Now, me and you, I'm not gonna argue with you about these caps no more. But Cat Williams, if you're still in the chat, please tell him it's just not me, and that the YouTube will flag their messages and start holding them. I had to release a couple people's messages because of that reason. Because if you keep typing in caps, the YouTube picks up on that for some reason, and they hold the comment themselves. It's not the moderator, not me. I see the message. It'll say that YouTube has held this message, and you have to release it. So that's the only reason why I'm saying about what I'm saying about the caps. And that's just it. Chloe Albert's Revenge, you're back in the building. I know that you went and ran over there to Cat Not Williams. We all family know I don't care. Sharing is caring, and then you're back. And I love to see it. What you talk about, Chloe? I'm gonna read your message. But society didn't give them another chance. What does she think the registry is even for Dubby? We all know Chloe Albert's Revenge is gonna say what she wanna say because it's in her name. What do you think? So, yeah, so we are just FFS hasn't extended yet. I'm not messing with you, FFS, but thank you so much for the super chat. So, y'all, we're going to get right into the verdict because the jury wasn't out long. So, Just Lee, yes, ma'am. You were right. You didn't think they was going to be out long on this, and they not. And they didn't. They didn't disappoint. They listened to the evidence. They heard all of the evidence. They heard all of the lies that the defense attorney said that she tried to put out there.
Why the fuck you lying? Why you always lying?
Yeah, she tried it. It didn't work. It didn't work, Michelle. Stop. Just stick to the freaking facts. That's it. So we heard the closing, and now we're going to hear the verdict because the jury wasn't out long. Here we go. Just hold on. I'm just trying to get to the verdict. Girl, I remember I was on pins and needles when this trial went to the jury. You should have seen me. I was on pins and needles, baby. They came back the same day. I said, hold on. Wait a minute. I'm waiting. Went over to another one of my favorite content creators at the time. And yeah, we had a little dance party praise break, if you will. So yeah, I'm going to bring it right on over here, and I thank you all for your support. And then after this, yeah, we'll get to the closing. That's going to be quick, and I'm going to teleport you guys over to I believe that I don't know where Flesh is. I think Flesh is supposed to be going live. Is that today or is that tomorrow? FFS, please enlighten me because I could not find him. Oh no, so Flesh is going live tomorrow. So I'm going to have to find another channel to redirect this traffic to the traffic to. But I just don't want, I have to redirect to somebody that knows that what a redirect is. So, yeah, because I try to stay clear of everyone's end. All right, we're going to go to Sustain Overruled after this. My girl is live, baby. My girl is live. We're going to go to Sustain Overruled after this. But come on, let's get into the verdict. And here it is. 1 second. I just want to get right into it. I ain't got time. But we're going to get this creep as he comes in and borrows his tie and his belt for the last time. Yeah, as he borrows. Can I get my belt, please? Can I have my belt, please? Could you give it to me? Give it to me, give it to me, give it to me. Hey, why am I... That's so inappropriate. I'm thinking about Rick James. Rick James just jumped in my head. And so I do apologize. I said apologized. I understand. Hold on. So yeah, I'm sorry. Let me just answer this. All right. So we're gonna get on here right here into the verdict, guys. Here it goes. Marinate this. Let's marinate on this. They woke him up out of his sleep. Get on up, buddy. There's a verdict. And he's standing next to the demon herself, Michelle. She was horrible in this case. If you know, you know. You know what I'm talking about. Horrible. Just horrible. Horrible. Come on, sir. Please move out the way. We want to see the creep. Yeah. Just horrible. Horrible. He forgot to turn
Excuse me,
off his...
let's go back on the record. 19 CF 7518. The counsel for state defense. If
Yes.
Mr. Quella's present. Anything we do before the, my understanding is we do have a verdict. Anything we need to handle before the jury comes out first from the state defense.
Again, did you want to address the second part, or you want to worry about it later? Okay. Nothing for the defense, Your Honor.
The only thing I will add to those in the gallery, obviously I don't know what the verdict is, whatever it may be, if you don't feel like you can contain your emotion, I ask that you step outside the courtroom now. If you know yourself, know you cannot contain yourself, please just step outside now and you'll be informed of the verdict. With that said, please get the jury. And Mr. Gray, just get the verdict form, hold it and have to give it to me.
Did she go off?
Those horror stories.
Your Honor, the jury returns to the court.
All right, the verdicts are legally sufficient. I'm going to give it to the clerk for publication. Mr. Quelez, please rise with your counsel.
In the Circuit Court of the 4th Judicial Circuit in and for Duval County, Florida, case number 16, 2019, CF 75.
Why she use the mic?
Division CRI, State of Florida versus Jonathan Jacob Quilles, verdict count 1. Plead the jury found the defendant guilty of first-degree murder as charged in the indictment. We find the defendant did actually possess and discharge a firearm. As charged in the indictment. We find the defendant actually possessed and discharged a firearm during the commission of the offense. Verdict count 3. Plead the jury found the defendant guilty of engaging in an act that constitutes sexual battery upon or with a child 12 years of age or older, but younger than 18 years of age, by a person in a familial or custodial authority, as charged in the indictment. So say we all that in Jacksonville, Duval County, Florida, signed by the foreperson, dated September 21st, 2023.
All right, counsel, Mr. Quelez, you may have a seat. Does either side want the jury polled?
Yes, Your Honor.
Members of the jury, the clerk is simply going to ask you individually a question whether this was indeed your verdict. I want you to disregard your jury numbers from last week. We're going to start from my far right first row, juror number 1, work our way down, and then commence back on the top row. So 1, 2, 3, etc. And we'll finish up with juror number 12 on my far left. So she's asked you a question, and you just respond with your answer.
Juror number 1, were these your true and correct verdicts? Yes. Juror number 2, were these your true and correct verdicts? Yes. Juror number 3, were these your true and correct verdicts? Yes. Juror number 4, were these your true and correct verdicts? Yes. Juror number 5, were these your true and correct verdicts? Yes. Juror number 6, were these your true and correct verdicts? Yes. Juror number 7, were these your true and correct verdicts? Yes. Juror number 8, were these your true and correct verdicts? Yes. Juror number 9, were these your true and correct verdicts? Yes. Juror number 10, were these your true and correct verdicts? Yes. Juror number 11, were these your true and correct verdicts? Yes. And juror number 12, were these your true and correct verdicts? Yes.
Oh shit! Oh shit!
Members of the jury, this is typically when in the process I dismiss you from your service. However, we need to move forward with phase 2 of the proceeding. That will not occur tonight. That will not occur tomorrow.
Okay.
Tomorrow, we're going to start back up on Monday for that process.
All right. And so that's what we wanted to get to for today. And so he was found not he was found guilty. And so they had dropped my my link down in the chat, my email address. And if you guys want to go over the I truly hope he threw but what he did, like Kendra, I really don't think so, and I hope he didn't either. He was dumb at best. And everything that he did once he started working at Ace Pick Apart was done in premeditation of unaliving the teenage young lady, Iyana Sawyer. It definitely was. So he was found not innocent. Chloe, yeah, he was found not innocent. So anyway, so let me just I thank all of you. Thank you for dropping the email. If you want to see the if you want to see the rest of this like case, he already been found guilty. Like, we don't have to watch it, but I do have some other trials in mind that I wanted to rewind that you guys may have never heard of before. I'm a true crime junkie, so yeah, I've watched a lot of trials, and I do have some in mind, a couple in mind that I think you guys will really be interested in. So that is the end of that trial. But I mean, if you want to drop me, or you can drop it in the comments if you want to see like the case coming up afterwards to determine the we don't need to see that he's guilty on all charges. And so if you're joining us for the first time and you didn't hit that subscribe button and turn on all your notifications so you never miss our live streams or videos, please hit the subscribe and like button, turn on that bell so you get all your notifications. So, you guys know that it wouldn't be me if I didn't end the show by raising awareness that men can get breast cancer too. So because of the stigma associated with the word breast, we've started using the term pec and or chest cancer over here. So let's continue to break the stigma and spread awareness, about men getting breast cancer just as well as women do. And to my ladies, please make sure that you are getting your mammograms, filling on your boobies to make sure that you are all right. All right. Don't you dare let anyone come into your house and disturb the peace that passes all understanding. I'm Survivor Speaks. I'll see you guys in the next live stream or in the next video that I upload. So we're going to teleport over to Sustain Overrule. She is an attorney, and her personality and the way she does things is sometimes it's just hilarious. So she mixes a little law and she tries to make things a little light, and normally her opinion is a little different than what the masses believe. She'll break it down in a legal way if you ask her. She's very interactive with her chat. So we're going to teleport over there. If you don't want to, you could just drop off, or please just go on over there and give her a thumbs up, subscribe, then drop off and go wherever else that you want to go. So thank you to the show sponsors today, Cat Not Williams and FFS. I didn't get you guys in the banner, but I will put you in the banner in the next show. I was just so excited to get to the end. So guys, I'll see you in the next video, and peace out. And I had forgot to turn up my music by No One. So I put these behind the videos, but sometimes like it doesn't, it overpowers the video. So I had it turned down, but I could not leave without telling my boy at No One, thank you. No One, drop your link, or somebody else drop No One's link in the chat. If you need some background music for your videos, go ahead and hit up No One. Go over there and check out his channel. you know, and then you're gonna have to deal with no one and get with him, you know, to determine, you know, how you guys are going to work this all out. So couldn't leave without doing that. And I had just remember, like, wait a minute, I don't have my music on. All right, but thank you to No One for this. And my outro is none other than my nephew. The song is on YouTube. Just type in Survivor Speaks Topic. And so, yes, it's on my music channel. I just have like the music that I use for YouTube. It is copyrighted, so it's over there. So anyway, let me get out of here and let's go. I love you all, and I'll see you in the next upload. Peace, 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 peace.
Full cycle, I just might though just like a Michael. Mama gone now, I'm thinking death is now we entitled. And it was me versus me, them battles had to fight through. And when you way in the dark, them demons try to fight you. But you can't let them when you gotta see the damn light. Diabetes came from nowhere, messed up whole life. That's what I used to think, my mama helped me out. I got one deer in the sky to make proud, don't count me out. Let's get it started, rest in peace my mama, I don't wanna talk. Fresh fit, who that little nigga, fresh the way he walk. New drip, I'm that one dude creating all the sauce. News flip, you that one do the worker, not a